Good evening, ladies and gentlemen. Please smash that like button, subscribe.
I see, Judge. I see. Okay. So I just need just a moment, like I stated, just to figure out how to get my camera enabled, maybe just 2 to 3 minutes, and then I will be ready, Judge.
Okay. And I have, if you have any influence, I have begged the state to be present at these hearings to possibly help move things along, but I'm just a lowly magistrate court judge.
Understood, Judge. I don't think I'm nearly as important as you, but I will definitely make mention when I'm able to.
Okay. But I'll tell you, Miss Land, it's not one of those don't catch me in the street. Don't let me catch you in the street notices. I'm not
Okay.
I'm not that violent.
Okay.
But I really love to have the input of the state on these proceedings.
I understand, Judge. I was not aware that they weren't present on these proceedings, and it would be my preference as well.
Yes, ma'am. Okay. For everyone, this is your first appearance hearing before the Magistrate Court of Clayton County. My name is Brad Gardner, and I'm a judge in this court, and I'm here to inform you of the charges that have been filed against you, to advise you of certain rights, to set bail on those offenses that I'm authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing. But should you give up this right, anything you say during this proceeding may be used against you. So please don't discuss the facts of your case. During this and all other proceedings, you have the following rights: to the presumption of innocence, to indictment by a grand jury for most felonies or by accusation for misdemeanors, to a speedy and public trial by jury, to see, hear, and question witnesses who are called to testify against you, to compel the attendance of witnesses to testify on your behalf, to testify on your own behalf or offer evidence in your own defense, and to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release from jail. These bonds may be posted by cash, commercial, or property. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. You will also be prohibited from contacting the victim while you are in jail. If you violate the court's order, your bond will be revoked and you could remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, that person would not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. If you are currently on active probation, this court is not authorized to set bond at this time. Whether bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You receive notice at the address you give of your next court date. Lastly, could I have everyone raise their right hand, please? Do you swear or affirm any statements you make during this proceeding shall be the truth, the whole truth, so help you God?
Yes, sir.
Okay. Miss Lynn, have you worked out your camera situation?
Can you hear me?
I can hear you.
Okay. I have not, Your Honor. I think what I need to do, because I have a glitch on my mobile device, I have another device and I'm about to access that now. For the convenience of the court, would you not mind, Judge, to do your first matter and then circle back around to me? I should be able to access this device momentarily.
Yes, ma'am. Let's start on the ladies' side with Miss Cofield.
Thank you, Judge.
Ms. Cofield, ma'am, you're charged with 2 driving-related offenses. The first is speeding. Bond is going to be set at $500. The next charge is driving vehicle without a valid license. Bond is going to be set at $1,000. Your preliminary hearing date is going to be set for July 5th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
I'm going to find that you qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No.
Okay, ma'am, you're free to go back.
Thank you.
Ms. Davis.
Hello.
Ms. Davis, ma'am, you're charged with 1 count of battery. I'm going to set the bond at $5,000. There's going to be a stay away provision on this bond, to stay away from a Shannon Hibbert. Do you understand that, ma'am? Your preliminary hearing date is going to be set for July 5th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
I'm going to find that you qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No.
Okay, ma'am, you're free to go back.
Oh,
Ms. Diggs? Ms. Diggs, ma'am, you're charged with 1 count of criminal trespass. Bond's going to be set at $3,000. There's going to be a stay away provision on this bond, to stay away from a Thomas Dwayne Hodges. Do you understand that?
Yes.
You said yes?
Mhm.
Okay. Your preliminary hearing date is going to be set for July 5th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer? It appears you said NA. Does that mean you're currently not working?
Yeah.
Okay. I'm going to find that you qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me? Okay, ma'am, you're free to go back. Miss Hall. Miss Hall, ma'am, you've been charged with one count of giving a false name, address, or date of birth. This is a misdemeanor offense. I'm gonna set a bond at $1,000. You're gonna have a preliminary hearing date set for July 5th at 8:30 in the morning, courtroom 201. The date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer? You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yes, sir.
Okay, ma'am, you're free to go back. Miss Shield, Miss Shield, you've been charged with one count of hit and run, leaving the scene of an accident. Bond's going to be set at $1,500. This is a misdemeanor offense. You're going to have a preliminary hearing date set for July 5th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of lawyer?
Yes.
It says here that you earn $12,000 per month.
Mhm.
Okay, you're beyond the threshold of being what we would consider indigent. So your options are going to be to hire your own lawyer, represent yourself.
No problem.
I'm sorry.
That's no problem.
Okay. I'm going to place that you're going to hire your own lawyer. Okay. All right, ma'am. You're free to go back. Miss Silva.
Hi.
Ma'am, you've been charged with one count of hijacking a motor vehicle, and this charge is a charge that I cannot set bond for.
Oh, can I say something,
I'll finish.
Your Honor?
Let him finish.
Hold on, ma'am. I'm gonna give you the opportunity to tell me whatever you want to tell me, okay? So pursuant to Georgia statute 17-6-1, I cannot set bond on hijacking of a motor vehicle. I've set bond on the public transportation, basically not paying for being on public transportation at $500. I've set the bond for criminal trespass as $1,000. Your preliminary hearing date is going to be set for July 6th at 8:30 in the morning, courtroom 201. I'm also setting a bond hearing date for July 8th at 8:30 in the morning, courtroom 201.
Excuse me.
Hold on, ma'am. I'm going to get to you. I promise. Do you want me to appoint you a lawyer? You're going to hire your own lawyer.
I don't care.
Okay. Is that a no?
No,
It's not a no.
whatever. I don't care. Do what you want. You guys just spent 21 hours in the infirmary with one meal and one cup of water. So obviously you guys can do whatever you.
Okay, ma'am. So I'm going to mark on the sheet that you're going pro se because you said you don't care when I was trying to offer you a lawyer.
What does that mean, pro se?
That means you represent yourself.
Yeah, that's
I'm
fine.
out, ma'am. I was trying to offer you a lawyer, ma'am.
So,
I am extremely agitated with this.
You can unmute her. Ma'am, the allegation is that you got on the bus and you got into the driver's seat and you started pressing buttons to try to put the bus in gear.
No, I pressed.
Ma'am, that's the allegation.
All I did, sir, Your Honor, was press the brake pedal for 5 seconds just to have some fun. And I liked the noise it made. Then I got down and got out, and he said, "I'm pressing charges." That's all I did. If you can go to jail and spend 21 hours in the infirmary because of what I did, then you guys need to go to court. I'm taking you guys to court.
Okay, ma'am, let me ask you a question, and you do not have to answer this question. What made you think that you could get into the driver's seat and start pressing buttons?
The both doors were open and it was on. And there was no one around. And I thought, okay, no one's around, so this won't matter if I just play around with the buttons. Because I used to do this to my dad's RV all the time.
Okay, ma'am. Now you see it matters. Now do you see it matters?
What crime have I committed? It's not hijacking if you don't take it anywhere.
Hijacking of a motor vehicle. That is the crime.
Hijacking is
I know you don't believe that was the crime, but that is the crime.
I'm just saying, hijacking, if you take it somewhere, if you bring it somewhere, take it.
Your Honor, are you finished with Ms. Silva?
One last thing.
So you can't say, "Barn, I'm going to be here until July." You're saying, "I'm
No.
going to be here until July."
Ma'am, ma'am, I don't know if you're a voter, ma'am, but this law was set by the legislature.
Yes, I am.
I cannot go behind the law. I am a person that is responsible for making sure that the law is followed. And I'm sorry that your attempt to have fun is going to have these collateral consequences.
Are you saying I'm going to be here until July?
Yes, ma'am.
Let me just tell you something. Hijacking, looking up on Google, hijacking is when you take it somewhere off the premises or you move it at all. I didn't touch it. I did not hijack anything. There was nothing to jack. There was nothing to hijack. Okay, sir. I plead this case. And Your Honor, please see that I was merely just.
So I'm gonna go back to the threshold question. Do you want me to appoint you a lawyer?
What will that do?
Are you gonna hire a lawyer?
What would that do? Because no matter, because I'm speaking in English here, and you're not understanding.
Yeah, I do. You're answering a question with the question. So I've marked pro se, which means you're going to represent yourself until you hire your own lawyer.
I don't need a lawyer.
You're now free to go back. She's free to go back.
Can I get an OGR bar or whatever? Can I get a bar? You're saying to be here until July.
Miss Lynn,
Yes,
you got your camera to work.
I did, Your Honor. Thank you for your patience.
Yes, I'm down to the last person on the lady side, and then we'll move to Mr. Smith.
Yes, sir.
Wendy Ward. Lady side, I think it's Ward, and I think it may be Spink, or there's Spike or Spink, or there's another name.
This is Ms. Ward, Your Honor.
Yeah.
Okay, Miss Ward, ma'am, you're charged with 1 count of violation Georgia Controlled Substance Act, simple possession of methamphetamine, setting a $3,000 bond. That's a felony offense. You're charged with 1 count of possession of marijuana less than an ounce. That's a misdemeanor. Bond's going to be set at $1,500. You're also charged with 1 count of use or possession of drug-related objects. Bond's going to be set at $1,500. Your preliminary hearing date is going to be set for July 6th at 8:30 in the morning, courtroom 201. Most likely will be by Zoom. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
What is the total of the whole amount?
$6,000, but there are going to be fees that the sheriff's department is required to add by law. So it'll be a little bit higher than the $6,000 figure.
What is the percentage on like a bondsman with that?
Okay, it's in I preface my statement with saying that I don't work for the bonding companies, but their fees are based on a percentage anywhere from 10 to 12% of the bond amount.
Okay.
So I think there are 5 or 6 bonding companies that are authorized to write bonds here in Clayton County. I would encourage you to contact each one. Okay?
Have a great day.
You too, ma'am. You're free to go back.
Thank you.
All right, let's bring up Mr. Bernard Smith.
I've got to wake up. So I'm next. Yes.
I'm
Hey, you're next. He's got his attorney here, so he's going first.
Oh, so,
Right here. Okay. No, Bernard.
how you doing?
Are you Mr. Bernard Smith?
Yes, I am.
Mr. Smith, ordinarily I would speak to you directly. You've taken advantage of the opportunity to hire a lawyer. So
Mhm.
I'm going to speak to your lawyer about your case. You should understand that anything that you say here is not privileged, nor is it private. So please don't say anything that you would not want the whole world to know. You understand me, sir?
Mm-hmm. Yes.
Okay. Attorney Lynn. Mr. Smith is charged with 1 count of public indecency. This is a misdemeanor offense. I've set a bond at $1,000. I would listen to you as to anything you want to say about your client as to the charge or to his or about his character's word that comes to mind, but it's not character, but about your client. You still muted.
Can I be heard now, Your Honor?
Yes, ma'am.
Okay, thank you, Your Honor. Judge, for your own edification, just so you know, Mr. Smith's background, he is currently 43 years old. He is a United States military Navy veteran. He served this country for 4 years in the Navy. He, within that, judge, suffers from mental health diagnoses that I would not like to say on the record at this time, but
That's fine.
Thank you, Your Honor. I appreciate that. But there are diagnoses, Judge. On the previous dates surrounding this particular day, which was May 26th of 2022, prior to those dates, Mr. Smith had made some attempt to go to the hospital to receive medical treatment for his condition. He was not able to reach the hospital on that previous occasion, which was May 23rd of 2022, because he had been in a motor vehicle accident. And so it's my belief that there may have been some lag between May 23rd and May 26th of him being able to receive the proper medical care that he needed. On the day in question, it's my understanding that there may have been some disagreement with a neighbor where he lives. From there, he apparently was hospitalized twice on May 26th. At some point, he was released. He went through whatever protocol those facilities had. He was released, and he was subsequently, I'm not sure if he was medicated there, if he wasn't medicated, what exactly occurred. But he was later found walking down Terra Boulevard in his hospital gown. From that point, he was sent to another facility, which I believe was Piedmont Hospital. In between that time, I believe warrants were drawn up for the public indecency charge. And so he was treated, released from Piedmont, and then rearrested on these warrants as of late. So, Judge, I would like to ask, given the circumstance and my belief that this is not a criminal matter, but more so a mental health matter, if Your Honor would allow Mr. Smith to sign himself out. Of course, as you know, Judge, he's entitled to a bond on a misdemeanor. But we're asking that you allow for him to sign himself out on his own recognizance to deal with the mental health matter. And we ultimately want to see if we can have this case done away with altogether.
Okay, so I set the bond at $1,000, which is my understanding lowest amount that a bonding company will entertain a bond or will come on to a bond. I'm not inclined to allow him to sign himself out by and large, because we really don't have infrastructure in place to monitor a person that gets a signature bond. So I understand what you've said, and with the bond amount that's set, he should be able to pay between $100 and $200, and I don't know what bonding company or whatever he's going to go through as it relates to that. But there is there's case law about if someone has been diagnosed and they're told to go through a certain treatment or regimen of treatment and they don't comply with that, that's treated as voluntary intoxication. And so, and I'm certain you know, like you can't drink a whole bottle of alcohol, get in your car, drive and kill somebody and say, well, I was drunk and that's why it happened. So those are issues that are going to have to get fleshed out as it moves along the path and the chain. But if your client is in a situation where he's been told to take medication or to on a certain regimen and he's not doing that, that's something that may not be a benefit to him.
Understood, Judge. I would like to have more probing discussion with Mr. Smith. I don't believe that is the case in this instance. I do believe that he is in making all the attempts that he can within his power to receive the care that he needs, but I most certainly will take what the court is saying into consideration and have some more probing discussion with him on that matter.
And that's, you know, and I'm this is not a situation where I would be inclined to dismiss the warrant, and I know that's not what you're asking. But I set the bond at an amount, as I said, it's the lowest amount that from my understanding, that a bonding company would entertain this, so that from a financial standpoint, he comes out better. If I set a $500 bond, he's going to have to pay $500. But setting the $1,000 bond, he can go through a bonding company and have a lower outlay as it relates from the beginning.
Yes, Judge. And I do certainly appreciate your consideration. And I do believe that that is correct. That's my understanding of the bonding process as well.
Okay. So Mr. Smith can go back and Ms. Lynn, you can be excused.
Thank you very much, Judge. And I appreciate you not penalizing me despite Ms. Mary's suggestion.
But she holds me in contempt every day. So
Oh, I know all about it, Your Honor. Trust me.
okay, have a good day.
Thank you, Judge. Have a great day as well.
You
Talk to
too.
you soon, Mr. Smith.
Let's bring up Mr. Bullock. Mr. Bullock, sir, do you know what you're charged with?
Yeah.
I cannot set bond on this offense at this stage. So bond is going to be denied on the first count, CW 52785. It's going to be denied pursuant to Georgia statute 17-6-1. And the second count, CW 52786 is going to be denied because the first count I can't set a bond, and I'm going to let the next judge set the bond amount. Your preliminary hearing date is going to be set for July 6th at 8:30 in the morning, courtroom 201. Would you like for me to see if you qualify for the appointment of a lawyer?
Yeah.
Are you currently working, sir?
No.
Okay. So I'm gonna appoint a lawyer to represent you. And your bond date is going to be set for July 8th at 8:30 in the morning. Do you have any questions for me, sir?
No.
Okay, sir, you're free to go back.
All right.
Oh, man. Are you Mr. Burdette?
I am.
Sir, you charged one count of simple battery. This is a misdemeanor offense. I'm setting the bond at $4,000. There's going to be a stay away provision on the bond to stay away from a Keith Burdette. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for July 5th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
You do qualify, sir?
Yes.
I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yes, I have a bench warrant hold. My attorney on that bench warrant set the date on the case for July or June the 27th, I think it was, or the 21st. And now I have a bench warrant out on my arrest for failing to appear. I did not fail to appear because the court case was not had not come about yet. I have a hold on a bench warrant, and I shouldn't have a bench warrant. That my attorney, my public defender, on a Zoom call that day set the court case back for a mental evaluation. I have not received that paperwork or the mental evaluation on that court case yet. I don't know where I'm supposed to go, who the attorney was. I can't remember the lady's name.
What county?
Clayton, City of Morrow also.
City, okay, so was it a charge out of City of Morrow, or was it a state charge, meaning It's
It was a charge at City of Morrow, but it was Clayton County courtroom.
okay. So, because of the whole pandemic thing, there are ways to kind of work around it. But it just requires communication. And I'm not saying that your side has not been trying to communicate with the state side, but it requires both sides to be able to communicate and resolve whatever issue is ongoing. So I would, well, I'll say this. If you were to post bond in this case, it now places your other issue at the front of the pile. And then that issue most likely will get resolved possibly faster. If your lawyer has not been able to resolve that matter, once you get placed upon the City of Morrow and they have to deal with you, then they may actually deal with you. But as long as you're kind of in the pile and paperwork, you may not get the attention that you deserve.
Okay, so what I'm asking is, if I bond out on this charge, I have to sit here until the court date on the bench warrant, is what I'm asking. I want a fake bench warrant, where my attorney had reset the date to July or June the 27th, I believe it was, or the 21st.
Yes, that is the procedure. But what I'm saying to you is that once you are now placed before them and they have to deal with you, they will deal with you. If your attorney has been unsuccessful up until this point in dealing with the issue, once they have to come and place you on a calendar and deal with you, that will help the matter to get resolved. And it may lead, and this is by way of observation from 22 years of practicing law. The prosecutor in Morrow that may have ignored this, once the prosecutor know they have to deal with it, they will deal with it. It's the whole thing of, like they say, well, I won't say that, but I'll say this. Once your issue is front and forward in front of them and they can't shirk it, they got to say yes or no. And if it's a failure to appear and it's a situation where there are reasons for the failure to appear, almost every jurisdiction say, let's just put them on the calendar, especially when you have a lawyer. They say, let's put them back on the calendar and we'll deal with it. So I don't know the details of your situation, but you have a lawyer, and I would encourage you to just listen to what the lawyer's saying.
That's the problem. You can't get in touch with the lawyer, but that's fine. I'm gonna say this on the camera. You need to get in touch, or Clayton County needs to get in touch with General Adam Hutchinson, United States Army, on a satellite terror attack in Clayton County in the City of Morrow that I've been under for the last 7 years. That's what this is about. The Johnsons, the Monroes of the state of Georgia. So I want that on camera. I thank you, Judge. I'll let you continue.
You're welcome. Thank you, sir. Mr. Cannon.
Morning, Judge.
Good morning, Mr. Cannon. Sir, you're charged with one count of firearms solicitation to transfer, and the allegation is that there 9 firearms that didn't belong to you that you were attempting to sell to a pawn shop. Bond is going to be, that's a felony offense. Bond is going to be set at $10,000. You're also charged with cruelty to animals, and bond is going to be set at $10,000 because I saw that there was another incident or allegation of cruelty to animals. So you're going to have a total bond set at $20,000. Because these are both felony offenses, you're going to have a preliminary hearing date set for July 6th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir, please.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yes, sir. When I was actually going through intake and booking, when I was actually speaking to the officers during the arrest, they said the cruelty to the animal was an actual misdemeanor charge. My dog, see, they said my dog was going through a heat situation when she
heat
actually,
stroke. Right, heat stroke.
when she actually got taken into Humane Society, it was determined that she has parvo.
Okay.
Now, I bought my dog. Yes, go ahead, sir. I'm sorry. I didn't mean to.
No, I was going to say that that's a circumstance that you need to speak to your lawyer about.
Yes, sir.
Because that will kind of carry the day, but right now it's being written as a felony.
Yes, sir. Understood.
Okay. All right. You're free to go back, Mr. Cannon. Mr. Cozine.
Cozine.
Yes, sir.
Is it Cozine or Cozine?
Cozine.
Cozine. Mr. Cozine, sir, you charged with 1 count of simple assault. Bond is going to be set at $3,000. There's going to be a stay away provision on the bond to stay away from a Lauren Webster. Do you understand that, sir?
I do.
Your preliminary hearing date is going to be set for July 5th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
How much do you make per hour?
$17.
Okay, sir, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back. Mr. Handfield.
Good afternoon, Your Honor.
Good afternoon.
I'm sorry.
I'm sorry, Miss Mary.
I said, what was Cozine's bottom at?
$3,000.
Thank
I hope you're having a good day, Your Honor.
Well, I hope I have a good day too, sir. You're charged with 1 count of aggravated assault by strangulation. I've set the bond at $15,000. There's going to be a stay away provision on the bond, stay away from a Charlene Handfield. Do you understand that?
Yeah, Your Honor, my wife and I have been going to marriage counseling since the incident in January. We actually attend the VA. I'm a veteran. We attend marriage counseling through the VA. Yeah, I have my two babies, my 2 children at the house. That's the only residence that I have, Your Honor.
Okay. All right. I'm gonna reduce your bond to $10,000.
Thank you so much, Your Honor.
You're welcome. There is going to be a stay away provision on the bond, stay away from Charlene Handfield. And I know you said that you've gone through counseling, but we place stay away provisions on these bonds for a reason. If she would like to have this condition modified, she can contact the district attorney's office.
Is there a number you can give me to call, please, Your Honor?
It's the Clayton County District Attorney's Office.
Clayton County District Attorney?
Yes, sir.
Your Honor, is there somebody in reference that she should speak to? Or just ask for the district attorney?
Victim witness advocate. But she should be the person making the call.
Yes, Your Honor, yes, totally understandable. I'll have the message relayed to her. I won't even contact her to let her know.
Do you want me to see if you qualify for the appointment of a lawyer?
Please, Your Honor.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any other questions for me?
About the bond, Your Honor. I just need to have some, I can't post that myself. I have to have somebody else post it.
Okay.
No, I was asking, am I allowed to post? If I post it, I have to pay 10,000, right? But if I get a bill company, I can.
You can go through a bonding company. It's what we call cash commercial or property. Cash, you can post the entire amount of cash and you'll get that returned to you when the case is over. Commercial, you go through a bonding company, they charge you a fee, but whatever fee that they charge, you don't get that money back. Or property, if you have property in Clayton County that is, it has at least 3 times equity of the bond amount, you can post that property. And they'll put, the sheriff's department will place a lien on the property. And when the case is resolved, they will remove the lien.
Understood, Your Honor.
Okay, any other questions?
Preliminary hearing, Your Honor?
Is July 6th at 8:30 in the morning. Courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail.
Yes, Your Honor. Thank you, Your Honor. You have a good day. God bless.
You too. Mr. Hodges.
Yes, sir.
Mr. Hodges, sir, you've been charged with a number of serious felony offenses. The armed robbery charge, I cannot set bond at this stage pursuant to Georgia Statute 17-6-1. So with aggravated assault, I'm denying bond on that charge. The armed robbery bond is denied pursuant to Georgia Statute 17-6-1. Criminal damage to property in second degree, which is also a felony, I'm denying bond on that charge. With criminal trespass, that's a $3,000 bond. Battery is $5,000 bond. And misdemeanor theft by taking, there's a $2,000 bond. There's going to be a stay away provision on this bond to stay away from a Tamara Diggs. Do you understand that, sir?
Yeah.
Your preliminary hearing date is going to be set for July 6th at 8:30 in the morning. Courtroom 201. The armed robbery is going to have to be heard before a Superior Court judge, and that date will have to be provided to you later because armed robbery carries maximum sentence of life.
All right.
So I cannot give you a hearing date for that today. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
I'm going to find that you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back, Mr. Hodges. Mr. Jones?
Good afternoon, Your Honor.
Good afternoon, Mr. Jones. Sir, you're charged with 1 count of theft by taking as a misdemeanor. Bond is set by schedule at $2,000. There's going to be a preliminary hearing date that's going to be set for July 5th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. I'm sorry, wait a minute. Yes, sorry. Put the wrong date down on the paperwork. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor, please.
Okay, I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
So so my bond set at 2,000. I can go to a bond company and get that taken care of.
Yes, sir.
And for my actual offense, what I'm being charged with, like, so somebody.
Hold on. Don't talk about the facts of your case.
I just wanted to know about the belongings, because I was told about these belongings that was taken, that they wasn't really taken. Like, I still have the stuff. I asked this person to come pick her stuff up, and she told me.
Mr. Jones, you're talking about the facts of your case.
Yeah.
And let me tell you why I stop people from doing that. This is being recorded.
Yeah. Yes, sir.
You have not spoken to a lawyer yet about any possible defenses that you may have. So how about wait until you speak to a lawyer?
First, okay. Thank you, Your Honor.
Yes, sir.
I'm finished?
Yes, sir.
All right, you have a good day.
You too. So Larkins.
The real Larkins. Who? Larkins. Real Larkins. Mooney.
Good morning. Are you Mr. Larkins?
No, Mooney.
I'm sorry?
Mooney, gentlemen.
Mooney. Mr. Mooney, sir, you're charged with 1 count of violation of Georgia Controlled Substance Act, simple possession of methamphetamine. Bond is going to be set at $3,000. You're charged with improper lane change. Bond is going to be set at $500. Charged with use or possession of drug-related object. That's also a misdemeanor. Bond is going to be set at $1,500. And you're charged with driving on a suspended license. Bond is going to be set at $1,500. That's a total bond of $6,500. Your preliminary hearing date is going to be set for July 6th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, sir.
How much do you make per hour, Mr. Mooney?
Maybe $9 an hour.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir, not at this time.
Okay, you're free to go back.
Thank you.
You're welcome. Did we lose Mr. Larkins? Mr.
Palominos.
Palominos.
Yes, hello, Your Honor.
How are you doing, sir?
Good, sir. How you doing?
I'm doing well. You're charged with 1 count of trafficking marijuana. And in the state of Georgia, anything over 10 pounds, I cannot set bond at this hearing. You're going to have a preliminary hearing date set for July 6th at 8:30 in the morning. You're going to have a bond hearing date set for July 8th at 8:30 in the morning. I would encourage you to hire a lawyer.
Yes, sir.
Because the lawyer may be able to negotiate with the district attorney's office and have you released before these dates
Yes,
that
Your Honor.
I have laid out. So is it your intent to hire your own lawyer, or do you want me to appoint you a lawyer?
If you can appoint one, that'd be highly appreciated.
Okay, you do qualify. I'm going to appoint you a lawyer. Do you have any questions of me?
Yes, sir. As far as the lawyer goes, the attorney, how would he be reaching out to me, or how's that going about in the state of Georgia?
So, my basic answer to that question is always, I don't work for the district attorney's office. I'm sorry, the public defender's office. So I cannot tell you when, but I do know that for the clients that they are appointed, they reach out to them as soon as possible on the video terminals. They set up meetings.
Yes, sir.
And the way it goes here, at least in Clayton County, at the end of this hearing process, I complete the paperwork and I send everything back to the public defender's office as it, Jesus, I'm getting these names wrong. I send everything back to the sheriff's office as it relates to the bond orders. There's an indigent defense office that I send the paperwork over as to the people who are requesting a lawyer. They process it and then they send it over to either the misdemeanor or the felony divisions.
Gotcha.
So that's the process of appointment. So I can't guarantee you like a timetable. From what I have observed, you'll get contacted this week, and you can tell them what you need to tell them. And I'll tell you, because these cases come to Clayton County, you're not the only person.
Yes, sir.
And coming from out west, and these cases happen on a frequent basis. So if you have the ability to hire a lawyer, it may help speed the process along.
I definitely can. It's just a lot harder being, incarcerated due to the fact that I am in Georgia and whatnot. I know if I had that ability, I would be a lot more able to do,
Right.
the right lawyer for me. So
Right. And so I would just,
I definitely could definitely use a lawyer, how you're saying. It'd be a lot more doable for my feet and my hands to be, out on the will to do that and to appoint the correct lawyer.
well, these are felony offenses, and I'll tell you, the judges, we're all on rotation. And when I come over into the preliminary hearing realm, the lawyers from the public defender's office do a great job in representing their clients, because I'll call it muscle memory, because they're dealing with the same people and they know what's going to happen, how it's going to happen. They know where to push, where not to push. And so I've seen them be more effective, honestly, than some of the retained lawyers.
Okay, all right. Oh,
Okay.
yes, sir.
All right, sir. You're free to go back.
Thank you. Have a good day.
You too. Mr. Reed. Mr. Reed, do you understand what you're charged with, sir?
Yes, sir.
I cannot set bond for this offense at this stage. So bond is going to be denied pursuant to Georgia statute 17-6-1. You're going to have a preliminary hearing date set for July 6th at 8:30 in the morning. Courtroom 201, but most likely it'll be by Zoom. You're going to have a, well, for the second charge, bond is going to be denied just because I'm going to let the judge that handles the bond deal with both charges. You're going to have a bond hearing date set for July 8th at 8:30 in the morning, courtroom 201. Do you want me to see if you qualify for the appointment of a lawyer?
Yeah.
So, okay. You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
I'd like to state this for the record. Deputy do the interview, he coerced me. I was under influence.
Okay. That you should tell your lawyer that. Is there anything else, Mr. Reed?
Yeah, everything that they written down, that was coerced. I was under influence, sir.
Okay. So the way that gets handled, Mr. Reed, is your lawyer, once the case is indicted, files a motion to suppress statements, and then they go through that process. The court analytical process of determining whether a statement was coerced or not. Is there anything else, sir?
That's it.
Okay, sir. You're free to go back.
Yes, sir. Thank you, sir.
You're welcome. Mr. Richards.
Good morning, Your Honor.
Good morning, Mr. Richards. Sir, you're charged with 1 count of battery.
Keep it down.
Bond is going to be set at $5,000. There's going to be a stay away provision on the bond to stay away from Joshua Richards. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for July 5th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir. That'd be awesome.
Okay. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir. I don't.
Okay, you're free to go back.
All right. Thank you.
You're welcome. Mr. Russell.
Good afternoon.
Good afternoon, sir. Mr. Russell, you're charged with 1 count of violation of Georgia Controlled Substance Act. And bond is going to be denied pursuant to statute 17-6-1. There's an allegation of 13 pounds of marijuana being trafficked, and I can't set a bond for anything over 10 pounds. You're going to have a $5,000 bond set on possession of a Schedule II drug. You're going to have a preliminary hearing date set for July 6th at 8:30 in the morning, courtroom 201. You're going to also have a bond hearing date set for July 8th at 8:30 in the morning, courtroom 201. But most likely, both of those hearings will be done by Zoom. Do you want me to see if you qualify for the appointment of lawyer?
Sir.
You said yes.
Yes, sir. Yes, Your Honor.
You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yes, Your Honor. I was under the, you said I got a trafficking charge, correct?
Yes, sir.
Yeah, I was under the assumption that I got hit with possession. Did not within the state. I never was flying or anything like that. I was in the state. So the officer informed me that I was hit with a possession charge versus trafficking because I didn't cross any state lines.
Okay. So it says that you were on a Delta flight.
Sir, I never was on the flight, sir, and the officers know that. I never was on the flight. I just was in possession of the luggage at the airport. And they told me that I had possession, and that's what we talked about when I was with the officers yesterday. So there's traffic, and I'm kind of confused on because I didn't cross any state lines.
So state lines only apply to a federal charge. They call it interstate commerce.
Yes, sir.
If you're in possession of more than 10 pounds of marijuana under Georgia law, that's considered trafficking. So if it's 9 pounds, I can set a bond. 10 pounds and 1 ounce, I can't set a bond.
Yes, sir. Understood.
Okay. Okay. Do you plan to hire your own lawyer? You want me to see if you qualify for the appointment of a lawyer?
Yes, sir. I think you just told me that I do qualify.
I did. Okay. Any other questions?
No, sir.
Okay, Mr. Russell, you're free to go. Yes, sir. Yes, sir.
With the court-appointed lawyer, I won't speak to them until, is there a way that I could possibly get a bond before the next hearing, or have to wait until that hearing to receive a bond?
So, yes, the short answer is yes, you can get a bond, but it'll have to be a consent bond through the district attorney's office.
And the only way to do that is by hiring my own lawyer, correct?
Well, the potentially the fastest way to do it is to hire your own lawyer. But the lawyers that are in the public defender's office, at least the ones that I interact with on preliminary hearings, are very good lawyers.
Yes, sir.
But they have volume.
Correct.
So it's a decision that you have to make.
Yes, sir. Could you give me a realistic timetable dealing with the public defenders?
I don't have the number.
Yes, sir.
But it
on
is
that bond date, though, that would be, I guess, the timetable, correct?
the bond hearing date is July 8th. I'm sorry. Yes, July 8th at 8:30 in the morning. So the thing that I think you should have to understand is that to the extent this is a nonviolent offense, and to the extent that you're not, El Chapo, the district attorney's office will work with your lawyer in determining what they believe to be a reasonable bond. It may not be a bond you believe reasonable, but they will most likely offer a bond, and it'll be a decision that you have to make.
Yes, sir. Do you have an idea of what that amount could be for that charge? The minimum, at least, could you tell me that?
I'll say, and it all depends on criminal history, circumstances. I think the lowest that I've seen agreed to is about 25,000. The highest that I've seen is 75,000.
Yes, sir. I just wanted to know.
Yeah. Anything else, sir?
No, sir.
Okay, you're free to go back. Mr. Smith. Mr. Smith, sir, you're charged with 2 misdemeanor offenses. Theft by shoplifting as a misdemeanor, bond is going to be set by schedule at $2,000. Possession of marijuana less than an ounce, bond is going to be set by schedule at $1,500. You're going to have a preliminary hearing date set for July 5th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. The form I have, you did not fill out. Are you currently working?
No, sir.
All right. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, I don't think so.
Okay. You are free to go back, sir.
Willis.
Mr. Willis, sir, you're charged with 1 count of felony theft by taking of a motor vehicle. Bond's going to be set at $15,000. There's going to be a preliminary hearing date set for July 6th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
No, sir.
Okay, you're going to hire your own?
Yes, sir.
All right. Do you have any questions for me, sir?
No, sir.
Okay, you're free to go back, Mr. Willis.
Thanks so much.
You're welcome. All right, do we have Mr. Larkins?
How you doing, sir?
I'm doing well. Mr. Larkins, sir, you're charged with 1 count of aggravated assault by strangulation. Bond is going to be denied on that charge.
No.
Sir, let me finish. You're charged with 1 count of terroristic threats or acts. That's also a felony offense. Bond is going to be denied. You're charged with 1 count of simple battery. Bond is going to be set at $3,000. 1 count of criminal trespass. Bond is going to be set at $3,000. There's going to be a stay away provision on the bond to stay away from a delinea day. Do you understand that, sir?
What I don't understand is, I've been in that house.
Mr. Larkins, I'm going to let you speak.
All right.
I'm going to shut my trap and I'm going to let you speak. But I got to tell you certain things, okay, sir? Do you understand that there's going to be a stay away provision to stay away from a delinea day?
Yeah.
Your preliminary hearing date is going to be set for July 6th at 8:30 in the morning. Your bond hearing date is going to be set for July 8th at 8:30 in the morning. Do you plan to hire your own attorney, or do you want me to appoint you an attorney?
I need help with that. Public defender, I guess.
Okay, I'm going to appoint you an attorney. And just so you know, Mr. Larkins, I'm going to listen to everything you have to say, but I also have to do my job and give you information. Okay, so I've done that part. Now I'm going to shut my mouth and I'm going to listen to you.
How is that terrorist? I don't understand the trespassing. I've been living in that house with that same woman. We've been together for 14 years. I've been there for 9 years in that same house.
Okay. Oh, stop. And no, and the reason I say stop is because people will rattle off 10 questions. And I'm like, just ask one question, I'll answer it. Ask a second question, I'll answer it. Okay?
Yes.
So in the state of Georgia, criminal trespass can be accomplished in 2 ways. One, you're at a place or location that you've been told to stay away from, or you damage the property of another without their permission. And it can be joint property. So it doesn't have to be a situation where Miss Day owns the property completely. If you and Miss Day own the property jointly and you destroy the property, you've destroyed her interest in the property. So that's where criminal trespass, and in this case, is saying that there is a TV that was broken. Okay, so that's the allegation. As you stand here now, you are an innocent person.
No, I said it was my TV. I broke it.
Okay. Okay. What's the next question, Mr. Larkins?
And then the call was made from someone else over a phone call that wasn't even in our household. I don't understand that neither.
You said the what?
The call was made from someone else that wasn't in our household.
To call the police?
Yeah. Even me and her both was looking like, what were they there for?
It doesn't, the call does not have to come from a person within the household. So say for example, you see a car in your neighborhood and you think—
How could they say strangulation then, if she didn't say it?
Mr. Larkins, you've jumped to the next question.
I'm sorry.
I promise you, sir, take a breath. I'm going to answer every question that you have. Okay? Say, for instance, there's a car in the neighborhood that you don't recognize, and you call the police about that car, and then they stop that car, and it turns out there's ski masks, handguns, and stuff from other robberies. The people in the car can't say, well, who called the police? We haven't done anything. People can call the police about suspicious conduct, and the police are entitled to conduct their own investigation. Doesn't mean that you're going to be found guilty. But that's how this stuff kicks off. So what was your third question?
I just don't understand how they can say strangulation. She ain't saying that, but
hold on. If you want me to read it to you, I'll read it to you. So it says that you placed your hands around Miss Day's throat and began choking her while stating you would kill her.
That came from someone else. That came from someone else making a phone call.
Well, it appears that the allegation from the affidavit is that the sister, Mr. Larkins. Okay, remember the ground rules?
Sorry.
Thank you. The sister apparently was on the phone and called the police when she heard something going on in the background. So the only person that could provide the information to the police is Miss Day. Did they separate the two of you?
Yeah.
So you don't know what was said while you were separated. So now you know what was said.
Her sister said that.
Mr. Larkin, I'm going to try this once again. You and Miss Day were separated when the police came, correct?
Right.
And she was speaking to the police, correct?
Right.
Your sister, her sister was not there, correct?
Right.
So who's the only person that could say that?
It's Miss Day.
There you go.
Because she the one told me that her sister told her.
Mr. Larkins, you can continue believing that.
Oh, shit.
And I'll continue believing in the Easter Bunny. How about that?
Damn, I believe you too. All right, thank you, Your Honor. Oh, shit.
Anything else, Mr. Larkins?
No, thank you. Yeah, so you said July 6th and July 8th?
Yes, sir.
All right, thank
Okay, free to go back.
you.
Is there anybody else you need to see, Your Honor?
No, sir. Not unless you're gonna try to force them on me. I'm gonna start calling you Detective Raquina. since I had that misstep. Have a good day. I will see you all tomorrow.
Yes, you have a good day as well.
Okay.
Laura, you need the case numbers, correct?
Correct. Yes.
All right. It's 22 CF 5584AO. Okay. This is this an add-on, folks? Oh, wait a minute.
Oh, it's one.
No, I'm looking at the second session. Never mind. Well, now I'm looking at the right one, but I don't have Torres on my docket that I looked at this morning.
Felony domestic violence, Your Honor?
Yeah, well, what I see is violation of condition of pretrial release, so I'm going to guess that he contacted the defendant, or the victim.
Yes, the underlying offense was bat strangulation and bat DV, so that's why it's...
Okay, well, this is not one that I reviewed. Oh, by the way, let me make let me make the announcement that I have reviewed, for the ones I had, I have reviewed all of the affidavits. I have found probable cause. Obviously, Mr. Brantz, you're free to make argument on any of these that you choose. And we are still appointing PDs for everybody, right? Somebody tell me if that's correct. Mr. Brantz, are we still in the?
That's fine, Your Honor. I think the order's still in place.
Okay. So under the current administrative order, I'm going to appoint the public defender provisionally to each case today unless they already have counsel, et cetera, et cetera. So this is not one that I was able to review this morning. It was not on Division 51's docket when I went through it. However, I'm going to, oh, shoot. This is Spanish. Are we using headphones or what?
No, Your Honor, everything's over the PA. I don't have visual, so if you can just tell me when you want to start. I wasn't sure if we were starting.
Yeah, no, that's fine. It's my fault. I forgot. Sir? Oh, that's right. You guys brought the paper over. Okay.
You want it?
Well, for the ones I haven't reviewed, that, yeah, I do. Oh, we got a warrant for this. Good.
I'm sorry, Judge Johnson. Did you need me to translate it to Spanish, for the group as a whole, what you stated regarding the PC and provisionally?
No.
Okay.
No, I did not. All right. So, but I do want to translate this. All right, Mr. Torres, you are here because you have violated a condition of your pretrial release, which I'm going to presume is that you contacted the victim.
Yes, they're unable to make court, Your Honor.
Go ahead, Laura.
I'm sorry, I didn't hear what the person just said at the
I don't know if I can speak. Yes, we did make contact with the victim, but she will not be attending IAs.
Thank you. Señor Torres, usted se encuentra aquí porque incumplió con las condiciones de su libertad provisional. Me parece que fue porque tuvo contacto con la víctima. Su señoría, sí logramos comunicarnos con la víctima y ella indicó que no podrá personarse hoy a la vista inicial.
And Mr. Torres, because you violated.
Your Honor, I believe the warrant suggests that there wasn't a PTR appointment made. They never, I don't know if it was contact with the victim. I believe it was a failed PTR appointment.
Su señoría, creo que fue por falta de presentarse a la cita de la libertad provisional. No fue por tener contacto o trato con la víctima. Fue por no presentarse a su cita para la libertad provisional.
Sí, pero lo que pasa es que yo no sé inglés. Entonces el que me llega las cartas es mi vecino. Y él la leyó y me dijo fue que lo que tenía que pagar una multa de 50 pesos más nada. Él no me dijo más nada.
The thing is, I don't speak English, and the correspondence was sent to my neighbor, and he told me that all I had to do was pay a fine, and that's it. He didn't tell me anything else.
Well, sir, I'm not sure why you would be taking legal advice from your neighbor, but I would suggest that's not the best course of action.
Señor, no entiendo por qué usted está aceptando asesoría legal de su vecino, pero le sugiero que no es el proceso más lógico que tomar.
And Mr. Brantz, I did see this affidavit now that I see it here, and my concern is that his PD also was unable to contact Mr. Torres as he had no address and his phone was not working.
Licenciado, estoy viendo ahora la affidavit que tengo ante mí y también yo tengo la inquietud que yo tengo es que el defensor público de él tampoco pudo tener contacto con el señor Torres ya que su teléfono no está funcionando y no tiene alguna dirección para él.
And for that reason, I'm going to leave these violations of pretrial release at zero bond. Sir, you are free to seek modification of that from the judge on this case. And I would urge you to get in touch with your lawyer as soon as possible to do that.
Bien, debido a esa razón, yo considero que él incumplió con las condiciones de la libertad provisional, por lo tanto, se impone prisión preventiva con respecto a fianza. Y, señor, usted está en su pleno derecho de solicitar al juez asignado a este caso modificar esta fianza. Y le sugiero que se ponga en comunicación lo más pronto posible con su abogado.
Your Honor, I would object. I believe he is entitled to bond.
Su señoría, protesto. Yo sí considero que él tiene todo el derecho a que se le conceda fianza.
This is not an initial appearance, Mr. Brands. He violated a condition of his pretrial release. I disagree. You're free to appeal that order. Good luck to you, sir.
Licenciado, esto es solo una vista de primera instancia. Él incumplió con las condiciones de su libertad provisional, por lo tanto no estoy de acuerdo con usted. Usted está en sus plenos derechos de poder apelar dicha orden. Buena suerte a usted, señor.
All right, Laura, the next case I have is Pacheo. Mr. Pacheo. You're up and around. The case number's 2022 CF 6975AO.
Your Honor. Oh.
Yes, Mr. Branch, did you wish to be heard?
Licenciado Branch, ¿usted desea tener la palabra?
Yes, as probable cause on the charge, I don't believe anything in the affidavit suggests that he was aware, had knowledge of, or should have.
I cannot. I'm sorry, Your Honor. I'm getting a lot of interference. If you can get closer to a mic or something, I'm not catching all his words.
Mr. Branch, you may want to pull that microphone up near you.
These aren't on. It's just the webcam.
Oh, they're not? Oh.
It's just the
I don't know.
webcam, I think.
I don't know how to fix that.
I can move up.
Mr. Branch, just do your best just to, I don't know, speak loudly and clearly.
Sure. As to probable cause on the charge, I don't believe there's anything in the affidavit that suggests our client had knowledge or should have had knowledge of the pregnancy. I believe it was 9 weeks, but nowhere in the affidavit did it say, or did the, allow the interpreter to translate. Sorry.
Su señoría, con respecto a los indicios razonables de criminalidad, yo sé que en la affidavit se le está acusando a él de un ilícito, pero no pienso que mi cliente supo que la víctima estaba encinta. Al menos yo no lo veo en el affidavit.
I believe there was just a conclusory statement by the affidavit officer.
Creo que simplemente es una declaración conclusiva que realizó el agente de este affidavit.
Well, if I remember correctly, do you have the PC on this one? Yeah, I did remember correctly. They've been married for 6 years and they have a 2-year-old child together. Simply because the affidavit is devoid of any acknowledgement on your client's part that he knew of the pregnancy, I don't find that a compelling argument. They've been married for 6 years. They already have a child. I have every reason to assume that he did know she was pregnant.
Yo me acuerdo muy bien que en el consta aquí que han estado casados por 6 años y tienen conjuntamente un hijo de 2 años, simplemente porque en el auto falta esa lenguaje y que indique que su cliente tenía conocimiento de este embarazo. Me parece un argumento planteado por tu parte que no me convence, porque él debía de haber sabido, ya que habían estado casados por 6 años.
It is the court's finding, Your Honor, but I believe probable cause is to be found within the 4 corners of the affidavit, but it's in the court's discretion.
Claro, su señoría, esto recaería en su discreción, pero yo considero que los indicios razonables de criminalidad deberían constar en el documento mismo.
All right. By the way, do you know which victims are here?
A ver, ¿acaso sabe cuáles de las víctimas se encuentra aquí?
Interpreter, you don't have to interpret this. No, Your Honor, I don't know. I know they're here. My instruction was when they hear the defendant's name, they'll be asked to step to the podium.
By whom? By me? Okay. Is Gabriela Trussell here?
Gabriela Trussell, ¿se encuentra aquí?
Okay, all right. I see nobody answering that. I'm going to grant him a bond of $3,500 on count one, the ag bat on pregnant woman, and $500 on count two, the DV battery. There'll be no contact, maintain separate residence. You may return one time with law enforcement to retrieve personal belongings.
Muy bien, se
I just
impondrá
switched
una...
I got to do the Spanish before I get to you.
Muy bien, se impondrá fianza de 3.500 con respecto al primer cargo, que es agresión física calificada contra persona encinta, luego $500 con respecto al segundo cargo por agresión física debido a un caso de violencia doméstica. Se impone las siguientes condiciones: prohibición de ningún tipo de contacto con la víctima, prohibido convivir con la víctima y se le concederá poder regresar a la vivienda una vez escoltado por agente policial para recoger sus pertenencias.
Your Honor, defendant does also have an immigration hold.
Su señoría, el inculpado también tiene una orden de retención por inmigración.
All right. And so I assume that you stating that and it being translated satisfies the requirement that we tell them. Okay.
Creo que el hecho que usted lo acaba de manifestar y la intérprete lo acaba de traducir nos permite cumplir con los requisitos regidos por ley.
All right. Good luck to you, sir.
Gracias, señor. Bueno, I'm sorry, Your Honor. I'm having one of those days. I just translated incorrectly. Buena suerte a usted, señor.
Thank you. All right. The next case I have is that Ms.? I'll just say females. The last name is Contreras Luis.
El siguiente caso es Contreras Ruiz.
Son más mis...
You can speak in Spanish.
Esos son mis apellidos, los dos.
What was that?
¿Qué dijo?
Contreras Ruiz son mis apellidos. Mi nombre es Yanka Melissa.
Contreras Ruiz are my last names. My name is Janta Abelisa.
We can, but it's tape.
Do I have the right person?
A ver, tenemos aquí la debida persona.
Yes, Your Honor, I believe you do.
Sí, su señoría, pienso que sí.
All right. Is Milton Del Cid here?
Milton Del Cid. ¿Se encuentra aquí?
He's here.
Oh, he is here? Sir, can you want to have him approach the podium? Sure.
Por favor, acérquese al atril.
All right, Laura, I think you're going to have to translate for the victim as well.
Yes, Your Honor.
All right. Sir, can you raise your right hand and face me?
Señor, por favor, levante la mano derecha y dirija su mirada hacia mí.
Do you swear or affirm everything you say today should be the truth, the whole truth, and nothing but the truth?
Jura y promete que todo lo que dirá aquí hoy día será la verdad, toda la verdad y más que la verdad.
Lo juro.
I do.
You can put your hand down.
Ya puede bajar la mano.
Sir, can you state your name for the record?
Indique su nombre para el registro, señor.
Milton Rolando del Cid Cerón.
Milton Orlando Del Cid. ¿Cuál es el otro apellido?
Cerón.
Cerón.
And sir, how are you related or connected to the defendant?
Señor, ¿cuál es la conexión o cómo es que usted está relacionado a esta inculpada?
Es mi novia.
She's my girlfriend.
Okay. And are you here today to tell me that you wish to have contact with the defendant?
Usted se encuentra aquí hoy día porque desea indicarme que a usted le interesa tener contacto con la inculpada.
Or that you do not wish to have contact with the defendant?
¿O es que no desea tener contacto con ella?
Deseo tener contacto con ella porque no tengo ningún cargo contra ella.
I want to have contact with her because I have not filed any charges against her.
Okay. So you're not in fear from this person?
Por lo tanto, ¿usted no siente temor con respecto a esta persona?
Claro que no.
Of course not.
All right, do you live together?
¿Viven juntos?
No.
No.
Okay. So, all right, and can you tell me today that you would have no problem if she were to become violent again in picking up the phone and calling law enforcement with the understanding that if you do that, she will be picked up and brought back to jail, no questions asked?
Usted me está indicando aquí hoy día que no tendría ningún problema con que ella vuelva a tener contacto con ella, y si ella empieza a ser violenta, usted marcaría a la policía sabiendo que si lo hace, ella sería detenida y encarcelada sin que le hiciesen pregunta alguna.
Sí, entiendo.
Yes, I understand.
All right, then I will grant the defendant a $500 bond under the condition that she may have non-hostile contact with the victim.
Muy bien, se le concede a la víctima fianza de $500 con el entendimiento de que cualquier trato que tenga con la víctima tendría que ser sin hostilidad.
What that means, ma'am, is that you may have contact with Mr. Del Cid. However, if you raise your voice to him, if you raise a hand to him, if you act aggressive in any way, and he calls law enforcement, you will be brought back to jail and no one will ask your side of the story this time. Do you understand?
Lo voy a conceder con el entendimiento, y esto significa que no puede tener ningún tipo de trato hostil con el señor Del Cid. Si usted en algún momento dado le levanta la voz, le levanta la mano o es agresiva hacia él, él llamará a la policía y usted será traída ante la autoridad sin permitirle a usted poder relatar su versión. ¿Entendido?
Okay.
Okay.
All right. Good luck to you.
Buena suerte a usted. Your Honor, may the interpreter have the case number, please?
Oh, I'm sorry. That was, hang on. That was 2022 MM 4080. I'm going to assume AO. Next is Mr. Guzman-Burrito. Do we have a victim in this case, Guzman-Burrito? You do. Can you come to the podium, please?
Tenemos una víctima en el caso del señor Guzman-Burrito. Si es así, por favor, acérquese al atril.
The case number, Laura, is 2022 MM 4077AO. Good morning, ma'am. Do you need the interpreter or not?
Buenos días, señora. ¿Acaso usted requiere un intérprete, sí o no?
Sí.
Yes.
All right. Can you raise your right hand and face me?
Por favor, levante la mano derecha y dirige su mirada hacia mí.
Do you swear or affirm everything you say today should be the truth, the whole truth, and nothing but the truth?
Jura y promete que todo lo que dirá aquí hoy día será la verdad, toda la verdad y nada más que la verdad.
Sí.
Yes, I do.
All right. You can put your hand down.
Bien, ya puede bajar la mano.
Can you please state your name for the record?
Por favor, indique su nombre para el registro.
Ángela Rivera.
Angela Rivera.
Ms. Rivera, how are you related to the defendant?
Señora Rivera, ¿cuál es la relación que tiene usted con el inculpado?
Mi esposo.
He's my husband.
Okay, are you here today to tell me that you wish to have contact with your husband or you do not wish to have contact with your husband?
¿Acaso se encuentra usted aquí hoy día para indicarme que desea seguir teniendo contacto con su esposo o que no desea tener ningún trato alguno con él?
Yo tengo una niña con él y tiene que ver su hija.
I have a daughter with him, and he needs to see his daughter.
That's not exactly answering my question. Are you in fear of this person?
No me está respondiendo a la pregunta exactamente. Entonces, dígame, ¿usted tiene miedo de este inculpado?
Sí.
Ya.
Okay, well, I understand that you have a child in common. However, it is my inclination to order that he have no contact with you. We can arrange to have a third party be available for childcare issues that need to be discussed. And in the future, if you choose to modify that condition or change your feeling on that, you could address that with the judge. But if you are in fear of this person, I'm not inclined to allow him to have contact with you, and I would order that he maintain a separate residence.
Muy bien, señora, entiendo que ustedes tienen un hijo en común. Sin embargo, tengo la intención de imponer en la disposición que usted no tenga ningún tipo de contacto con él. Claro está, se pueden hacer arreglos para que una tercera persona esté disponible y ocuparse de cualquier asunto con respecto al cuidado de la menor. Y en el futuro, si usted desea modificar o cambiar esta disposición, podría entonces dirigirse ante el juez para ello. Pero sabiendo que usted le tiene temor a él, no estoy dispuesto de que usted tenga ningún tipo de contacto, no estoy dispuesto de que él tenga ningún tipo de contacto con usted y ordenaría que tampoco esté permitido el convivir con usted.
Okay.
Okay?
¿Está bien?
Sí.
Yes.
All right. All right, Mr. Guzman-Burrito, you do qualify for pretrial release. That means you don't have to post a bond, but you have to follow their rules.
Señor Guzman-Burrito, usted reúne los suficientes requisitos para la libertad provisional, lo cual significa que no le toca depositar fianza, pero sí tendrá que seguir las normas que ellos tienen.
So, in addition to whatever rules they ask you to abide by, I'm also going to order that you have no contact whatsoever with the victim in this case, your spouse.
Entonces, aparte de tener que seguir las reglas que ellos le van a pedir a usted, también ordenaré que usted esté prohibido tener ningún tipo de trato contacto con la víctima en absoluto, es decir, su cónyuge.
You must maintain a separate residence, and you may return to your residence one time with the escort of law enforcement to retrieve personal belongings.
Entonces, usted estará prohibida convivir con ella y se le permitirá regresar a la vivienda una vez escoltado por agente policial para recoger sus pertenencias.
Ma'am, is there anyone who is available to act as a go-between for child care issues that we could designate as that person? Is there anyone who can help you with this?
Señora, ¿acaso hay alguien que estaría disponible para poder llevar a cabo el papel de intermediario entre ustedes dos con respecto a los asuntos de la niña? ¿Hay alguien disponible que podríamos designar que le pueda ayudar a usted?
No, yo solamente vivo con él y mi hija, yo no tengo a nadie más.
No, it's just me and my daughter that live with him. I don't have anyone else.
State, do you have any objection if I order he can text her for child care purposes only?
No, that's fine, Your Honor. There is also an app that I have heard some parents use as a way of coordinating. Again, it's still via phone, but at least then there would be more of a record, I believe.
¿La Fiscalía tiene alguna objeción que yo permita que él pueda enviarle mensajes de texto a ella con respecto al tema del cuidado de la niña? No hay problema, su señoría, pero también existe una aplicación que se puede utilizar en donde los padres pueden coordinar eso. Creo que esa aplicación permite que siempre haya un registro de las conversaciones.
All right, well, so, sir, I am going to order that you can contact your wife via text solely for the purpose of coordinating child care.
Bien, señor, voy a permitir que usted pueda comunicarse con su esposa vía mensaje de texto solo para el único propósito de coordinar el cuidado de la menor.
And just so we're clear, you are not to text her about anything else.
Y para que le quede bien claro, usted está prohibido enviarle mensajes de texto de cualquier otro tema.
So if you send any other message, either a threat or anything, begging her to do something with the case, anything that is not related to child care issues, and your spouse were to show that text to law enforcement, that would be considered a violation of your release conditions and you would be rearrested. Do you understand?
Entonces, si usted le envía un mensaje donde la amenaza o un mensaje de cualquier cosa donde, por ejemplo, le está pidiendo, rogando que haga algo con respecto al caso, mensaje que no esté relacionado al cuidado de su hija, ella lo podrá enseñárselo a la policía y dicho hecho será considerado un incumplimiento de las condiciones de su libertad y usted será detenido nuevamente. ¿Entendido?
Do you understand, sir?
Señor, ¿me ha entendido?
Yes, sí.
Yes.
All right.
I have a question.
Yes?
Dígame.
Entonces, si es ella que me envía los textos a mí, ¿qué yo puedo hacer en ese caso?
What if she's the one that's sending me the messages, text messages? What do I do then?
Sir, the order only applies to you. It doesn't matter what she sends you. The order, the order only applies to you.
Señor, esta orden, esta medida solo corresponde a usted. No tiene que ver nada con ella. Esto solo corresponde a usted, a su persona. Okay.
What was the bottom
It's PTR. No contact other than texting and maintain separate residence. All right, good luck to you, sir.
Muy bien, entonces ningún tipo de comunicación, al menos que sea por mensaje de texto, y no puede convivir con ella. Buena suerte a usted, señor.
All right, I think this is our last case, Laura. It's case number 2022 MM335AW. The defendant's name is Orozco-Aguilera. Do we have a victim present for that case?
Tenemos víctima presente para el caso Orozco-Aguilera.
All right, I see nobody responding. Okay. Senor Orozco-Aguilera, he does not qualify.
Legal status.
Oh, okay.
I'm sorry.
So if I wanted to do no drugs, no alcohol, random UAs, but how does it get tested?
You can do drug testing. Drug testing through PTR. You can just put no alcohol or drugs. Because he doesn't have a hold, he doesn't have a legal status. You can do no alcohol or drugs.
Yeah, but there's no monitoring, right?
If you violate.
Yeah, okay. All right, sir, I'm going to grant you a $500 bond on this case.
Señor, con respecto a este caso, se le concederá fianza de $500.
You are to maintain a separate residence.
Prohibido convivir con la víctima.
You may return one time with law enforcement escort to retrieve personal belongings.
Se le permitirá una vez regresar a la vivienda escoltado por agente policial para recoger sus pertenencias.
I'm also going to order that you consume no alcohol or illegal drugs while you're on pretrial release.
Y también ordenaré que mientras que esté libre bajo programa de libertad provisional, estará prohibido el consumo de alcohol o drogas.
There's no PTR.
No.
Oh, because you said on pre-trial release.
Oh, did I say? I'm sorry. I misspoke. I didn't mean to say, well, I meant
We know, I know.
on,
Well, he's not
while
on
he's
bond. he's not on
released
bond.
prior to his case. All right. Good luck to you, sir.
Buena suerte, señor.
Your Honor, no contact?
Yeah, I said that.
With the two victims, it was two victims, Your Honor.
Oh, there's two, yeah, no contact with any victim, maintain separate residence from any victim. No, may return one time, no alcohol or drugs.
Bien, prohibido contacto con ninguna de las víctimas, prohibido convivir con ninguna de las víctimas, permitido ser escoltado por un agente policial una vez y prohibido alcohol y drogas.
All right, good luck to you.
Buena suerte a usted.
For bond?
All right.
Okay.
That's the attorney case.
Huh?
That's the attorney case.
What, D'Angelo? Okay. All right, Laura, thank you. That was our last Spanish case.
You're welcome, Your Honor. I will disconnect.
Thank you. All right, this is Mr. D'Angelo. Are you here for him?
Yes, sir.
Okay. And this was brought back today. Was this addressed yesterday?
That's my understanding, Judge. I was not aware of the case until after court yesterday. Michael Brown, on behalf of the defendant. Judge, I have not filed an NOA on this case, and I do have a witness here.
Okay, well, it is PBL. He's not entitled to bond.
Your Honor, if I may, it's attempted second degree, so actually it's not a PBL. He is entitled to bond.
Can I have two?
Well, let's avoid the conversation. Is the state stipulating to that he's entitled to bond?
Yes, Your Honor, that is the reason that it was reset for today, was just for a bond amount. He is
Okay,
entitled
does the
to
state have a
bond.
recommendation on amount?
I'd go with 25,000, Your Honor.
A defense, you want to be heard as to the amount? If he's entitled to a bond, I'll give him a bond. When I looked at this morning, I must be wrong, because I thought even attempted second was still PBL. Because he shot him, right?
Attempted second's a second.
Allegedly, I'm sorry.
Attempted second's a second-degree felony. If they would have alleged a firearm, that changes things. They didn't charge it under the firearm.
Didn't the arrest affidavit say?
That's the police decision. They charged as attempted second.
Didn't he go to the hospital with
Yeah.
several gunshot wounds?
Yeah, that's not the charge before the court.
No, unfortunately, they just charged it as attempted second degree murder, Your Honor. Yeah, there was no firearm mentioned. Even though, yes, he was shot with a black handgun. Yeah.
Judge, I just want to,
Well, hey, look, if that's what the state did, it's what, or not the state, sorry, geez, God, good look from Miss.
Judge, just to give, I'll proffer a couple things for the court's decision on amount.
Well, here's the thing. Since that's the status of the case, I guess, and the state's stipulating the fact that he's entitled to bond, then he's entitled to bond. However, the state may amend it, right? And he may then be ineligible.
Correct.
So
Before the court.
I understand, Mr. Bankiewicz.
Judge,
I'm not disagreeing with you.
I'm not on entitlement. The court suggested a $25,000 bond.
Well, no, that was the state.
Oh, I'm sorry.
I asked the state what they said, and the state said 25.
Can I just proffer a couple things for the court's consideration on amount?
Well, I was coming to the defense to ask what they want.
I'd ask for a $10,000 bond.
Okay, is he have the inability to pay the 25? I don't, because I will tell you this, I don't think the 25 is unreasonable.
I just want to let the court know a few things. The alleged victim in this case has a felony warrant out, and for a VOP, Ms. Bartlett, who is present before the court, is Mr. Armstrong's girlfriend. Mr. Armstrong lives with Ms. Bartlett. The alleged victim has an injunction against him, and he was present, would be her testimony, at her house where he wasn't supposed to be, and the victim has been
Is
threatened.
that where this occurred?
That's my understanding according to Ms. Bartlett.
So I don't remember anything about the location other than they, in a car together, he got out, the incident happened, he got back, and the girlfriend drove him to the hospital.
Let me ask Mr. Armstrong, can you afford a $25,000 bond?
What's 10% of that?
What?
In other words, it'd be $2,500 to a bondsman.
Correct.
Not really.
How much can you afford?
Well, I didn't understand. Did he say yes or no?
He said not really.
Is that what he said?
Yeah, that's what I heard.
Why can't I hear anybody? I don't understand. You guys can hear him? Okay. I'm telling you, my ears are still stuffed from the plane, I guess. I don't know.
Mr. Armstrong, could you afford a $10,000 bond?
Yes. Yes.
Is he working?
Are you working if you were out?
Yes.
What's your job?
Work for 84 Lumber.
I mean, I got to be honest with you, Mr. Bankwitz, after reading the affidavit, and I understand that's simply an allegation, hearsay at this point, et cetera, et cetera. I do have a concern for him being a danger to the public. I mean, it's pretty egregious what's alleged. And it wasn't only in the allegation, as you're well aware, it wasn't simply what happened between allegedly this person and the defendant and the victim, but as they drove away, he was allegedly taking shots at the vehicle as it drove away as well, which seems to indicate a total disregard for the safety and welfare of the other person at the scene.
Understood.
And so, I didn't look to see if this guy has any history, criminal history or anything, and that may or may not be relevant at this point. I think it would be.
He's not a convicted felon. He has two.
No, it's okay. What I'm explaining all this to you is to sort of underscore the reason that I'm going to go along with the state's recommendation. I appreciate your position, and I can appreciate whether he can afford. He says he can afford 1,000, but not 2,500 if he were to go to a bondsman. But the allegations are very serious, and you and I both know. But for the stroke of the pen, we wouldn't even be having this conversation.
Yes, sir.
So I think he should consider himself fortunate that he's getting a bond. And as we've already discussed, or at least addressed, I don't know that his entitlement to a bond is going to remain. That's up to the state, obviously, but. All right. So with the stipulation of the state, as the posture of the case as it stands today, I will grant him the bond. The conditions are he is to possess no weapons, no firearms, no anything. If you have any of that in your possession, you must surrender it to law enforcement within 24 hours of your release. You are to have no contact whatsoever with either victim. I'm going to call the witness a victim as well at this point. So no contact whatsoever with any of those people that were named in the arrest affidavit. It seemed like there was some relationship between these two, but it's not familial, right?
It's not familial. Miss Bartlett is Mr. Armstrong's girlfriend.
Okay.
Mr. Armstrong lives with Miss
She's the one that was in the car? No.
No.
Oh, okay, all right.
She's not a witness.
Okay, well, that's fine.
The victim.
All I'm saying is don't have any contact with the victim and the witness.
Okay.
Other than that, I don't care.
Okay.
Okay?
Yes, sir.
All right. State any other conditions? All right, grant him a bond of 25,000 with the aforementioned conditions. Good luck to you, sir.
I have nothing further before the court. May be excused.
Thank you, Mr. Bankwitz.
Mr. Brown.
Brown! Oh, I apologize.
You said it right the first time.
Yeah, okay.
I'll see you next Friday, Judge.
Okay, I'll try to remember, Mr. Brown.
I'll see you online next Friday. Good job.
Okay. All right, so you need that? That's the old one. What's the matter? Why are you shaking your head? Bless you. Bless you. All right, is this Khalil Batia?
Yes, sir. Bethea.
Bethea?
Yes, sir.
All right, Mr. Bethea, you have actually two cases. The first one is 2020. Oh, I forgot I'm supposed to be saying these case numbers. The first one is 2022 CF 4441 AO, burglary of a dwelling with 2 criminal mischief. I will grant you a bond of $10,000 on count 1, 100 and 100 on 2 and 3 respectively. You also have 22 CF 7003 AO, that's a domestic violence battery and a resisting officer without violence. Do we have a victim in this case? You do? Are they down at the jail?
They shouldn't be, Your Honor. They should be here.
Well, it looks like corrections was shaking their head yes.
It says that the victim may attend court, but evidently she's
No.
not here. We,
Oh, you weren't shaking your head at me. You were shaking something else.
we did give them the times to be here, Your Honor.
All right, that's fine. All right. Well,
Candasia Thomas.
all right. Deputy's going to call the halls for the victim. At this point, unless the victim appears and testifies otherwise, as I said, I'm granting him a bond of $1,500 on count 1, 100 on count 2. All right. You are to have no contact whatsoever with Candasia Thomas. You must maintain separate residence. Do you live together?
No, sir.
Okay.
No, sir.
Sorry?
I was
okay.
saying no.
All right. That's fine. Then there's no reason for you to need to return. Those are the bonds I'm granting. Good luck to you.
Your Honor, what was that case number for the battery and the resistant, please?
2022 C.
Is this a misdemeanor case?
It is.
I've got it as 2022 CF 7003 AO. That's what printed out from Odyssey.
Yes. Oh, wow.
Oh, well, I thought you said it was misdemeanor.
No, I thought it came in as a misdemeanor.
Yeah, when you read it, it's a misdemeanor. There's
Yeah.
nothing felony about this, but it was given a CF number.
I thought it was it aggravated?
No, Your Honor. No, sir.
Okay,
That's the case number I got. I'm not going to change it.
the other case had conditions on the warrant. Are you keeping those conditions?
Yes. Was that the burglary?
Yes.
Oh, well, yeah, no contact. I'm sorry. So on 2022 CF 4441 AO, in addition to the bonds that I previously announced, 10,100, 100, also no contact with victim, co-defendant, with the victim, maintain separate residence, do not return to the scene of the offense. Oh, do not possess or consume alcohol, drugs, illegal drugs, or controlled substances without a prescription, and do not possess any weapons or firearms. I'll add that if you have any in possession, you must surrender them within 24 hours of your release.
That felony, it should be a misdemeanor.
Well,
Is there another number?
No.
Okay.
we can't. You guys amend it later, or do we need to address it today?
I think it can be fixed at a later time, Your Honor. He's charged with a misdemeanor, so it's more, I would say, administrative than it is.
Oh, he is?
anything else.
Okay. Is that just the arresting officer's
No,
mistake?
it's on here. No. No.
All right, well, whatever.
Okay. Yeah. Moving on.
Good luck to you, sir.
Thank you.
I'm the judge. Address the judge.
Hello, Judge.
Mrs. Bird?
Mister.
All right. Are you Mr. Bird?
Yes, sir. Yes,
All
Your
right.
Honor.
Mr. Bird, I did read the affidavit. I did find probable cause. I am going to grant you bond. Do we have, we have a victim.
Huh?
We have a victim here. Good morning, ma'am. How are you? Can you raise your right hand? Do you swear or affirm everything you say today should be the truth, the whole truth, nothing but the truth?
Yes.
You can put your hand. You can put your hand down. Just a minute, sir. Ma'am, can we ask him to be silent for a minute, please?
Yes, sir.
Ma'am, can you state your name for the record?
Jacqueline Bird.
All right, and you are related how?
His mother.
His mother, okay. And this was this the one at the dump?
No.
Oh, living room, okay. Oh, yeah, okay, I remember this. All right, so Ms. Bird, this is your son? And you're here today to tell me that you wish to have contact with your son, or you do not wish to have contact with your son?
To have contact.
You do? You're not in fear of this person?
No.
The allegations are quite serious.
No.
Why aren't you in fear of him? Is this an isolated incident?
May I tell? I brought a letter today that's a diagnosis letter from Dr. Psychiatrist.
Well, I understand he may have a diagnosis and he may have mental health troubles, but that may even be more concerned that he's going to, act out.
If I may, Your Honor, my son just came back from New Jersey where he was attacked by someone who beat him up really badly. He has cracked ribs. He was in the ICU in the hospital up there for quite a while, I think at least a week. I helped him get back down here because of fear of what was happening up there. He has very low impulse. He's been manic for a while. There are difficulties with him being able to see his son. And he's just, what I wanted him to do was to be evaluated because there's something wrong. He's not been this way with me, this crazy physical way. He's very, very manic. And he needs to be seen by someone.
Well, I don't disagree with you, but in the meantime, sounds like you're at risk.
I was caring for his pets while he was away at his home, and I'm now back at my home. And I think what happened, it may be an isolated thing because of how manic and how messed up he is right now.
Well, again, I can appreciate that he's struggling with mental health issues and other issues, and I can certainly agree with you that I hope he gets help. He needs, is he on any psychotropic medication?
I don't know. This is the thing. I don't know his current psychologist. So that's why I called the police in order for him to be evaluated. Is this Baker Act or something? He needs to be someplace where someone can see what's going on with him. I don't know what's going on with him. I know that he's hurt physically because of what happened and he was hospitalized twice for it, but I don't know what's going on with him emotionally and mentally. He's got very, very low impulse control and he has some trauma in his past that kind of keeps coming up for him. And I just think that jail is not the right place for him. I think where he should be is someplace for him to be evaluated.
First of all, you're absolutely correct. The problem is you don't really have any mental health, services in this country. Jail tends to be our answer for that. And I'm not saying it's right, but he's entitled to a bond. I absolutely am going to, grant him some type of release. The only question today is whether I should order that he have no contact with you. And I understand you have some desire to have contact with him. Tell me you're not in fear of him. I think you told me that.
Yeah.
But everything that you're telling me is actually making me more concerned that you will be in danger if I don't order. Again, it's a piece of paper. He can violate it quite easily. However, if he does, then he will be brought back to jail without any questions asked because he's under the jurisdiction of the court. So he's not entitled to a due process, or to due process while he's under the jurisdiction of the court, and he can be rearrested and brought back to jail with no questions asked. So there's some protection for you because you can pick up a phone and tell 911 that your son contacted you, via phone, email, or came to your house or anything. And if he were to do that, he can be brought back to jail. He will be brought back to jail. Okay, so there's some protection for you. And I am not disputing your assertion or your belief that these things are happening due to mental illness. Maybe what you mean is he's not responsible for this, or he shouldn't be held responsible for this because he doesn't mean what's happening. It's simply the condition. And that may be. But until he's getting treatment, until he's, got a diagnosis and is getting counseling or psychotropic medication to help him deal with this, I'm really reticent to allow him to have contact with you.
His car is parked in front of my house. He does not live with me. So he just.
Well, that makes it a little easier.
Yeah.
Well, I'm going to order that he can return and get his car. Yeah. He would have to be escorted by law enforcement to do that, but he can get his car.
Get evaluated. My understanding about the evaluation was that they would take him for a couple of days and evaluate him, and so I thought.
Well, it sounds like you're talking about the Baker Act.
Baker Act, yes.
We're not here to deal with that. Okay, and if I remember correctly, this is the affidavit that said the law enforcement officer thought he was going on a Baker Act.
Yes, that's what I couldn't remember the words Baker Act, and I said he needs to be evaluated.
Well, okay, let me ask you a question. Did you simply call 911 and ask him to be picked up for Baker Act, or did you fill out a petition and file it with the court?
I filled out a form when they came there.
No.
That was all. And because of all what was going on, so I didn't do that properly, I guess.
Well, I don't know. It sounds like you can petition the court to have him involuntarily committed. They will hold him for 72 hours. He's required to be evaluated by a mental health professional. That person can recommend further, not incarceration, that's the wrong word.
Your Honor, once they get booked and they are seen by medical, we do not even have a mental health hold in place, but I know they are screened for mental health when they get booked in jail.
I'm sorry?
They get screened for mental health. So that may still be the status. I don't have a mental health hold in place. Usually if it is that, they do put a mental health hold in place. I do not see one, but that doesn't mean that he's still not going to continue on getting screened.
That's a part of, that's why I brought this letter, just to say just a little bit about it. The doctor says that, my son is very intelligent, and his level of intelligence serves to mask his difficulties with comprehension of social situations and all that stuff. So what happens is that people won't recognize it.
And I can appreciate all that. And he needs to get some assistance. If you wish to have him involuntarily committed, I would urge you you can even, I'm assuming he lives in Orange County, you could even, before you leave here today.
Yes.
Get, is it the 5th?
345 self-help.
345, the self-help clinic, and you can ask them about the steps you need to take.
Okay, I would like to do that.
Yeah, but what you're going to need is you're going to need a petition for a Baker Act petition, and you're going to ask a judge to make a decision based on what you put in that petition. As to whether or not they're going to issue a pickup order. I think that's what they call it. And if the judge does that, then he will be taken to a hospital.
Yes.
He will be evaluated by a mental health professional. They can hold him for 72 hours. If the mental health professional deems that he should be detained longer or put into some sort of treatment, they can make that decision then.
Okay. That's what I intended to do. What happened when he came to the house, everything
I understand.
Spiraled.
I understand. And I can appreciate what you're going through. All right. I'm just going to urge you to look into that. You're here today. You could, if you got time, you could look into it today. I am going to grant him a bond because he's entitled to a bond.
Yeah.
Okay. And the bond is going to be $500. Oh, I actually had put 1,500. Is this felony? Oh, yes, it's because you're over 65.
I did not press charges, Your Honor. Doesn't matter.
I understand.
Your Honor, as to a contact order, I would have you ordered no hostile, because if Ms. Bird decides to apply for the guardian advocate position if he is corrected.
Well, I don't think that's really something for me to consider whether Ms. Bird's going to apply for guardianship, and it didn't sound to me like she is. I think she has an avenue to address her concerns. That's up to her if she wants to go that way.
I don't even know what that means.
Well, the public defender is suggesting that I alter the contact order to be non-hostile contact in the event that you wish to seek a guardianship over your son, which that's a little more complicated issue, and there's a lot more that goes into that.
Your Honor, it was more to the Baker Act hearing that needs to be held within 5 days of the petition, and that a guardian advocate can sometimes be appointed at the hearing.
Right, but why would she need non-hostile contact to do that? I don't see why that would be necessary.
I guess for the purposes of the hearing, they would both be present at the hearing.
Well, the judge hearing the Baker Act would have the power to modify his conditions of release, would they not?
I believe so, if it's a judge. I don't know if magistrates have that same power. I sometimes see magistrates holding hearings for Baker Acts.
Well, all right. I can appreciate that. In this case, 2022 CF 7004AO, I'll grant him a bond of $1,500. I will order that he have no contact with the victim, his mother. He maintain a separate residence, which he already does, so that shouldn't be an issue. He is permitted to return one time with law enforcement escort to retrieve his vehicle from his mother's residence. And Mr. Byrd, I have appointed the public defender to represent you today, so you have an attorney on this case. If you think it's necessary to modify the conditions that I've placed on you, for instance, to non-hostile contact or whatever it may be, you're free to seek that from the judge on your case.
Can I talk to you?
But in the I would advise you to speak with your lawyer, because anything
you said 500 first. I'm on Social Security. I don't have money.
Judge, I think you said 500, and then you said 1,500. Can we get a clarification?
Well, it's because I thought it was. I mistakenly was thinking it was misdemeanor battery. It's not. It's battery on a victim 65 years of age or older. It's a felony.
No.
What?
Your Honor, can I also ask for no drugs, no alcohol based on his history?
What's my history?
Were drugs or alcohol involved in this one?
Not in this, Your Honor, but if you look at the face sheet,
Uh-huh.
there are a number of drug convictions.
All right. Well, then, per the state's request, I'll order that, sir, if you do post your bond and your release, you are to have no illegal drugs or alcohol, no controlled substances without a prescription.
Sir?
Yes.
Never mind, I have prescription.
Are you what?
I have a prescription for medical marijuana. I'm not in no drug trouble. I take it every day. Anxiety to keep me off the other pills. I don't bother nobody.
Sir, if you have the legal ability to have that, then
I do.
My order doesn't prohibit it. It says you may not have any drugs or alcohol without a prescription.
I don't drink 8 years, sir. Can you please?
All right.
Sorry.
All right. Sir, good luck to you. Ma'am, if that's something that you're interested in doing, I would urge you to stop downstairs if you have the time to do it.
345?
Taking off. Yeah.
All right?
Give us a call.
Yeah.
Thank you, Your Honor. Thank you, Mom. Sorry.
All right. My next case is Bradley. This is Xavier Richard Bradley. Do we have any victims for this case?
Your Honor,
Sorry?
he's mental health.
Oh, he's mental health? All right.
Yeah.
Okay.
We'll waive
that. Yeah.
Let's say he'll waive.
He'll waive the.
Oh, I'm sorry. Forgive me, Mr. Brantz. It's been a few weeks since I did this. All right, so you're waiving on Bradley. What I have? I had 3,500 on count one. This is 2022 CF 5569 AO. Count one was DV battery by strangulation, $3,500 bond. No contact, maintain separate residence, no drugs, no alcohol. May return to the residence one time with law enforcement to retrieve belongings. And on count two, I'll grant him a bond of 100. So 3,500 on count one, 100 on count two. In case number 2022 CF 6993 AO, I'll give him a bond of $1,500, no drugs, no alcohol. Point PD. All right, next I have Chisholm.
She in mental health, Your Honor.
All right, health is Chisholm.
We'll waive that appearance as well.
Who is?
This one that you just.
Well, no, he said Chisholm was mental health.
Yeah, he said he's gonna waive it.
Oh, God dang. I cannot hear. I swear I'm deaf. All right, Chisholm, PD's waiving appearance. What did I have? Oh, I had $3,500 bond in case number 2022 CF 7005 AO, that on a victim over 65. I'll grant him a bond of $3,500. Maintain separate residence. No contact. No drugs. No alcohol. Point the PD. All right. Let's see. Bradley. All right. We're jumping around. Is Bradley there?
No, sir. Next, we have a Marcos Cora Gomez. Guzman, I'm sorry.
Oh, I must not have gotten rid of that.
I believe we did that.
Yeah, I just didn't go to the next one. All right. Okay, so this is case number 2022 CF 5246 AO. I don't think this is the one. Oh, I remember. I couldn't understand why I wrote the notes I wrote, but now I remember. I wrote on this.
It should be a PBL.
Zero bond. Well, no, I don't have any indication that this one is. He's got DV battery, burglary of a dwelling, and criminal mischief.
Right.
But the reason that I had indicated to myself that I wasn't going to grant a bond is because he was out on bond for DV battery by strangulation from the same, or on the same victim.
Yes, Your Honor.
And so my note to myself was, because I have a great concern for the safety of the victim in this case, I wasn't going to grant a bond, and I was going to tell Mr. Cora Guzman that he would have to seek release from the judge on this case due to the fact that you were out on bond for an egregious domestic violence charge against the same, with the same victim. And so
Your
clearly, Honor. Yes, Mr. Grant.
I would have you set bond on the warrant, and if you are inclined to revoke bond on the out on bond case, that would be the legal route, because he is entitled to bond on the charges in the warrant.
Am I not entitled to make a determination that the public is in danger or the victim is in danger from this person, even though he may be otherwise entitled to bond under the law?
Yes, Your Honor. If you can review this and state that.
Do I have to do a written
No.
finding of my reasoning?
No, No, Your Honor. It just has to be stated on the record that you find that the community, this particular victim, there are no conditions of release that you believe would
Protect this person, because he was already out on bond for. Yes, go ahead, Mr. Brantz.
Your Honor, that's incorrect. The rules of criminal procedure suggest that the state can file a pretrial detention motion to hold our client no bond, but that has to be filed with the court. Further, it has to be a charge punishable by life, a capital crime or a charge punishable by life to hold a client no bond. That would be the proper route.
So it's your position, Mr. Brantz, that I do not have it within my discretion to find that there's no conditions of release that would protect the alleged victim in this case and deny him bond. Is that what you're saying today?
On the warrant, Your Honor, yes. But you are able to revoke bond on the out-of-bond case and hold him no bond there.
I'm fully aware of that, and that will be revoked. But I am also finding it because I believe it's within my discretion, and I would urge you, Mr. Brantz, that you have preserved the issue for appeal. But I believe I have the discretion to find, Ms. Eugene's got something to say.
Your Honor, if you look at Florida statute 907.041, it is, sorry, I found it and then lost it. It is 4C under the subheading pretrial detention. The court may order pretrial detention if it finds a substantial probability based on defendant's past and present patterns of behavior that any of the following circumstances exist. The defendant has previously violated conditions of release and that no further conditions of release are reasonably likely to assure the defendant's appearance at subsequent proceedings. The defendant, with the intent to obstruct the judicial process, has threatened, intimidated, or injured any victim, potential witness, juror, or judicial officer, or has attempted or conspired to do so, and that no conditions of release will reasonably prevent the obstruction of the judicial process. So there are actually, Your Honor, a number of conditions, instances where you can hold someone pretrial detention with no bond, and it's not only that the state has to file a pretrial detention motion.
I appreciate you giving chapter and verse to my prior reasoning and confirming for
may I just make one more thought?
Briefly.
That same statute says that it should be governed by the rules of criminal procedure.
All right, Mr. Brantz, I'm not going to give this guy a bond on the new case. I am revoking it on the old case, and I will sleep soundly. You may appeal it. You are free to do that. I'm not giving this guy a chance to get out and have somebody end up dead. Bond is denied. You have to seek bond on this case from the judge on this case, and I'm also revoking your bond in 2022 CF 4908AO, battery by strangulation of the same victim. And I really don't think I need to state a lot on the record for my reasoning. I think it's pretty clear from the facts. But I believe I've also stated it sufficiently in the event that this gets appealed. Good luck to you, sir.
There's conditions on the warrant.
There's no conditions on that. I'm not granting him a bond. Any conditions would have to be set by the judge.
Okay.
He's not getting a bond from me.
Your Honor, that's on all counts.
Correct. All right. Is this Davies?
Yes, sir.
All right, Davies. Case number 22 CF 7006AO. We have victims. Is this the one that was at the dump?
Yes,
okay.
Sir.
You broke the window, right? All right, so let's do this. Both of you can raise your right hand. Do you swear or affirm? Can you hear me, sir? All right. You both swear or affirm everything you say today should be the truth, the whole truth, and nothing but the truth? All right, you can put your hand down. Your mom, your granddad. Okay. Mom, are you here to tell me that you wish to have contact with your son, or you do not wish to have contact with your son?
I need my son home. It helps take care of him.
Okay. Do you live with Grandpa? All right, Grandpa, do you wish to have contact with your grandson? You're not in fear of this person? Sounds like he went a little nuts at the dump, didn't he?
We didn't call them.
I know you didn't call the police. That doesn't mean it didn't happen. Right? The allegation is that he put you on the ground and Grandpa had to help you up.
Everybody went. It was all of us. It was a lot. It was everybody.
We were sweating. It was hot.
I mean, we just got done.
Hang on, guys. We have to, wait a minute. We have to do this so at least there's a clear record. So, Mom, you wish to have contact with your son, and you wish him to return to the home where you live, which is also his grandfather's home.
He doesn't live with us. He lives with his dad, but he comes and helps me.
Okay, so you don't need him to live with you just to have non-hostile contact with you, but he can maintain a separate residence. That means he can come and assist you, but he can't live there. That's okay with you? Well, hang on. I'm trying to do this one at a time so we have a clear record.
That's fine with me.
Mom, that's okay with you. Grandpa, if I order you have non-hostile contact, that means he can come and assist your daughter and be in your house as long as he's not violent or hostile, verbally, physically, whatever. If he acts out in any way, either one of you pick up the phone and call 911, he is returned to jail with no questions asked. Nobody's going to ask his side of the story because he's under the jurisdiction of the court. Are you both willing to tell me that you're okay with, if he gets a little crazy again, pick up the phone?
Yeah, this never happened before. So.
Okay. I just want to know that you're okay with it. Yes? Yes, Grandpa? Yes. All right. All right. Ms. Guerra, is there any reason he doesn't qualify for?
He's on pretrial diversion out of Seminole.
Oh, he is?
Yes, out of Seminole County.
Or what's the charge?
Possession, possession of marijuana and possession of drug paraphernalia.
Oh, okay. So
He was-
it's not a battery charge, though.
No, Your Honor.
Is he working?
He doing my job because I can't work.
He helped me on the truck.
We're doing the roof. We're
Is
doing.
he getting paid? Or is he just?
No, anything.
Well,
All right.
We
all right.
give him money. Yeah, we take care of him.
All right. Mr. Davies, I'm going to release you on your own recognizance. Okay? You're going to be released under the condition that you have non-hostile contact with your mother and your grandfather.
Your Honor, the state objects. This would be a dangerous charge, and per the statute, he cannot be released on non-monetary conditions.
You do have discretion, Judge. You can send our.
Wait, Mr. Brantz is now saying I have the discretion. A minute ago, you said I did not.
In this instance, yes.
Well, Ms. Eugene, would the aforementioned statute that you read into the record on the last case, would it not apply here?
It's the same statute, Your Honor.
So, but you're saying there's something that would prohibit me from, I mean, I can make it $1.
For the majority of it, it does say that you are not allowed, it would prohibit you from doing it, but Mr. Brands is also correct that down at the bottom, it does also say you have the discretion to do it.
Yeah. So I can either grant him a $1 bond and satisfy that, or just ROR him.
Yes, Your Honor.
Okay, all right. So I'm going to grant you a release on your own recognizance, so you won't have to post a bond. However, you will be under a non-hostile contact order. And just so we're clear, what that means is you can have contact with your mother and your grandfather. You can go over to your mother's home and help her with whatever you're helping her with. However, if you were to raise your voice, raise your hand, get out of line in any way, either one of the victims in this case, being your mom and your grandfather, can pick up the phone and call 911, and you will be returned to jail, and nobody's going to ask, hey, what's your side of this, okay? Because you're under the jurisdiction of the court. You're not entitled to due process. All they have to do is make an allegation. They could even be wrong, and it wouldn't matter. You'd come back to jail with no questions asked because you're under the jurisdiction of the court. Do you understand that?
Yes, Your Honor. Thank you.
All right. Point the PD. Release from ROR over the state's objection. His release is under the condition they have non-hostile contact with either victim. There was no drugs or alcohol in this, right?
No, Your Honor.
Okay, all right, so I'm not going to impose further restrictions. All right, sir, good luck to you. Stay in touch with your lawyer about your case, okay? All right. Thank you, folks. He'll be released later today.
I have to go to Orange, or I have to go.
He's going to be down at the jail. Yeah.
Yeah. So that case where the mother came, did you do a one-time return? Because she said his file was there. I don't think you did that.
No, I said he could return one time to law enforcement to retrieve his vehicle.
Okay.
I did say that.
Okay.
All right, Skipper, is this Mr. Skipper? Yes, sir. All right. All right, Mr. Skipper.
Yeah, do you have a case number for this case, Your Honor?
I do. It's 2022 CF 7007AO. I did review the affidavit, and I'm going to stay the bonds as they are on the arrest affidavit. And for the record, that means on count 1, he has a bond of $2,500. On count 2 is no bond. Count 3 is $2,500. Count 4 is $1,000. Count 5 is $1,000. Count 6 is $1,000. Oh, and the last one, no, I'm sorry. I am going to grant him a bond of $100.
And Your Honor, I believe.
No. Here's my notes. Count 7 is a $500 bond. No contact. Maintain separate residence. Do we have a victim? No. I'm sorry. I am granting him a $500 bond on count 7. It's DV battery, 500, no contact, maintain separate residence. And on count 8, he's got a $100 bond. I will stay that.
Your Honor?
Yeah.
I believe there's a witness to this case.
Where?
Maybe the victim, Shontavious Williams.
I asked if there's any victims. Nobody responded.
They sent her to 7C.
Tavia.
That's where we are. We're in 7C. Is somebody here on the Skipper case? Nobody's here on the Skipper case.
Maybe 4C. She must have been sent to the wrong courtroom.
That's what it was. She don't know where to go.
Okay, well, what is it that he believes the witness was going to tell me?
Nah, she was gonna say like she was trying to put a restraining order instead of all of this. Like she didn't want to press charges.
All right. Well, I don't have anybody here on that case. I'm maintaining the bonds as they are on the arrest affidavit with the difference that count 7. I'll grant him the 5. Sir, can I just get this into the record? I'll grant him the $500 bond on count 7. Maintain separate residence, no contact. Everything else, I'm staying.
So I got a new bond, I got a bond. So I got to stay.
Good luck to you.
That's a call. Oh,
maybe that's what he was talking about. I wonder.
So do you think they're gonna wait for her to wander to courtroom 7? They're not gonna do that. You're not, but I'm saying you're not that important. What they gonna wait? Now if she show back up, yeah.
Do we have Mr. Spencer?
Sir, Mr. Johnson, sir, can I speak for a second, sir?
I wouldn't advise it. You have a lawyer.
Yeah.
All right, Mr. Spencer.
Yes, Your Honor.
Case number 2022 CF 6998AO. What case is it?
Crystal Lee Johnson.
Crystal Lee Johnson?
We haven't got that. Okay, thank you.
Oh, I see it. Robinson. Did we do Robinson yet?
Haven't got to that yet.
We haven't got to that.
Okay. All right, well, hang on. I got Mr. Spencer here, right? And Mr. Spencer's case is 2022 CF 6998AO. He's got one count of false imprisonment, domestic violence. The other one's battery, DV. I'm going to grant him $3,000 bond on count 1, 500. Well, nah, I'll do 100 on count 2. And no contact, maintain separate residence, may return one time with law enforcement, escort to retrieve his personal belongings, appoint the public defender. Good luck to you.
Thank you, sir. Thank you.
Chanada.
Morning,
All right, Mr. Chanada. All right, Mr. Brantz is probably going to want to be heard on this.
He is entitled to bond, Your Honor.
He has what?
He is entitled to bond, if that was what you were alluding to.
Well, yeah, but we're going to get back to the argument about my discretion here. And my understanding is he was under a no contact order, and not only did he contact the alleged victim, he did it from jail. I'm assuming knowing full well he was being recorded. Okay, somehow I got behind on this. Why do I not have a second page indicating that he was, because he wasn't out yet, right? He hadn't posted bond on the, he was under.
Add-on charge, Your Honor. He's here on other cases, but this is an add-on today. So
Right, but one of the other cases
the other case
was
here.
2022 CF 651780.
Correct. He was already seen on that. And
Okay, but he was ordered to have no contact with the victim in this case, correct?
Correct.
And in violation of that pretrial release order, even though he was still in jail,
Yes.
he calls her from jail
And he gets the contempt.
and starts telling her she's got to drop the case or he's going to kill himself or herself. I don't know. So he's clearly shown that he cannot follow the orders of the court. And he did it with rapidity. So is the 2022 CF 6517AO case has that been addressed, the fact that he violated that? Did they revoke his release?
No, he was already here on that case. They gave him bonds, but he's here on the violation of probation as well, at a no bond status.
Wait, violation of probation?
Yeah, he's also, but we're not here to address that, Your Honor. He was.
No, yeah, I have the contempt of court.
Right, that's all we're here to see. But he's also here. He was already IA'd on the aggravated battery, the battery.
And they gave him a bond on that?
Yes, let me pull that up again, Your Honor. He was.
Who did that?
But see, he was, let me just, give me one moment.
Looking.
Because he was booked in on June 7th for that case. He was IA'd, I believe, on, give me one moment, the 8th. Yeah, he was IA'd on the 7th, Your Honor, and he was given a bond of, let me pull that up. Okay, so for the aggravated battery, his bond was 3,500. For the aggravated assault, for the battery was 500 with conditions of no contact, do not return to the scene of offense, do not possess any weapons, may return one time, and surrender weapons and firearms within 24 hours. Those were the conditions of his release.
Was he released on that or not?
No, because he's still here, because he has a VOP as well. So he never was released, Your Honor.
State, you want to be heard as to bond? Mr. Brantz, I am sure is going to tell me he's entitled to bond.
Your Honor, he is entitled to.
Well, I mean, yes, he is entitled to bond under the Constitution of Florida and the United States and law. However, you know, we get back to the discretion argument.
Your Honor, based on the flagrancy of it, that he did contact the.
From jail.
From the jail, while also being present for a violation of probation, I don't understand what conditions the court would be able to place that would keep the victim safe.
Well, he clearly has no regard for the orders of the court. You already have no contact. No problem. All right, Judge. Can I use the phone, please? I gotta make a call.
Your Honor, may defense be heard?
Mr. Brantz, you want to be heard?
Yes, Your Honor. I know it might be a losing argument, but Mr. Tanada is entitled to a bond on the current charge. If the court is using its discretion to hold him no bond, I would have you consider that he is already here on a VOP at no bond. In the out on bond cases, the court can revoke it in their discretion, which would hold him here on those charges. But as you mentioned, under the Constitution, Florida statutes and the rules of criminal procedure, he is entitled to bond on this charge.
Don't forget the U.S. Constitution.
Yes, under the due process
You said
clause.
Florida, right?
Florida Constitution and the due process clause of the U.S. Constitution. That's correct.
All right. Which number is that one?
That's the 14th Amendment, Your Honor.
Very good. I think he's right. All right. I'll grant him a bond of $10,000 in this case. No contact whatsoever with the victim. No contact means no contact, Mr. Tanada. That means you can't call her from jail, if that wasn't clear before. I'm also going to revoke, can I revoke in 2022 CF 651780 since he was found to be in violation of that order?
No, this is just the add-on.
Oh, because it's not in front of me?
I don't.
You violated it, and nobody.
Oh, that's a good question.
All right, I'll leave it alone then. I don't want to make it difficult. $10,000 bond on this one. No contact. Maintain separate residence. Point the PD. Unbelievable. Good luck to you.
Thank you, sir.
Don't thank me. Barber.
Good morning, Your Honor.
2021 MM 5810AO. All right, Barber. Oh, the judge gave you a $2,500 bond on this failure to appear, so I'm going to leave it at $2,500.
Yes, sir.
Would you like to? Just Miss Bradley we did, I think. Would you like to?
Yeah.
All right. Benauna?
Yes, sir.
All right. Do we have a victim on Benauna? No. All right. All right, Ms. Benauna, you do qualify for pretrial release I'm going to grant your release under that. This is 2022 MM 407680. I will order that you maintain separate residence. My understanding from the affidavit is that that was already happening. So no contact with the victim, maintain separate residence. Because you're already living elsewhere, is there any reason that you need to return to the victim's house?
Just to get the mail.
To get her mail, Your Honor, so one-time return, I believe it would be appropriate.
All right, you may return one time with the escort of law enforcement and retrieve personal belongings to the extent you need to. All right, good luck to you.
No contact.
Yeah, no contact, maintain separate residence, may return one time with law enforcement.
What's the bottom line?
This is PTR.
Oh.
All right, Crystal Lee Johnson, and we do have somebody here for that. Sir, can you raise your right hand? You swear or affirm everything you say today should be the truth, the whole truth, and nothing but the truth, so help you God?
Sir.
All right, you can put your hand down. What's your name for the record, sir?
Edward Burke.
Who?
Edward Burke.
All right, and how are you related to the defendant?
She's the soon-to-be mother of my child.
Okay, are you in a relationship?
Yes.
Are you married? Do you live together?
Yes.
All right, and are you here today to tell me that you wish to have contact with Ms. Johnson, or you do not wish to have contact?
I wish that you do not put in place a no contact order. She needs to see an OBGYN.
She can do that under a no contact order.
I would request if you can release her on ROR so I wouldn't have to spend the $100 to get her out of jail today.
State you want to be heard. So basically, just for the bottom line, sir, you're asking that she be released ROR and that she be allowed to have non-hostile contact with you and return to the residence?
Yes, sir. Please, Your Honor.
Ms. Garrett, it says she didn't qualify.
Yeah, we weren't able to verify any community ties. We could qualify Ms. Johnson for pretrial release. We just need to verify residential information. We had 2 different addresses, so we weren't too sure. She has no priors.
She formerly resided at 154 Shadow Trail, but she's been living at my residence for about 4 months.
And what is your residence, Ms.?
It's 3202 Kew Gardens Lane, Orlando, Florida.
Okay. All right, Judge.
All right, is that good enough, or does
good,
she
yes.
need further screening?
No, she's good, Your Honor.
All right, Ms. Johnson, because your significant other here has provided the information that PTR was lacking, my understanding is that you can be released on PTR, so I will grant that. You don't have.
Would she be placed on like a pretrial diversion program?
No. This doesn't address the underlying case. That's for another day. This is simply getting her out.
Yes, sir.
Okay. So I'm going to release you on PTR. You don't have to post a bond. You have to follow their rules. You are to be permitted to have non-hostile contact with the victim in this case. Okay. And just so we're clear, if you were to become hostile, either verbally or physically or in any way whatsoever, and law enforcement were to be called, you would be returned to jail with no questions asked because you're under the jurisdiction of the court. So nobody's going to ask your side of it this time, okay? All right. Good luck to you.
Excuse me, Your Honor, could you just ask the defendant, is she planning on residing with the victim at all? Is she planning on?
That was my understanding. So,
she is.
Ms. Johnson, you intend to return to, sorry, what was your name, sir?
Edward Burke.
Mr. Burke's residence?
That's the plan, yes.
Okay. All right, Judge. Thank you.
All right. Good luck to you.
Thank you.
Jared Muller?
Muller.
It'll be today.
All right, this is Mr. Muller?
Yes, sir, Your Honor.
All right, so your case number is 2022 MM257AA. Domestic violence battery, I'm going to grant you a $500 bond. Order that you have no contact with the victim. Maintain a separate residence. You may return one time under the escort of law enforcement to retrieve any personal belongings. You are also to have no alcohol or illegal drugs while
Your Honor, we did qualify Mr. Mueller. The face sheet that we have, we weren't able to.
He does?
His print, yeah, we updated the information, so he does, Judge.
All right, well, scratch that,
Okay,
except for the
thank you.
conditions. You do qualify for PTR, so I'll grant you pretrial release. That means you don't have to post a bond. You just have to, you have to stay under their jurisdiction, okay, their supervision.
I do
The
not-
other thing,
I do
the
not
other
live
thing,
with my wife. I live with.
well, that's
my mom.
fine. Then
Okay.
it won't be a problem for you to comply with the separate residence requirement. So no
Thank you.
contact, separate residence, and I guess tell me you don't live there, then there's no reason that you need to return.
Thank you.
All right. I'll take that as a yes.
Yes.
Good luck to you.
Yes, sir.
All right, Naboa?
Yes, sir.
All right, I don't see anybody in the courtroom for Naboa.
We did qualify Mr. Naboa for pretrial release, Your Honor.
All right, I see that. Mr. Naboa, do you live with your mother?
No, sir.
No?
No.
Was that a no?
No, sir.
No, Your Honor.
Okay. So, sir, you qualify for release on pretrial release. I'm going to release you under that program. You do not have to post a bond, but you have to stay under their supervision and follow their rules. You also are going to be ordered to have no contact with the victim. In this case, your mother. You must maintain a separate residence. And since you don't live with her, there's no reason for you to return to retrieve personal belongings, so I'm not going to order that. Good luck to you.
Thank you.
Robinson?
Yes, sir.
All right. Robinson, this is case number 2022 MM 4082AO. Ma'am, are you the alleged victim in this case?
Yes.
Okay, before I swear you in and you state things on the record, I do see that you've invoked your rights under Marcy's law.
No, I don't know, because, I'm not that familiar with the court and everything, so what is that?
Well, so what it means is you have a right to keep any information about you confidential. However, if you wish to state something on the record today, I have to put you under oath, and you will be stating things on the record, for instance, like your name.
Yes.
Which is one of the things that you're permitted to keep confidential under that law.
I'm okay with,
Well, I just want to make sure you're aware.
yes, thank you.
Okay, and so you wish to proceed today? All right, can you raise your right hand? Do you swear or affirm everything you say today should be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right. All right, and so, normally, can I even ask her to state her name under a Marcy's law? All right, will you state your name for the record?
My name is Murdis Robinson.
All right, you're the alleged victim in this case?
Yes.
Yes?
Uh-huh.
Okay, and how are you related to the defendant?
I am his wife. I've been his wife for 35 years.
All right, are you here today to tell me that you wish to have contact with your husband or that you do not wish to have contact?
I wish to have contact with my husband. And because my husband suffers from dementia,
Okay.
and he has problems with his eyes and he cannot see clearly, I have to drive him around.
Well,
I want to talk about
hang on,
what happened.
can I ask you a couple questions?
Yes.
Because, and I understand that you want to tell me about what happened.
Uh-huh.
Today's not really the day for that. The only thing that I'm trying to narrow down or get a handle on is under what conditions of release I should grant. And so I can appreciate what you're telling me, that there's cognitive disabilities, maybe some physical handicaps that are contributing to the allegation of what happened. But considering that those conditions still exist and will exist if I release him. Are you not in fear of your husband, given his condition, that he may become violent again?
No, I'm not in fear of that, and he's not a violent person.
Okay, well, the allegation was that he was violent at one time.
And I would have to explain that more, you know.
Well, okay, but
He's
so
not a violent person.
That's all right.
And I'm not afraid of him.
You're under oath and you're standing here before me today and telling me that you do not fear
No,
violence from this person.
no, not at all.
All right. If I were to release him, it would be under a non-hostile contact order, which means he can come home.
Mhm.
But it also means, since he's under that order, if he were to act out in any way, verbally, physically, it doesn't matter, and you were to call 911 because the situation was getting out of hand, the deputies would respond, or law enforcement would respond and remove him from the home and bring him back to jail. And nobody would ask his side of the story because he's under the jurisdiction of the court while he's on release. Are you willing to tell me that if this were to happen, that you are comfortable making that phone call?
Absolutely.
Okay. Did you make the phone call in this case?
Well, yes, I did make a phone call because,
okay. That's
I would
okay.
have
You
to
don't have to
explain
explain it.
it. Okay.
No, you don't, but you, by that,
Yes, I
I
did.
understand that,
Mm-hmm.
okay, you were willing to do it this time, and so I'm going to trust that you're willing to do again if it's, and you know, the problem is if he is suffering from dementia,
Mm-hmm.
and he does have some physical handicaps, which, you know, somewhat prohibit his perception of things going on around him, you may not be able to handle the result of that on your own, right?
Yes, I can.
Well, okay. I don't mean that as an insult at all. I simply mean that.
Thank you for that. But I can because I'm retired and he's retired, and everything, you know, I monitor everything that he does. What happened, you know, with he was accusing me, and from my research, I'm supposed to ignore it. I did not ignore it, you know, when he was accusing me, and I did not ignore it. And by me not ignoring it, it came into an argument.
All right, well, it sounds a little bit like you're blaming yourself, which I don't agree with. That's okay. Okay? He does qualify for pretrial release, yes?
Yes, Your Honor.
All right. So with the testimony that you've given me today, I am going to release him on the pretrial release program. That means he doesn't have to post a bond. He will be required to stay in touch with their office and follow whatever rules they require of him.
Thank you.
I'm also going to order that while he's released, he is to have non-hostile contact with you. That means he can come home, he can be with you, whatever, but in the event that he were to become aggressive verbally, physically, it doesn't matter, in any way whatsoever, and you were to pick up the phone and call law enforcement, then, as I said earlier, he would be brought back to jail and nobody's going to ask any questions, okay? They're just going to come and take him.
Mhm.
And the reason for that is because he's under the jurisdiction of the court.
Thank you.
Okay, so you do have that safeguard. I hope that you don't need to use it, but I also hope that in the event you do, that you will.
And I do appreciate it, and I will.
Okay. All right. Well, he'll be processed out later today. Good luck to you. And the other things that you want to talk about the case, you can talk to the state attorney's office about those things because the prosecution of the case doesn't happen today. That's later.
Where do I pick him up at?
Down at the jail at the BRC Booking and Release Center.
So what jail is that? 33rd?
33rd.
Okay. All right.
Okay.
Thank you very much.
All right. Good luck to you, ma'am.
Yes.
Yes.
All right. Next on my docket is Sneed. Is this Mr. Sneed?
Yes.
Yes, Your Honor.
All right. Do we, okay, we don't have any other victims here, so I'm just going to assume that we have no other. Mr. Sneed, I'm going to grant you a $500 bond on this battery case. I'm going to order that you have no contact whatsoever with the victim. You must maintain separate residence. Do you live together at this time?
Yeah, we moved down from Georgia together, and I gave up my job when I moved with her, and I'm away from all family, and I have like no social income.
So are you telling me I shouldn't grant a bond? All right, I'm going to grant the bond, $500 bond. You already have no contact. You're going to have to maintain a separate residence. That means you cannot return to the home, okay? You may return one time with law enforcement escort to retrieve any personal belongings that you need, but you are going to have to find somewhere else to live. If you need to modify that condition, sir, I'm also appointing the public defender to represent you today. I would talk to your lawyer about filing a motion to change that if you need to. All right, good luck to you. Tata.
Sir.
All right, Mr. Tata. This is a stalking charge. Came in with no bond. I will grant you a bond of $500. You're to have no contact with the victim, the alleged victim, and I don't believe that it didn't appear that you resided together. So, but I'm just going to order that you maintain a separate residence. And since you don't live together, there's no reason to grant a one-time return. Is that correct? You don't need to go back to get anything. You don't live together.
No.
All right, so no contact, maintain separate residence, $500 bond. Good luck to you.
Thank you.
Ms. LaCrosse.
Yes, sir.
Okay. Oh, this is an out-of-county warrant. All right, you have a $2,000 bond on this warrant out of Polk County.
Yes,
I will
sir.
stay that bond. I'll stay that bond. You can post it, or you can wait for them to come pick you up. Oh, has she got 2 cases?
Just one.
Oh, okay. Okay, I'm gonna stay your bond at 2,000.
Okay, so I just have to get someone to post the bond? Yes. Thank you.
All right, Mr. Allah? Allah?
Yeah. How you doing today, sir?
Sir, you're here on a violation of probation. There's no bond on that. You'll have to seek release from the judge on your case. I'm going to stay it at no bond. I will appoint the public defender for the purposes of the violation.
Like today? Out of curiosity.
You should be curious.
Yes.
All right. Good luck to you. Good luck to you.
Okay, that's the case. All right. Thank you, sir.
Mr. Black, sir, you're here on a violation of probation. It's a 0 bond. I'm leaving it at 0 bond. You'll have to seek release from the judge on your case. Good luck to you. Kelly. Jail.
Hello.
Oh. Are you still pushing? He said stop pushing.
I'm not touching anything.
Oh, I was like, what? You still pushing?
Good morning, Your Honor. This is Laura Royo, State Certified Interpreter and Police Warrant.
All right. Thank you, Laura. We have one, two, I don't know, a few cases. So our first one is Ms. Gonzalez Rivera, 2022 CF 7001AO. And think I had this one, didn't I? Okay. Ms. Gonzalez-Rivera, you have bonds in your case as follows, and I will pause here, Laura.
Señora González Rivera, en su caso dado, las fianzas serán de la siguiente manera.
On counts 1 and count 6 of your charges, you do not have a bond, and I'm not going to grant you one. Those are punishable by life, and therefore you're not entitled to a bond.
En el primer cargo y el sexto cargo no se le ha concedido fianza y no lo haré porque acarrean pena máxima de cadena perpetua y por lo tanto no tiene derecho a uno.
On the remaining counts, you have the following bonds. On count 2, $2,000, count 3, $10,000, count 4, $30,000, and count 5, $30,000.
Y en los cargos restantes las fianzas serán en el segundo 2.000, en el tercero 10.000, en el cuarto 30.000 y en el quinto 30.000.
I am going to leave those bonds at those levels.
Se mantendrán las fianzas en esas cifras.
And I am appointing the public defender to assist you in this case.
Y se le designará defensor público para que le ayude en la causa.
Good luck to you.
Buena suerte a usted.
Your Honor, I would ask for no return and no contact with any co-defendants.
Su señoría, solicito que esté prohibida regresar al lugar de los hechos y prohibido ningún tipo de contacto con los coacusados. Serán ambos.
Okay, agreed. No contact with any co-defendants. Return, wasn't this a car?
It was a hotel, Your Honor.
Oh, that's right, it was a hotel. All right, so no return to the hotel and no contact with any co-defendant.
Entonces, estará usted prohibido tener ningún tipo de contacto con los coacusados y prohibido regresar al hotel.
All right, good luck to you.
Buena suerte.
The next case is Robes Serentes, 2022 CF 6987 AO.
Do you want to talk to your lawyer?
Okay, this is one of the ones. Oh no, I did get to this. I remember this one. Hang on. Oh, yep. All right. I did review this one. Sir, you have bonds in this case, which is 2022 CF 6987 AO. On count 1, you have a bond of 1,000. Count 2 of 100. I will leave the bonds at those amounts and appoint the public defender. Good luck to you.
Bien, señor, ya estudié el caso y se fijará la fianza en el primer cargo en 1.000, en el segundo en 100. Esas cifras se mantendrán y se le designan defensor público. Buena suerte a usted.
The next case is Kevin Rios Roman, 2022 CF 6994 AO and 2022 CF 7000 AO or 7000 AO. In case number 22 CF 7000 AO, sir, you have on count 1 and count 4, you have no bond. They are punishable by life, and you're not entitled to a bond, so I am not granting you one.
Muy bien, en el caso 22 CF700, con respecto al primero y cuarto cargo, no se le concede fianza. Ustedes, estos delitos acarrean cadena perpetua, por lo tanto no tiene derecho a ello y no le concederé uno.
On counts 2 and 3, you have bonds of 10,000 and 30,000 respectively. I will leave those bonds at those amounts.
En el segundo y en el tercer cargo tendrá fianza de 10.000 y 30.000 respectivamente y se mantendrán las cifras en esas cantidades.
In case number 2022 CF 6994AO, you have, go ahead.
No, it's all right. Go ahead, Your Honor.
You have the following bonds. On counts 1 through 3, you have a $2,000 bond. On counts 4 and 5, you have a $1,000 bond.
Y en el caso 22 CF6994, con respecto al primero hasta el tercer cargo, las fianzas serán 2,000 y con respecto al cuarto y el quinto cargo, la fianza será 1,000 para cada uno.
I'm going to leave the bonds at those amounts. I am appointing the public defender in both of these cases. In the former case, you would have no contact whatsoever with any of the co-defendants and no return to the scene.
Entonces se mantendrán las fianzas en estas cifras. En ambos casos se le designará defensor público. Con respecto al primero, usted está prohibido tener ningún tipo de contacto con los coacusados y prohibido regresar al lugar de los hechos.
Your Honor, I apologize. Can I also add no weapons, no firearms?
Su señoría, me disculpo, pero ¿se puede por favor agregar también prohibido armas o armas de fuego?
Also, you are to possess no weapons or firearms. If you have any in possession, you must surrender. Thank you. Surrender them within 24 hours of law enforcement.
Muy bien, entonces usted está prohibido ningún tipo de arma de fuego o arma alguna. Si las tiene, tendrá que entregárselos a las autoridades dentro de un plazo de 24 horas.
Good luck to you.
Buena suerte.
All right. Next case is Rodriguez-Reyes, case number 2022 CF 6977AO. Sir, pursuant to the warrant in this case, you have a bond of $7,500. I will leave it at that amount. If you post the bond, you are to possess no drugs without a prescription, no weapons, no firearms.
Bien, señor, en el caso 22 de F6977, conforme a la orden de arresto, se fijó la fianza en $7,500, la cual la cifra se mantendrá en esa. Y si usted logra depositar la fianza, estará prohibido ningún tipo de drogas o fármacos, al menos que hayan sido recetados, y prohibido la tenencia de armas.
Good luck to you.
Buena suerte a usted.
All right. The next case is Mr. Sonatal, 2022 CF 6997AO.
He bonded, Your Honor.
Oh. Okay. So is this Vargas Rodriguez?
Yes, sir.
All right. So this is case number 2022 CF 6995AO. Okay, hang on. This is one that I. All right. Sir, you have bonds in this case in the following amounts. On count 1, it's $5,000.
Las fianzas en la presente causa serán de la siguiente manera. El primer cargo, 5,000.
On count 2, 3, and 4, you have a bond of $1,000, and on counts 5 and 6, it's $500.
En el segundo y el cuarto cargo, la fianza será 1,000 y en el quinto y el sexto, 500.
I'm going to stay the bonds at those amounts. I am appointing the public defender to assist you in this case. Good luck to you.
Se mantendrán las fianzas en esas cifras y se le designará
Oh,
defensor
he's
público
PTR.
para representarle. Buena suerte a usted.
Refer to the court.
Well, yeah, actually, I didn't realize, he does qualify for pretrial release.
Parece ser que reúno los suficientes requisitos para salir bajo libertad provisional.
Your Honor, these are some fairly serious charges.
Yes, they are.
A co-defendant to the other, at least 2 to 3 co-defendants who are trafficking with firearms.
Oh, is this the same case?
Yes, Your Honor.
Su señoría, estas acusaciones son bastante graves. Tenemos aquí coacusados 2 o 3 con respecto a tráfico de armas de fuego.
And the PC in this case, as I read, was shake.
Me pareció que los indicios razonables de criminalidad en este caso dado eran una mierda.
I thought that trafficking case was built on something a little more substantial.
Pensé que iban a sustentar el caso de traficar en algo más.
I believe there is a sentence in here that says he was there to pick something up, Your Honor. So
Yeah,
he
but
may not have been involved in the trafficking per se.
Si no me equivoco, aquí indicaba que él pasó por ahí porque tenía que recoger algo. No creo que en sí estaba participando en el tráfico.
Yeah, I'm not sure how they would know that until they encountered them.
No sé cómo podrían saber eso hasta que se encontraran con ellos.
Does he have any criminal history?
¿Acaso tienen él antecedentes penales? No, su señoría no los tiene.
All right. Sir, you do qualify for pretrial release. The state is asking me not to give you that option due to the severity of the charges and the proximity to co-defendants with more serious charges.
Señor, usted sí cualifica para la libertad provisional, pero la Fiscalía me está solicitando que no se le conceda eso debido a la gravedad de la acusación y la proximidad que tuvo usted a los coacusados.
What that means is that even though you're not facing at this point the trafficking charges, the state believes you may be involved.
Lo cual quiere decir que aunque en este momento dado usted no está enfrentando acusaciones de tráfico, la Fiscalía sí piensa que usted estaba participando en ello.
And it is a valid point, however.
Lo cual es un punto bien válido, sin embargo.
I will give you the option to be released on the pretrial release program if you choose.
Si usted escoge hacerlo, le voy a dar la opción de poder salir bajo libertad provisional.
If you elect that option, you don't have to post a bond, but you do have to follow their rules and you will be supervised by them.
Si usted escoge tomar esa alternativa, no tendrá que depositar fianza alguna, pero sí le tocará seguir las normas que ellos tienen y estará bajo supervisión.
If you do elect to be released under the pretrial release program, I'm going to add that you are to have no illegal drugs and alcohol, and you shall be tested randomly by urinalysis to ensure that you don't ingest any.
Y si usted entonces decide aceptar la libertad provisional, agregaré como medida cautelar que usted estará prohibido consumir ningún tipo de droga alcohol ilegal y que tendrá que someterse a controles de orina de manera aleatoria para confirmar que no está ingiriendo nada.
All right.
Your Honor, we did qualify Mr. Vargas for straight pretrial release. Can we just ask him right here with the Spanish interpreter if he wishes to do the PTR?
Su señoría, él reúne requisitos para libertad provisional. Por lo tanto, podemos preguntarle ahora que tenemos aquí la intérprete si él está interesado en hacerlo.
All right. So, sir, what that means is pretrial release approved you for straight release without the condition of the urinalysis, the random testing that I am imposing.
Señor, eso lo que quiere decir es que ellos le han aceptado para poder hacer la libertad provisional sin la condición que yo indiqué de control de orinas, lo cual había agregado yo. I'm sorry, Your Honor, I didn't hear. I believe someone was speaking as I was interpreting.
I'm sorry.
I apologize. That was me, Laura. So, sir, I just need to know if you wish to, if you're going to accept release under the pretrial release program, knowing that you're going to be tested, you're going to be under urinalysis, random urinalysis.
Entonces, señor, necesito saber de usted si desea aceptar ser puesto en libertad bajo programa de libertad provisional, sabiendo que se tendrá que someter a controles de orina de manera aleatoria.
¿Cuál es la otra opción?
What is the other option?
That you post the monetary bonds.
Que deposite la fianza monetaria.
¿Completo o puedo usar un fiador?
Does it have to be the complete amount, or can I go through a bondsman?
No, you can go through a bondsman.
Puede, si desea, ir a través de un fiador.
Que sí.
Yes, then.
Puedo hacerlo con un fiador y puedo salir bajo libertad.
I can go through a bondsman and get out.
Okay.
So in other words, he doesn't want to quit using.
No, le estoy haciendo una pregunta. Yo estoy haciendo una pregunta.
No, that was a question. I was posing it as a question.
Yes, you can go through a bondsman.
Sí, puede ir a través de un fiador.
So no PTR?
Así que no quiere hacer la libertad provisional.
PTR wanted to
So, la libertad condicional que incluye, yo no tengo que pagar ahora mismo nada. Va a salir, pero...
¿Pero qué?
¿Me puede explicar la libertad condicional qué es lo que incluye?
So,
¿Puedo salir ahora
trial
mismo?
release means I don't have to post a bond. I can get out now. Could you please explain to me what it will entail?
It means that you have to call into, is it weekly?
No, John, he'll be supervised and there'll be drug tests done. So it could be, he'll have his first appointment, maybe this month, next month, and then it'll be up to the officer, but he'll be drug tested as well.
I'm sorry, Your Honor, I could
sorry.
not catch.
That's
everything.
okay. Laura, let me repeat it for his information and you can translate. Okay, if you choose the pretrial release, you don't have to post a bond. You will have to report to them. You will be supervised by that office. You will be subject to random urinalysis. Whenever they tell you to go take a test, you go take a test. If you come up dirty, that's a violation of your pretrial release and you go back to jail.
Si usted escoge hacer la libertad provisional, entonces no tendrá que depositar fianza alguna. Tendrá que ir a reportarse ante ellos. Usted será supervisado por la oficina de ellos y tendrá que someterse a controles de orina en cada momento que ellos se lo pidan. Y si esa orina le sale sucia, entonces le van a acusar de haber incumplido con su libertad provisional y se encontrará de regreso en la cárcel.
Y si escogería eso, ¿saldría hoy mismo?
But if I take that, would I be released today?
Yes.
Yes.
Sí.
Your Honor, can he... Y una pregunta, si ahora mismo ellos me hacen una prueba de dopaje y sale con marihuana, ¿puedo caer preso al momento o solo es después de esto?
If right now they ask me to do a drug test and it shows up that I consumed marijuana, would I be detained right now or what?
Your Honor, can he have 30 days before urinalysis?
Se le concedería 30 días antes de que se le pidiera una prueba de orina.
Ok, perfecto. Yo tomo eso.
I don't know how to do that, Judge.
I'm sorry, Your Honor. I didn't catch the complete answer. I have to ask him to repeat.
I haven't answered yet. I mean, probation, we usually give them a free pass on the first one.
Want to do after 30 days.
Your Honor, just to save time, the state has no objection to him starting after 30 days. And also with conditions, can it be the no return, no contact with the co-defendants, and no weapons or firearms?
All right, sir, I'm going to, don't worry, Laura, you can just translate this part of it.
Okay.
Sir, I'll give you the option to accept the PTR release. I will give you a 30-day window to clean out your system. You will also, no matter whether you post the bond or you do PTR, you are to possess no weapons, no firearms, no illegal drugs or alcohol, subject to random urinalysis, and no contact with any co-defendants.
Muy bien, señor. Si usted decide aceptar salir bajo el régimen de libertad provisional, se le concederá un tiempo de 30 días antes de que se le pediría una prueba. Ahora, aunque usted escoja el programa o decide depositar fianza en vez, sepa que usted tendría las condiciones de estar prohibido consumir ningún tipo de droga o alcohol, tendría que someterse a controles de orinas aleatorias, no podría tener ningún tipo de contacto con los coacusados y tampoco se le permitiría la tenencia de armas de fuego.
Habla español. Habla español. This case, huh? No. Okay. I got it. I get this one. I get the, how you call it, the
PTR.
PTR, the one who, el que yo se supone que yo tengo que orinar.
I'll take the PTR, the one that's asking for me to give a urine.
Okay, thank you. Good luck to you.
Está bien, gracias. Buena suerte a usted.
Okay, gracias. Sorry, I don't have to clean up.
Anyways.
Huh?
That's right.
I don't have no
All right, this is Mr. Suarez, 2006 CT 13962AO. Mr. Suarez, you failed to appear some time ago in this case, and the warrant that you were picked up on has a $2,500 bond that was given by the judge. I will leave it at that amount.
Your Honor.
Señor Suárez, usted faltó comparecer tiempo atrás en esta causa y el juez asignado ese caso, cuando fue detenido, impuso una fianza en $2,500 y yo mantendré esa cifra tal cual.
Your Honor, there was an offer to resolve withhold time served on the no valid. I had a chance to briefly speak with Mr. Suarez. I gave him a Spanish plea form to review before court. I believe he wishes to resolve no contest. He signed the plea form as well.
Su señoría, se extendió una oferta para resolver la causa de dictamen de culpabilidad en suspensión con condena cumplida con respecto a la acusación de conducir sin licencia válida. He discutido brevemente con el defendido y le he entregado el formulario declaratorio en español. Tengo entendido que él desea presentar declaración de no me opongo y además firmó el formulario.
Is that correct, Ms. Eugene?
Yes, Your Honor.
All right.
¿Es cierto eso, licenciada? Sí, su señoría.
Mr. Suarez, raise your right hand and face the camera.
Señor Suárez, por favor, levante la mano derecha y dirija su mirada a la cámara.
Do you swear or affirm everything you say today should be the truth, the whole truth, and nothing but the truth?
Jura y promete que todo lo que dirá aquí hoy día será la verdad, toda la verdad y nada más que la verdad.
Sí, todo el tiempo digo la verdad.
All right, you can put your hand down.
Ya puede bajar la mano.
Sir, I'm told by your attorney that you wish to accept an offer in this case to resolve it of time served. Was adjudication time served?
No, it's a withhold.
A withhold and time served. Is that correct?
Señor, tengo entendido que el abogado, que usted le ha dicho al abogado que desea aceptar esta oferta para recibir un dictamen de culpabilidad en suspensión con condena cumplida. ¿Es cierto eso?
Sí, porque tengo mi esposa que vive y está en la calle sola también.
I'm sorry.
Que yo no esperaba eso. Si yo tuviera un necesito, yo iba.
I'm sorry, Your Honor. I don't know if he is speaking to the court or to someone else, but I cannot hear him.
Yo estaba recién llegado.
He's not close enough to the microphone.
Sir, do you wish to accept a plea and resolve this case today? Yes or no?
Señor, hoy. ¿Desea usted presentar su declaración para resolver la causa hoy día, sí o no?
Sí, sí.
All right, I am told that you were given a Spanish plea form to read over. Did you read that over?
Se me ha dicho que a usted se le entregó un formulario declaratorio para leer. ¿Lo leyó usted?
Sí.
Yes.
Did you sign that form?
¿Y lo firmó usted?
Sí.
Yes.
Did you understand what you read?
¿Entendió lo que leyó?
Sí.
Yes.
Do you have any questions about what you read?
¿Alguna duda con respecto a lo que leyó?
No.
No.
So, because you read and understood that form, you do realize this is a criminal matter, and you have every right to go to trial if you choose and force the state to prove that you did what they say you did.
Ya que usted está enfrentando una acusación penal, usted ha entendido que tiene el derecho de proceder a juicio oral y exigirle a la fiscalía de tener que demostrar que usted cometió el ilícito que dicen ellos que cometió.
You understand that?
¿Eso lo entiende?
Sí.
Yes.
Okay.
Está bien.
And also, because you read the form, you understand that you have a right to be represented by a lawyer. And although Mr. Brandt, I'm sure, has spoken to you a little bit today, you would have the opportunity for a more meaningful conversation with a lawyer before you did anything, if you chose to do that. Do you understand that?
Y como leyó el formulario declaratorio, ha entendido que tiene el derecho a la asistencia letrada y según se me ha dicho, usted ha tenido la oportunidad, aunque sea un poco, de poder consultar con el licenciado, pero si desea, tendría el derecho a una conversación aún más detallada antes de hacerlo. ¿Usted entendió eso?
Do you understand that, sí or no?
¿Lo entendió sí o no? Yes.
Que yo salgo libertad. Sí, yo entendí.
Okay, and but you understand that because you want to enter this plea and resolve the case today, you're giving up the right to have the trial, and you're essentially waiving the right to speak with a lawyer, even though you spoke with Mr. Brandt, because the case will be over today, and you will not have an opportunity. We will not have a trial, and you don't have an opportunity to discuss the case at length with the lawyer. Do you understand you're waiving those rights?
Entonces, al aceptar usted este convenio declaratorio, estaría resolviendo la causa hoy día y, por lo tanto, estaría renunciando el derecho a que se celebre un juicio oral y el derecho de poder consultar con un abogado. Y eso sería porque se concluiría con la causa hoy mismo y no tendría la oportunidad de poder posteriormente hablar con un abogado. ¿Eso lo ha entendido usted?
Sí.
Yes.
Are you currently on probation for any other case?
Actualmente se encuentra usted cumpliendo régimen de libertad vigilada por algún otro caso penal?
No.
No.
Are you under the influence of drugs or alcohol today?
¿Hoy día se encuentra usted bajo los efectos de droga o alcohol?
No.
No.
Have you ever been diagnosed with a mental illness?
¿Alguna vez le han diagnosticado a usted de padecer de un trastorno mental?
Hasta ahora no. Lo que tengo problemas de audición que me van a cuando salga.
I'm sorry, I need him to get closer to the microphone. Acérquese más al micrófono.
Okay. Ahora no tengo de problemas mentales.
I don't suffer from any mental problems right now.
All right. Finally, sir, whether this applies to you or not, do you understand the idea that if you are not a U.S. citizen, entering a plea to a criminal charge would subject you to deportation? Do you understand that concept?
No sé si esto corresponde a usted o no, pero usted entiende la idea de que si usted no es ciudadano de los Estados Unidos y asienta en actas un convenio declaratorio aquí hoy día, quedaría sujeto a deportación. Dicho concepto, ¿lo entiende usted?
Sí, yo nací en Camden, New Jersey.
¿Cómo?
Yo nací aquí en el United States.
I was born here in the United States.
That's fine, sir. I just need to know if you understand the idea.
Está bien. No, simplemente le pregunto que si ha entendido esta idea.
Entendí.
Understood.
I will find that your plea is freely and voluntarily entered, that you've knowingly and willingly waived your right to a trial and waived your right to a lawyer.
Determino que usted presenta esta declaración por su libre albedrío, que usted manifiestamente y a sabiendas renuncia a su derecho a un abogado y a juicio oral.
And I'm told you're entering a plea of no contest, is that correct?
Y tengo entendido que usted estará presentando declaración de no me opongo, ¿cierto eso?
Cierto.
Correct.
I will accept the plea of no contest. I'll withhold adjudication. I'll order you to pay court costs of prosecution. Are we doing public defender lien, Mr. Brantz?
Aceptaré su declaración de no me opongo. Se impondrá dictamen de culpabilidad en suspensión más costas judiciales y costas de enjuiciamiento. Se están solicitando honorarios de defensor público, licenciado.
I assumed I was appointed, Your Honor, so I signed the form, so yes.
All right, I'll order you to pay court costs in the amount of $351. If I give you 3 months to pay that, is that enough time?
Le ordeno que pague $351 en costas judiciales. Si se le concediera 3 meses, ¿le será suficiente tiempo?
Is 3 months enough? Is 3 months enough time to pay $351?
3 meses le será suficiente tiempo para pagar $351.
¿350? Ah.
350?
Si salgo y trabajando donde estoy, sí, lo puedo pagar.
If I get out and if I can continue working as I have, yes, I can pay it.
All right, sir, do you have any questions about the plea you entered today?
Señor, ¿alguna pregunta con respecto al convenio que acaba de asentar en actas hoy día?
Pero salgo hoy mismo.
But will I get out today?
If there's nothing else holding you, yes.
Si no hay nada más que le tiene ahí retenido, entonces sí.
Gracias y Dios me lo bendiga.
Thank you.
No, it's just withholding court costs, that's all. I'm not doing credit terms.
Gracias.
He has already been here, Your Honor.
No, because I have to adjudicate him for the time served, though.
¿Dónde?
He's to be released. How
Si
about
lo
if I just
consigo
say
para este miércoles,
he's to be released
tengo que
after
traer.
this case?
What is the credit time served?
Right.
Yeah, but it's a withhold. I have to adjudicate him if I do time served, don't I?
No.
All right, I'll sentence him to 2 days, Orange County Jail, give him credit for the 2 days he's already done. He's released as to this case.
Muy bien, se le acepta se impone 2 días y se le acredita los 2 días cumplidos, será puesto en libertad con respecto a esta causa.
Sí, a mí sí, con permiso, ¿dónde el miércoles voy a hacer una memo para conseguirlo? Para traerlo, si Dios quiere, el miércoles. ¿Dónde lo traigo? ¿Aquí?
I'm sorry, I'm not catching every word he's saying. A ver, repite un poquito más alto, es que no le oigo muy bien.
Ok, si yo consigo, yo voy a llamar a mi madre, si lo consigo el miércoles, ¿dónde lo llevo el dinero?
If I am able to get all the money on Wednesday, where do I take the money to?
The clerk of court.
Ante la Secretaría del Juzgado.
Aquí mismo.
Downtown.
Oh, right here?
Okay, yo estoy ahí mismo.
All right, sir, if you wish to appeal that sentence, you have to do it in writing in 30 days. If you cannot afford an attorney for the appeal, one will be appointed for you. Good luck to you.
Señor, si le interesa apelar la sentencia, lo tendría que hacer por escrito y dentro de un plazo de 30 días. Y si no pudiese costearse un abogado para ello, se le podrá designar uno. Buena suerte a usted.
Laura. Thank you. I think that was our last one, right?
Yeah.
Thank you, Laura.
You're welcome, Your Honor.
All right, see you. Oh, that was a good one. Billy Robinson. Oh, no, Billy Madison is the movie.
You and I have a strange concept of what good one is.
Yeah, well, we got through it. All right, is this Mr. Robinson?
No, he refused, Your Honor.
Oh, he refused? Dang it.
We'll waive.
Oh, we're waiving. All right. He was here on an FTA. He's got a $2,000 bond on the capias or the warrant, so I'll leave it at that. Next would be Smith. Smith is on here on a failure to appear. The warrant set a bond of $500 or mental health pretrial release. Has he been screened?
Not yet. Let me see. Let me see if he has a mental health.
Sir, you have the, it's on the warrant. No, it's not a hold. The judge wrote it on the warrant. So you can post a bond of $500 and be released. You have the option, because the judge wrote it on the warrant, that you could be screened for mental health release. Would that mean he'd be held until he could go through the screening?
I think that may take a couple of days, Your Honor.
So that could take a couple of days. Do you want to, but if you're approved for mental health release, you wouldn't be posting a bond, you'd simply be under their supervision. But you have to be screened first, and it may take a couple days before that gets done, so you wouldn't be released. If you posted the bond, you'd be released today as long as nothing else holding you.
He's here on another case, Your Honor.
Oh, he's got another case?
Yes.
Oh, okay.
So, yeah.
So you wouldn't be going today anyway, so should I just give him the option and? All right, so sir, you're going to have the option on this case. You can either post the bond or you can be screened for mental health. All right, good luck to you. Pick your poison. Should be up to Peterson. Yes?
Yes, Your Honor.
All right. Mr. Peterson, you have a $1,000 bond. I'm going to leave it at $1,000. Point the public defender. Good luck to you. Tesner?
Yes, Your Honor.
Sir, you have a $1,000 bond on this charge. Oh, no, you qualify for PTR. All right. Sir, you qualify for pretrial release. I'm going to release you on that program. You don't have to post a bond. You just follow their rules. And I am appointing the public defender to represent you. Good luck to you. It's grand theft. I don't think, I think this was is this the one where it was the mom's car or aunt's car he was living in or something?
No, this is the one where he rented a vehicle a month ago and just didn't return it.
Didn't bother returning it.
And didn't pay for it either.
Yeah, no other conditions.
Allegedly.
All right, next one on my list is Campbell.
He refused, Your Honor.
All righty then.
We'll waive.
English?
No,
Yes, sir.
Campbell.
No, he said Campbell refused.
Yeah, he said he waived.
Yeah, but you still have to get.
Oh, he waived. I'm sorry. I forget. You guys forget I'm out of practice on this. Okay, he's got a $500 bond on the trespass. I'll leave it.
And no return?
No return to the scene of the crime. Alleged crime. All right, English?
Yes, sir.
English got a $500 bond on the trespass. I'll leave it at that.
We did have an offer to resolve, Your Honor.
Oh, great. Okay.
I spoke with Mr. English. Oh, by the way, I spoke with everybody as a friend of the court before your appointment. And I'm collecting the plea forms, giving them to my supervisor to give to Judge Caraballo, just for your knowledge.
Okay.
The offer for Mr. English was an adjudication, time served. Spoke with Mr. English, gave him a plea form to review, and he wishes to resolve no contest.
How many days?
Yes,
1 day.
1 day. All right, Mr. English, you wish to accept the state's offer, correct?
Yes, sir.
Can you raise your right hand? Do you swear or affirm everything you say today should be the truth, the whole truth, nothing but the truth?
Yes, sir.
All right. Sir, did Mr. Brantz give you a plea form to read over?
Yes, sir.
And did you read that and sign it?
Yes, sir.
Did you understand, I'm sorry, what you read?
Yes, sir.
Do you have any questions about what you read?
No, sir.
All right, so because you read and understood it, you realize it's a criminal charge, meaning you have every right to go to trial if you'd like, force the state to prove that you did what they say you did. But because you're going to enter a plea today, we're not going to have a trial. The case is over today, so you're giving up the right to a trial. You also have a right to be represented by a lawyer. And although Mr. Brantz has discussed this with you briefly, you would have more opportunity to sit and discuss the case in more detail with a lawyer. But once again, if you enter the plea, the case is over today. So essentially, you're waiving your right to a trial and a lawyer by entering this plea. Do you understand that?
Yes, sir.
Are you currently on probation for any other case?
No, sir.
Are you under the influence of drugs or alcohol today?
No, sir.
Have you ever been diagnosed with a mental illness?
No, sir.
And finally, sir, whether it applies to you or not, do you understand the idea that if you're not a U.S. citizen, entering a plea to a criminal charge will subject you to deportation? Do you understand that concept?
Yes, sir.
I think that was a yes. All right. And sir, I'm told you want to enter a plea of no contest. Is that correct?
Yes, sir.
I'll accept the plea of no contest. I'll sentence you to 1 day at the Orange County Jail. I'll give you credit for the 1 day you've already done. I'm adjudicate you guilty of the charge, order you to pay your court cost of prosecution, and PD lien of $323. If I give you 90 days or 3 months to pay that, is that enough time?
Yes, sir.
All right. Do you have any questions about the plea you entered?
No, sir.
If you wish to appeal that sentence, you have to do it in writing in 30 days. If you cannot afford an attorney for the appeal, one will be appointed for you. Good luck to you, sir.
The PD
Sir,
said he was waiving.
The PD said what?
He was just doing it in front of the court.
Oh, all right. So you don't want the PD lien?
I signed it now. I guess I'm appointed.
All right. For the rest of these.
For the remainder, right.
All right, then okay. That's fine. I don't care. Don't come out of my paycheck. All right. Is this Mr. Haynes?
Yes, sir.
Is Mr. Haynes accepting a plea today? Oh, wait, this is out of county. Oh, no, it's not. It's a trespass. Are we playing? Who's playing? Somebody tell me.
There is an offer, Your Honor. It's a withhold, sir.
Okay, is he taking it?
Yes, Your Honor. I spoke with him. I gave him a plea form to review. He does wish to resolve no contest today.
Said time served. How much you got? 1 day?
And no need to
Don't be
appoint us.
Do or don't?
Do not.
Yeah. 2 days. All right.
Does have a hold for.
Yeah, I see you from Seminole County. So, sir, you understand that if I accept your plea today and resolve this case will be concluded. However, you won't be released because you have a hold from Seminole County. They have to come get you, or you may have a bond on that. I don't know. But you won't be released until you address your Seminole County case. You do understand that, correct?
Yes. Could I ask a question, please?
Sure.
Do you know what the hold is on Seminole County?
Yes, for burglary of structure, and you was given an $8,000 bond.
Burglary of a structure, you do have an $8,000 bond you could post. Are we resolving this today or not?
Burglary?
No, don't watch.
Oh.
No,
Yes.
this case. Yes, all right. All right, so raise your right hand, please. Mr. Haynes? Do you swear or affirm everything you say today should be the truth, the whole truth, nothing but the truth?
Yes, sir.
Put your hand down. Mr. Haynes, I'm told you want to resolve the case by accepting the state's offer. You also, or actually, Mr. Brantz told me that he had given you a plea form to review. Did you read and sign that plea form?
Yes, sir.
Because you read and signed that plea form, did you understand it?
Yes, sir.
Do you have any questions about it?
No, sir.
Therefore, you do realize it's a criminal matter. You have every right to go to trial if you choose. You also have a right to be represented by a lawyer. We would appoint one for you if you couldn't afford your own. However, because you're going to enter a plea today, the case is over today, and we're not having a trial, and you don't have time to speak with the lawyer. So you're waiving both of those rights by entering this plea. Do you understand that?
Yes, sir.
Are you currently on probation for any other case?
No, sir.
Are you under the influence of drugs or alcohol today?
No, sir.
Have you ever been diagnosed with a mental illness?
Yes, sir.
Is that something that impairs your ability to understand what you're doing today?
No, sir. Not today,
So, all right, so you are thinking clearly, and this is what you want to do in this case. Is that a true statement?
Yes, sir.
All right. Finally, sir, whether it applies to you or not, do you understand the idea that if you're not a U.S. citizen and you enter a plea to a criminal charge, you're subjecting yourself to deportation? Do you understand that concept?
Yes, sir.
All right. I'll find that your plea is freely and voluntarily entered. You've knowingly and willingly waived your right to a trial, waived your right to a lawyer. I'm not sure, but I think Mr. Brantz told me you're entering a plea of no contest. Is that correct?
Yes, sir.
I'll accept the plea of no contest. I'll sentence you to 2 days in the Orange County Jail. I'll give you credit for the 2 days you've already done. I'll withhold adjudication. Order you to pay your court costs, your cost of prosecution, the amount of $273. Sir, I'm going to order that upon 60 days from whenever you're released, since you have a hold, that you must appear at the Orange County Clerk of Court to either pay the court costs or set up a payment plan. Is that enough time? 60 days after your release?
Yes, sir.
All right. Do you have any questions about the plea you entered?
No, sir.
If you wish to appeal that sentence, you have to do it in writing in 30 days. If you cannot afford an attorney for the appeal, one will be appointed for you. This will resolve this case, sir. You are released as to this case. Remind you that you have a hold from Seminole County. You'll have to deal with that. Good luck to you.
Thank you so much.
All right. Thomas Jordan.
Yes, sir.
All right. This. So I'm showing, oh no,
Sir.
that's Sarah. What happened to Henderson? Wait a minute. Henderson, Hogue, Hodge?
Henderson bonded, Your Honor, and Hodge bonded.
Fantastic. All right. All right, well, I'm assuming this one's not a plea, correct?
I believe so, Your Honor. I don't
I didn't
have any
hear.
offer. I have no offer from the state, Your Honor.
Well, yeah, because he's here on a violation of an injunction. He was out on bond for violation of an injunction. Sir, do you know what injunction means?
Yes, sir. Yes, sir.
I'm not sure that you do. You were hiding in the closet under clothes when deputies arrived. All right. And so, Mr. Brantz, are you going to argue that he's entitled to a bond for violation of a injunction against repeat violence when he was already out on bond for violation of an injunction against repeat violence? I don't know how many times we go back on this. Are you going to tell me it's not within my discretion to deny him bond?
That's right, Your Honor. As to the current charge, the state could either file a pretrial detention motion, but as they haven't done that, and it's not a punishable by life offense, he is entitled to bond on the current count. As to the out on bond case, the court may revoke in their discretion, and that would be the proper route, Your Honor.
Well, that's what you believe the proper route would be. Mr. Jordan, do you understand that you have an injunction prohibiting you from having contact with the alleged victim in this case?
Yes, sir.
And you had one previously, correct?
Well, they have, yes, sir.
Yes or no?
Yes, sir.
And you violated it twice now, correct?
Yes, sir.
Yeah, that's not fair. Well, he's not under oath.
True, Your Honor, but I would strike his answer. I think he was getting caught up in the.
I know, I get it. Why should I let you back out?
Sir,
You don't seem to understand that the court has told you, stay away from this person.
My misunderstanding, sir. I'm sorry. I have kids.
Misunderstand. What did you misunderstand? What do you not understand about don't talk to this person, don't have contact with this person, don't go to their house?
I live at that residence.
Well, no, you don't, as long as you have an injunction.
Yes, sir. Yes, sir.
You got to live somewhere else. I'm sure you've been told that.
Yes, sir.
And now you're telling me you live there, so it sounds like you're going to go right back there.
You about to stick your own self.
No, sir. I'm gonna go stay with my brother.
State, Mr. Brandt says I have no ability to deny bond on this.
State disagrees. You do. You have the discretion, Your Honor.
I know. We had this discussion earlier.
You did.
Mr. Brandt, I appreciate your position. I do. That is absolutely 100% your job to make that argument, sir. However, I disagree with counsel. I think it is within my discretion, because this guy has now allegedly violated a injunction against repeat violence twice. I find that if I grant him a bond on this new charge, I cannot ensure the safety of the alleged victim in this case, and therefore I'm not granting him a bond, and I am revoking his bond in case number 2022 MM3703AO, who I assume is the same victim. Am I right?
I did not check, Your Honor.
I assume it's the same victim. So, sir, I am appointing the Public Defender's Office to represent you in this case, and they may wish to appeal my ruling, and that's perfectly fine. In the meantime, you can seek release from the judge on the case if you wish, but because you don't seem to understand that you're not to have contact with this person, I'm not inclined to grant you a bond at this time.
Well, it was canceled. It was dismissed.
It was dismissed. Was the injunction dismissed?
I believe it expires next month.
Oh, it expires next month. Well, we can have a party then.
I put my objection on the record, just my argument from before and just my objection now.
Sure.
And I would.
Was that enough, or do you need more?
That's enough, Your Honor.
All right. Good luck to you, sir.
Well, you should call us.
For the court's information, the statute is 907.0417. That specifically deals with violating conditions of pretrial release or bond.
Thank you. All right. Is this Mr. Rowe?
Yes, Your Honor.
All right, Mr. Rowe, you're here on 2022 MM4078AO, resisting without violence. This, I believe, had a $500 bond.
Your Honor, there was an offer to resolve the resisting with the conviction time served, and I believe there was an offer to resolve on the out-of-bond case, failure to exhibit a driver's license. That's also a conviction time served. Spoke with Mr. Rowe before court, gave him a plea form to review. I believe he was vote no contest today.
All right.
That's fine. I would have us appointed in both cases if we weren't already appointed.
Well, I don't know if you were appointed in the other one, but I'll appoint you in both of these. All right, Mr. Rowe, do you want to resolve these cases today?
Yes.
You raise your right hand. You swear to affirm everything you say today should be the truth, the whole truth, nothing but the truth?
I affirm.
You affirm?
Yes, sir. Yes.
Okay, fair enough. I said swear or affirm, so that's fine. All right. My understanding is the agreement with the state is adjudication time served on both cases. How much has he got in on each? One on each?
Oh, well, I'm not too sure.
Well, the other case is 2022 CT 923 AW. Do you know how much time he's got in on the other case, Mr. Brantz?
I'm not sure of the exact number, no, Your Honor.
All right, do you want me to just say time served and leave it amorphous?
I feel that should be sufficient, yes.
All right. All right, so, Mr. Rowe, did Mr. Brantz give you plea forms to read over on these cases?
Yes.
And did you read and sign those plea forms?
Yes.
And you understood the plea forms?
Yes.
Because you read and understood the plea forms, you realize that in both of these cases, these are criminal matters, and that means you have every right to go to trial if you choose and force the state to prove that you did what they say you did. However, because you're going to enter a plea today, the cases, both of these cases are over today, and we're not going to have a trial because it's done today. Therefore, by entering this plea, you are giving up your right to have a trial in both cases. Do you understand you're waiving that right by entering this plea?
Yes.
All right, you've had some counsel from, so are you satisfied with the assistance he has given you today?
Yes.
Are you currently on probation for any other case?
No, sir.
Are you under the influence of drugs or alcohol today?
No, sir.
Have you ever been diagnosed with a mental illness?
Yes, sir.
Is it something that impairs your ability to understand what you're doing today?
No, sir.
So you are thinking clearly, and this is how you want to resolve the cases, correct?
Yes.
All right. And finally, sir, whether it applies to you or not, I don't care if it applies to you. I just need to know if you understand the idea that if you're not a U.S. citizen, entering a plea to a criminal charge would subject you to deportation. Do you understand that concept?
Yes.
All right. Find that your pleas are freely and voluntarily entered. You've knowingly and willingly waived your right to have a trial, and you've had assistance of counsel with whom you say you're satisfied. I assume you're entering pleas of no contest in these cases. Is that correct?
Yes.
All right. In case number 2022 MM407880, I will accept your plea of no contest. I'll adjudicate you guilty of resisting an officer without violence. I will sentence you to 1 day in the Orange County Jail. I'll give you credit for the 1 day you've already done. You are to be released. As to this case, I'll order you to pay your court costs, your cost of prosecution, your public defender lien. That all comes to $323. In case number 2022 CT 923AW, I will accept your plea of no contest. I will adjudicate you guilty of that charge.
14 days.
You got 14 in? I'll sentence you to 14 days. Orange County Jail, give you credit for the 14 days that you've already done. He is to be released as to both, in both cases. And in the other case, I will order you to pay your court costs, your public defender lien, and your cost of prosecution. That also comes to $323. Therefore, your total is $646 is your court cost, cost of prosecution, and PD lien for both cases. If I gave you 6 months to pay that amount, sir, is that enough time?
Yes. Yes.
All right, 6 months to pay. Do you have any questions about the pleas you entered today?
No.
If you wish to appeal either sentence, you have to do so in writing in 30 days. If you cannot afford an attorney for the appeal, one will be appointed for you.
Yes,
all right, this will conclude both cases. Good luck to you.
Okay.
All right, Mr. Sherrod.
You can. Yes, Mr. Sherrod, Your Honor.
All right, is this pleable?
No offer was given, Your Honor.
Oh, no offer was given. All right.
Your Honor,
all right.
Mr. Sherrod would like to plea to the bench to resolve this case today.
Do we do pleas to the bench at IU?
You can, Your Honor. However,
oh, this is the guy that went in Publix and walked out. 356. Well, actually, that's not so surprising nowadays.
Yes, warrant out of Pennsylvania for failure to appear. They only go an extradite on
Yeah, they're not going to extradite on it. Well, do you have a criminal history on him?
Yes. Only the face sheet, Your Honor, which.
Oh, that's right, I have that. 5 felonies, 8 misdemeanors, failure to appear once, unknown 20. So that's arrest?
Correct, Your Honor.
I take it Mr. Sherrod has a drug problem. Multi-state, delivery of cocaine. Oh, boy. Well, so, Ms. Eugene, Mr. Brand says he wants to plead to the bench. Does the state have any input on a suggested sentence if I were to take a plea today?
I would just point out that he is already out on bond for resisting an officer without violence, and formal charges actually have been filed in that case.
I wasn't going to revoke on that. I didn't find them sufficiently related.
Only to let you know that he has recent charges that are still pending, Your Honor.
Yeah.
He had a conviction last year, and as you mentioned, 5 felonies, 8 misdemeanors, with at least 1 conviction for a grand theft.
How much time he got in on this? 1 day?
Yes, 2 days, Your Honor.
2 days? 2 days. Well, I tell you what. All right.
Your Honor, I would have you consider that he's also ponying up. He's told me personally that he wants to resolve this. He wants to talk to the court about resolving this case. So I would have you consider that that ability to work with the justice commendable.
Okay, I'm not sure what that means, but I will state this for the record. I don't know. Is he transient?
He listed an address.
He has an address?
According to
We have an address.
Do you? Is he working?
Let's see.
How long unemployed? He's been unemployed for 8 months. You know, to be honest, the court, especially on these petty theft cases, I tend to look at the underlying facts. And when people are accused of taking food, I tend to be a little less, or a little more lenient, I think would be the way to put it. But sir, you need to understand that if you're in need of food or assistance, there's better ways to go about it. There are agencies that can assist you with this rather than just walking into Publix and walking out with food. I know that seems convenient, but there are agencies out there to assist you if you need that type of assistance.
Yes, sir.
So if you want to plea to the bench today, I'm willing to take a plea. I will adjudicate you, however, and just so you understand, and I'm guessing you do, but maybe not. Petty theft is an enhanceable offense. If you have 2 convictions for petty theft and you ever get picked up again, the state can charge it as a felony even if it's a misdemeanor amount. My guess is you already have a prior. Would I be correct in that?
There's a theft,
No, sir.
there is a previous theft offense.
That was
It's a
a real
grand theft.
He said no.
It's a grand theft.
Oh, it's a grand theft. Well, it still
Sir,
counts.
That's a real estate. It was a real estate thing doing a job that I was charged with.
Okay, well, it still would mean you have 2 convictions for theft, and the state can file, if you were to be picked up for a petty theft, they can file it as a felony. That's all I'm saying to you.
Yes, sir.
And if that changes your mind about entering a plea today, that's absolutely 100% fine. You have the option to talk to a lawyer about it. I mean, I would grant you a bond. I'm not going to revoke your release on the other one because I don't think they're sufficiently related unless it was resisting arrest from a petty theft, which I didn't look that deeply into it.
No,
But-
sir. I do not wish to do that. I actually have a job that I'm supposed to be starting tomorrow, and I just want to go ahead and get this thing over with and apologize.
All That's fine. I just want to make sure that you have all the information that you need. And the most important thing here is for you to understand that it will be a conviction. It sounds to me like this is strike 2. And if you get picked up again, even if it's a misdemeanor amount, even if it's food. The state can file it as a felony.
Yes, sir, I understand.
All right. Mr. Brantz, did he fill out a plea form?
I'll fill one out for him now. Is it a adjudication?
Mr. Sherrod, can you raise your right hand?
Yes, sir.
You swear or affirm everything you say today shall be the truth, the whole truth, and nothing but the truth?
Yes, sir, I do.
All right, Mr. Brantz, not Mr. Brantz, Mr. Sherrod, I see that you're signing a plea form right now. Apparently, I don't know that you had an opportunity to read it. Have you seen those plea forms before?
Yes, sir, I have.
Have you read them in the past?
Yes, sir.
You understand what they say?
Yes, sir, to the fullest.
All right, well, let's just make sure of a couple things. Because you've read these before and you know what's in there, you realize that this is a criminal matter, which means you have every right to go to trial if you choose and force the state to prove that you walked out of Publix with food without paying for it. But if you enter this plea today, you give up that right to a trial because the case will be over today and we're not having one. So by entering this plea, you're waiving your right to have a trial in this case. Do you understand that?
Yes, sir, I do.
All right, Mr. Brantz, are you asking to be appointed on this?
Yes, sir.
Are we friend of the court? All right. So Mr. Brantz has had an opportunity, limited as it may be, to speak to you about this case. Are you satisfied with the advice you've gotten from Mr. Brantz?
Yes, I am, sir.
All right. Sir, are you currently on probation for any other case?
No, sir, I'm not.
Are you under the influence of drugs or alcohol today?
No, sir, I'm not.
Have you ever been diagnosed with a mental illness?
No, sir.
And finally, sir, whether it applies to you or not, do you understand the idea that if you are not a U.S. citizen, entering a plea to a criminal charge will subject you to deportation?
By all means, sir, I do.
All right. Just a quick question, Ms. Garrett. Are they going to hold him until Pennsylvania says we're not coming?
No, it's only surrounding states, so he's.
Oh, so okay, that won't affect him? All right. All right, sir, I'm going to find that your plea is freely and voluntarily entered. You've knowingly and willingly waived your right to have a trial. You've had assistance of Mr. Brantz that you say you're satisfied with. I assume you're entering plea of no contest. Is that correct?
Yes, sir.
All right, I'll accept your plea of no contest. I'll adjudicate you guilty of the charge of petty theft. I'll order you to serve 2 days in Orange County Jail. I'll give you credit for the 2 days you've already done. Order you to pay your court costs, cost of prosecution, your public defender lien, all that comes to $323. If I gave you 3 months to pay it, is that enough time?
Actually, if you could give me 6, it'll be a little bit better. I'm just getting ready to start a new job and trying to get everything back.
6 months to pay your court costs, all right?
Fingerprints.
Yeah, and oh, shoot, I didn't order prints. Did I adjudicate some other people without prints?
No, just this one.
All right, sir, and the jail's going to have to take your fingerprints before you're released. He is to be released as to this case. I will take no action on the 2022 MM1959AO. Sir, do you have any questions? Are you pointed on the other case? I don't know.
What? No.
Clerk says no. He can seek appointment.
Yeah.
All right, sir, do you have any questions about the plea you entered today?
No, sir, I don't.
If you wish to appeal that sentence, you have to do it in writing in 30 days. If you can't afford an attorney for the appeal, one will be appointed for you. This will resolve the case. Good luck to you.
Thank you, sir.
All right.
Oh, they're appointed.
All right. Is this Ison?
Yes, sir.
Okay, Mr. Ison, you are here for failing to appear. You have a $1,000 bond that the judge gave you. I'll leave it at that. Good luck to you.
Okay.
Oh. All right. Arterberry. All right, Mr. Arterberry.
May I have a moment? Your Honor, may I have a moment to confer? I didn't speak with Mr. Arterberry, but he does have an offer. Thank you, Your Honor. This is Mr. Arterbury.
Yeah.
We would just request ROR. He's trying to get back to Tampa Bay, but he would still be within the state jurisdiction. And if we're appointed, he'll have our number to keep in touch so that he can show up for any court dates. It is a trespass under the state misdemeanors statute.
What are you asking?
An ROR, Your Honor.
He wants ROR, Your Honor. So he's not accepting the offer. He just wants ROR instead.
All right, hang on. Well, he had one failure to appear this February. Got 3 trespassings, and this is not just a trespassing. Apparently, he was harassing the customers. So it's a little bit more egregious than just your regular old run-of-the-mill trespassing. So I'm not inclined to grant him ROR. He has a $500 bond. I'll leave it at $500. I will appoint the public defender to assist him in this case. Good luck to you.
Okay.
Give us a call.
All right. Clardy? Are you Ms. Clardy?
Yes.
All right. What are we doing, Mr. Brantz?
There's a withhold time served offer for Ms. Clardy. I did speak with Ms. Clardy before court, gave her a plea form to review, and I believe she wishes to resolve no contest today. I spoke with her as a friend of the court. No need to appoint.
All right, so you're not being appointed.
That's right.
Okay. Ms. Clardy, can you raise your right hand? Do you swear or affirm everything you say today should be the truth, the whole truth, nothing but the truth?
Yes.
You put your hand down. Go ahead and sign that form. All right, this is 2022 MO 714AO. Since it's MO, is that the 223 plus 10, so 233?
Just 223.
Huh?
223.
Yeah, but there's 10.
I think that's when the information is found.
Oh, okay. So 223. All right. Ms. Clardy, my understanding from Mr. Brantz is that the offer is a withhold adjudication and time served, and you wish to accept that offer and resolve the case. Is that correct?
Yes.
All right. Did you read the plea form that you just signed?
Yes, I did.
Did you understand it?
Yes.
Do you have any questions about it?
No, sir.
Because you read and understood it, realize this is a criminal matter. It's considered a second-degree misdemeanor, and you have every right to go to trial if you choose and force the state that you did what they say you did. But because you're going to enter this plea today, we're not going to have a trial. The case will be over today. Therefore, you're waiving the right to a trial by entering this plea. Do you understand that?
Yes.
You also have a right to be represented by a lawyer. Mr. Brantz has been kind enough to talk to you about this today, but you would have the opportunity to have a more meaningful discussion with a lawyer if you chose to. But because you're going to enter this plea, so again, the case is over, and you're not going to have that opportunity. So you're giving up the right to a lawyer as well. Do you understand that?
Yes.
Are you currently on probation for any other case?
No.
Are you under the influence of drugs or alcohol today?
No.
Have you ever been diagnosed with a mental illness?
No.
And finally, whether it applies to you or not, do you understand the idea that if you're not a U.S. citizen, entering a plea to a criminal charge would subject you to deportation? Do you understand that concept?
Yes.
Okay,
Yes.
I'll find your plea is freely and voluntarily entered. You've knowingly and willingly waived your right to a trial, waived your right to a lawyer. I assume you're entering a plea of no contest. Is that correct?
Yes.
All right, I'll accept your plea of no contest. I'll withhold adjudication. I'll order you to serve 1 day?
2 days, Your Honor.
2 days in the Orange County Jail. I'll give you credit for the 2 days you've already done. You are to be released. As to this case, your court costs come to $223. I will reduce that to a civil judgment based on the assertion that you are currently transient and unemployed. Do you have any questions about the plea you entered today?
No.
If you wish to appeal that sentence, you have to do it in writing in 30 days. If you cannot afford an attorney for the appeal, one will be appointed for you. This will conclude the case. Good luck to you. All right, Mr. Flores.
God bless you, Your Honor.
All right. Mr. Brantz, what are we doing on Mr. Flores?
This is also a panhandling case, a withhold, credit time served. I spoke with Mr. Flores before court, went over the plea form with him. He reviewed that, wishes to resolve no contest, and he's already signed the plea form.
Okay. How many days again? 2 days.
No need to appoint.
All right, Mr. Flores, can you raise your right hand? Do you swear or affirm everything you say today should be the truth, the whole truth, and nothing but the truth?
I do.
You put your hand down. In case number 2022 MO 71588, I think that's AO. Okay. It's my understanding from Mr. Brantz that you wish to accept the offer of a withhold and credit time served in this case. Is that correct?
Yes, sir.
All right. I'm also told that you read and signed a plea form. Did you do that?
Yes, sir.
Did you understand the form you read?
Yes, sir, I did.
You have any questions about that form?
Sir.
Was that no?
No, sir. No, sir.
Okay. So because you read and understood the form, you realize that you have a right to go to trial if you choose. You also have a right to be represented by a lawyer, and we can provide one for you if you can't afford your own. But by entering this plea today, you're resolving the case today, and therefore, we're not having a trial. And although Mr. Brantz did discuss the case with you, you're giving up the right to have a further conversation with a lawyer about this case. So you're waiving your right to a trial and a lawyer by entering this plea today. Do you understand that?
Yes, sir, I do.
All right. Are you currently on probation for any other case?
No, sir.
Have you ever been diagnosed with a mental illness?
No, sir.
Are you under the influence of drugs or alcohol today?
No, sir.
Finally, sir, whether it applies to you or not, do you understand that if you're not a U.S. citizen, entering a plea to a criminal charge would subject you to deportation?
Yes, sir.
I'll find your pleas freely and voluntarily entered. You've knowingly and willingly waived your right to a trial, waived your right to a lawyer. I assume you're entering a plea of no contest. Is that correct? Are you pleading no contest?
Yes, sir. No contests.
I'll accept your plea of no contest, withhold adjudication, order you to serve 2 days in the Orange County Jail, give you credit for the 2 days you've done. He's to be released as to this case. It's an MO case, so your court costs come to $223. Based on the fact that you've been unemployed for more than a year, I will reduce that to a civil judgment. Do you have any questions about the plea you entered today?
No, sir.
If you wish to appeal that sentence, you have to do it in writing in 30 days. If you cannot afford an attorney for the appeal, one will be appointed for you. This will resolve the case, sir. Good luck to you. All right. Mr. Neal.
How you doing, sir?
I'm doing fine. Mr. Brantz, what are we doing?
We do have a time served offer on the panhandling, Your Honor. I spoke with Mr. Neal before court, went over the plea form. He wishes to resolve no contest today. I did have a question about the out-on-bond case, if the state has an offer on the out-on-bond case to resolve both.
Adjudication, credit time served.
State said adjudication, credit time served. Was it adjudication on this case as well?
Generally a withhold, Your Honor, but as he's doing both at the same time, withhold on one, adjudication on the other.
Okay. I just had, nobody said withhold adjudication on the current case.
For this one, it would be a withhold.
I heard.
716, it would be a withhold.
Yeah, okay.
What's the case number he's out of mine?
He's out on 2022 MO 615AO.
Okay.
And this one is 22 MO 716AW. One's AO, one's AW. All right. Mr. Neal, raise your right hand, sir. Do you swear affirm? Do you swear affirm everything you say today should be the truth, the whole truth, nothing but the truth?
Yes, sir.
All right, put your hand down. Mr. Neal, you have 2 cases of disorderly conduct. my understanding is that you wish to enter a plea and resolve both of these cases today. The first case, the 22MO716AW, it would be a withhold adjudication and credit for time served. So you have one or two in. Credit time served for 2 days. And in 2022MO615AO, it would be an adjudication of guilt and credit time served. Do we know how many days? Anybody know how many days he's got in on the
Let me calculate.
on the other one?
I think we do have to be appointed in this case, Your Honor, because we're appointed in the Adam Bond case.
Yep, point to PD.
It's 20. 4 days.
And 4 days in on the prior case. So, sir, is that what you wish to do?
Yes, sir.
All right. Did you read and sign a plea form just now?
Yes, sir. Yes, sir.
Did you understand that form you read?
Yes, sir.
Do you have any questions about it?
No, sir.
Because you read and understood it, you do realize you have every right to go to trial on these cases if you choose and force the state to prove that you did what they say you did. But because you're going to enter a plea today, we're not having a trial in either case. They're both going to be done today. So you're giving up your right to a trial by entering a plea in both cases. Do you understand that?
Yes, sir.
Mr. Brantz has discussed this case with you, and you were previously appointed public defender in the other case. Are you satisfied with the assistance that you've received from your attorneys?
Yes, sir. I really am.
All right. Are you currently on probation for any other case?
No, sir. No, I'm not.
Are you under the influence of drugs or alcohol today?
No, sir.
Have you ever been diagnosed with a mental illness?
No, sir.
And finally, sir, whether it applies to you or not, do you understand the idea that if you're not a U.S. citizen, entering a plea to a criminal charge would subject you to deportation?
Yes, sir. I understand that.
All right. I will find that your pleas in both cases are freely and voluntarily entered. You've knowingly and willingly waived your right to have a trial, and you've had assistance of counsel with whom you say you're satisfied. A case number 2022 MO 716AW. Sir, I assume you're entering pleas of no contest. Is that correct?
Yes, sir. Yes, sir.
All right. So in the first case, I'll accept your plea of no contest. I'll withhold adjudication, order you to serve 2 days in Orange County Jail, give you credit for the 2 days you've already done. You're to be released as to that case. Your court costs come to $223 in that case. In case number 2022 MO 615AO, I'll accept your plea of no contest. I'll adjudicate you guilty of that charge. I'll sentence you to serve 4 days in Orange County Jail, give you credit for the 4 days you've already done. You are to be released as to both of these cases. I do need the jail to take fingerprints in the 2022 MO 615AO before you leave. Also order you pay $223 in court costs on that case. Your total from both cases comes to $446. I'll note that you've been unemployed since as long as you can remember. I will therefore reduce the court costs in both cases to civil judgment. Do you have any questions about the case of the pleas you entered today, sir?
No, sir. I don't.
If you wish to appeal the sentences, either sentence, you must do it in writing in 30 days. If you cannot afford an attorney for the appeal, one will be appointed for you. This will resolve both cases to you, sir. Good luck to you.
Thank you very much. Thanks, sir.
Come on. Come on.
Take care.
How many more pleadables do we have? Not that I don't love them.
I think I only made offers in 2 other cases, Your Honor.
All right. Is this Brown?
Yes. Yes, Your Honor.
All right. What are we doing, Mr. Brown?
Just a moment, Your Honor, to confirm.
Was there an offer in this?
Withhold credit time served.
No. Like Mr. Brance is holding up paperwork like the coaches do. Of course, both wearing masks.
We're ready. Sorry.
Mr. Brant, we have,
Mr.
what are we
Brown,
doing?
Mr. Brown's here on a no valid. He's requesting RR at this time, and he's going to work with our office to resolve it down the road. I believe he has some paperwork coming that may validate his license, but he said he'll stay in contact with our office, show up for any court dates, but he does request ROR.
All right. Ms. Eugene?
No objection, Your
He
Honor.
has no failures to appear. He is going to work with the PD's office. I'm not really opposed to ROR on this.
No objection.
All right, sir, I'll release you ROR, appoint the public defender. Good luck to you. Stay in touch with your lawyer. Dega Spirits?
Yes, sir.
All right. Uh-oh. Ruh-roh. Were we driving on a DUI suspension? Oh, dear, dear, dear. Don't tell me that. Okey doke. Did you make an offer on this?
Did not.
Okay, good. All right, so sir, you have a $500 bond on this. I'm going to leave it at that amount. However, because you were driving on a DUI suspension and you were out on bond for that DUI in 2021 CT 748180, I am going to revoke your bond on that. Oh, it was diversion? Oh, wait a minute. Is this the one I read where he went in and told him he needed a duplicate license and neglected to tell him he had a DUI? Asked for registration. His license was suspended in November. He physically went to DMV and asked for, no. Revoked. I'm revoking your release in 2021 CT 748180. I don't know if you have the PD or a private lawyer on that, but you'll have to seek release. You don't get to try and scam the system and then. All right, stay his bond at 500 on the new Willis. Revoke his release in 2021 CT 748180. I will appoint the public defender to represent him in both cases.
Your Honor, I do apologize. I'm here on that case. I didn't realize you were.
Oh, you're here for Mr. Degaspiris?
Is it Joseph Degaspiris?
Joseph George Degaspiris.
Hi there, Joseph. I don't know if you can see me. I'm sorry. I didn't realize you were having initial appearance here today. I do have a word on that. We did represent him on the 2021 case, and I can speak to that. His license should have been not suspended anymore. There must be some sort of administrative error. I can speak on that, Your Honor. We'll clear it up. I don't know what happened, but...
Hold the phone.
Okay.
Hold the phone. Why wouldn't his license have been suspended any longer? It's an administrative suspension, not a court suspension, right?
Yes, Your Honor.
So he may have been eligible for a BPO, but actually wouldn't be because it was November. Oh, no, wait, November.
Your Honor, he already did the 6 months. That's what I'm trying to say. So he completed what he needed to complete with the DUI level 1 school, and he finished the 6-month administrative suspension. So he was eligible to then get his license again. So it should have been cleared. I don't know what happened. He was under the impression it was. It should have, and we checked with the Tallahassee too, and they said that it was ready to go. So.
D 221 48 79 7030. Counsel, I understand what you're saying. And he very well, the 6-month revocation was up likely by today. And he probably would have been able to get one had he not gone in on November 16th and gotten a replacement license. Okay? He wasn't eligible for a replacement license. What he did is illegal. You do understand that, right?
I was unaware of the replacement license, Your Honor. All I'm aware of is I spoke with Michael Pinella, who is the attorney of record on the underlying case. And
Well, hang on. Because you say you were unaware of it, but he was aware of it because when he was pulled over on the 16th of June, he told the cop he went in November and got a license and asked for a replacement license. And also, I don't know if he said this or the cop just assumed just that he did not bring the DUI citation to the DMV. He also stated he'd hired a lawyer for his case and he was currently going through a pretrial diversion. That's all well and good. But here's what's not good. At 2:43 p.m. on November 16th, and I'm going to assume that that was shortly after he got out of jail for the DUI arrest, he went down and fraudulently obtained a replacement license when he was not eligible for one. Right? He is not able to get a license after he's been arrested for DUI. The ticket is a license for 10 days. It's a full license. After that time, if he chooses not to ask for an administrative hearing, he is then potentially eligible for a business purposes only license if he can prove he's been enrolled in the DUI counterattack school. That's not what he did. He went down to the DMV after he got out of jail from being arrested for DUI and said, I need to replace my license. He didn't mention that he'd been arrested for DUI. That is illegal. He's not permitted to do that, and from the arrest affidavit on this case, it seems he was fully aware of what he did. And what I don't understand is he got into the DUI diversion program and nobody bothered to look at the status of his license, I guess because they don't suspend it in that program, right? But he's still under the administrative suspension no matter what. Am I incorrect?
Your Honor, maybe I'm a little confused. I know he got the BPO. Are you able to see that on your end? Because we assisted him with that. I guess that's where the confusion is coming from.
Come on up, counsel. Where's my, oh, I don't have a mouse. When was he arrested on the DUI? Somebody tell me. It was November, I know that. This is what I'm looking at. You see where this says replacement? In the, well, I don't know how much I can turn it on.
Was this, so when, was that immediate, like, the day after he was becoming DUI?
What day were you arrested for the DUI, sir?
November 12th.
The 12th. So it was several days after. Yeah.
Your Honor, I can't speak on that.
I can. I know exactly what he did. He went down and just conveniently left out the fact when he went to DMV that he'd had a DUI arrest and he was facing an administrative suspension and said, I need a replacement because I lost my license. And they said, okay, here's a replacement. He wasn't eligible for one. He knew what he was doing is wrong.
Yeah, Your Honor, I don't know about that. I just know that he called our office and we did help him with the BPO. So he never,
No, he's never gotten a BPO. Where do you see a BPO being issued? He doesn't have a BPO. He hasn't gotten it. It would show up here that he was received it.
Do you mind that he's on the round a little bit the records on behalf?
Sure, that's fine. But this is as of today, counsel. Just so you know, he ain't got a BPO. Unless David's wrong. Oh, it says suspended. No, actually, David says it was suspended November 12th, 2021. Had he gotten a BPO, it would show that he got a BPO, that he was issued a restricted license. He ain't been issued one. And call me cynical, but I'm pretty sure he knew exactly what he was doing. Also, his vehicle's registration is expired.
Your Honor, I'm looking at the files. I just wanted to double check. I do have the paperwork I filled out and submitted on his behalf to give him the BPO. I can confirm that.
Fantastic. He doesn't have it.
Well, because the 6 months already ended for his administrative suspension, so that's why he was eligible to get his actual license back.
I'm not saying he wasn't eligible. I'm saying he went down and falsely told DMV he lost his license and he needed a duplicate when he knew he wasn't eligible. He's been driving around on that license ever since, even while you represented him, even while you submitted the paperwork to get the BPO, which he has not received. They have not issued a BPO case. You may have all the paperwork, and that's fantastic, but they haven't issued one. The last time anything happened on his license was November 16th at 2:43 in the afternoon when he went down and lied and said he lost his license and I need a replacement. That's not what happened. His license was taken when he was arrested for DUI.
Your Honor, I'm not debating that that's, I know that says that. I'm just trying to wrap my head around it because this is something we have personal knowledge with getting him the BPO and it was approved. So I guess
He didn't get a BPO. You may have submitted all the paperwork in the world. Nobody ever issued a BPO. DMV didn't.
Your Honor, I have a question because what does admin SUS sustained mean?
It means the suspension was sustained. It's administrative suspension. They may have asked for a hearing and
Okay.
and it was, they asked it to be lifted and
Okay.
DMV said, no, we're not lifting it. We're sustaining it.
Oh, okay.
I'm just thinking, I'm thinking about that. That's what's confusing me because here is there something I can submit to you from the DMV to show that? Because I know that that's what that says. I'm not arguing otherwise. I clearly says that and I believe you with that. I just don't understand where the conflict is, I guess. Because
The conflict is, the conflict I have with the license he's carrying around is that he got it by lying. And then he drove around on this fraudulent license. So, that's what I'm upset about. If he had followed the rules, he could very well be walking around with a full license today because the suspension would have run. And he could have gotten a BPO long before this. He didn't do that. You may have done the paperwork. I'm sure you did. But he ain't got one. And I'll go to the other source I have, which is GHSMV license check. And it's likely going to show me that this is the only license they're aware of. Because they think he has a valid license, which he does, but it's fraudulent.
on your end, Your Honor, does it show that there was the paperwork submitted and that it was approved? Are you saying that he just never went to obtain it or that there was nothing filed regarding the BPO at all?
Hang on. ASPJ.
Just like that.
Okay, well, here you go. On DHSMV license check, driver's license D221-487-97003-0 is currently canceled, suspended, revoked, disqualified. This is a result of the following infractions shown on your driving record, and if you look down at what that is, it's driving with an unlawful balance, 0.08 or above, effective November 12th, 2021. It's still in effect. It's never been lifted.
Your Honor, can I show you an email from the DMV directly that we received?
If you wish.
I'm pulling it up right now. Your Honor, as I don't want to stand here. Would you rather recall this case? I just don't want to take up your time.
No, because look, on November 24th, 2021, the administrative suspension was sustained. Also on November 24th, 2021, they authorized a C restriction, which is a BPO. He never got one. And the reason he didn't get one is because he went in on the 16th and lied. Told him he lost his license and please give me a replacement, which they did because the person at the counter didn't know any better. He knows what he did. I know what he did. Despite the paperwork or any work that you've done on his behalf, he's never been issued a BPO. And my suspicion is if he went in and even though he would be eligible for one and tried to get one, they would then see that he went in and lied to them. And they would say no. But despite all that, he knew he was suspended. He knew he fraudulently got a license. He was out driving around on it and got caught. He even told the judge, he told the cop, I went in and got a replacement. And therefore, I'm typically very lenient on Willis cases. I really am. But not when you're driving around on a DUI suspension and you go in and fraudulently replace a license you're not entitled to. He knew exactly what he was doing.
Your Honor, I was under.
I'm not saying you were. Please don't misunderstand me. I'm not saying you knew he did all this. He knows he did it, and I know he did it. And I can plainly see that he did it. It's documented. It's not your fault, okay? But I'm not going to reward him for gaming the system. And in this case, I'll leave his bond at $500 on the new charge, but I am revoking his release on 2021 CT 7481AO, which I have stated several times now. You will have to seek release from the judge on that case.
Your Honor, if I may just show you the email real quick.
Sure. Please make it quick.
Not been addressed yet.
I know, Pam. Did he do it? No. Okay. Thank you for showing me the email. Revoke his release in 2021 for the 5th time. Revoke his release in 2021 CT 7481AO. Leave his bond at $500 on the other one.
Are you pointing the PD on the new case?
No, he's got counsel.
Okay.
Are you going to represent him on his new case too?
That's my understanding. It hasn't been officially confirmed, but that's.
Just he's going to hire his own attorney. Good luck to you, sir. This is taking too long, guys. We got to move this along. Adam, what case are you on?
Judge, I'm Ty McLean. He's
I realized it's taking long time to think, because I went to BRC.
Oh, you did? Well, they're having issues with the air down there.
I was already running late, so I was like, oh my God.
Wow. He's way down there. Okay. Well.
Who you got, Your Honor? We can bring him up.
Do you have Ty McLean up here?
Yes, sir, we can get him. Can we do this case and then we'll get it next?
Yeah, that's fine. I'll do Eason. They're gonna bring him up, Mr. Pollock. All right, Mr. Eason. Are these pleables? Is there an offer?
It's on probation, Your Honor.
There was no offer.
Okay, good. I'm gonna leave his bond at 500. All right, leave your bond at 500. Good luck to you, Mr. Eason. I'll point the PD. Do you want the PD appointed, Mr. Brands?
Yes, that's fine.
All right, point the PD. Is that Jones behind you? Ms. Jones?
Yes, sir.
All right, this says, all right, what happened to Herrera Antunez? Did they bond?
Yes, sir.
All right, Ms. Jones, you failed to appear. The judge issued a warrant with no bond. I'm leaving it at no bond. You'll have to seek release from the judge on your case. Good luck to you.
Thank you.
Your Honor, we have.
Is that McLean?
Yes, sir.
All right. All right, Mr. McLean, your attorney is here in the courtroom with me. Mr. Pollock, I know he's got a $500 bond on this, and I know you're going to ask me not to take any action. My concern, however, is that the three cases, the new case and the other two that he was out on bond on already, are all for failure to register. What is going on? Why is he having such difficulty registering?
Not a problem, Judge. I'll explain that. The first two cases, I was not representing him on those when he picked those charges up. There is a significant concern that he may not have been required to register.
He doesn't have a designation as a sexual offender or sexual predator?
He was adjudicated for sodomy, and in Florida, sodomy was not back in 1973, the courts have said that sodomy is not an offense that would qualify as a sexual offense. And so there is some concern about whether or not he...
Was the alleged victim an adult?
Yes.
Oh, okay.
And the conviction is from Oregon.
Okay. So this isn't... Okay. This isn't what you think of when you...
Exactly.
Okay.
And so when you see the third, my understanding is that it was his intention to start registering once he hired me. And I think there just may have been a mistake.
Well, he's out on bond on these 2021 cases, so he obviously was aware of them and posted bond.
Right, but I think something came up that prevented him to timely show up, and then the sheriff was, their radar is on him, so if he failed to timely show up, I think they immediately took action on that. Actually,
I guess, but my question is, this new case is 2022 CF 4061. Is that 1080 or just?
So there's
Well, anyway, but the point is, so he's got a 2022 case. He'd already been arrested twice in 2021. I don't know what dates, but he was clearly aware of his at least the Florida's potentially erroneous conclusion that he was supposed to register, and then he failed to again.
Right.
So, you know, it's like, okay, you're going to tell me, well, there was some confusion given the facts of the case, maybe it doesn't qualify, et cetera, and I can appreciate all that, except for the fact that he'd been arrested twice for failing to register. So wouldn't he be on notice by 2022 that he was supposed to be registering?
So, Judge, the second arrest stems from December 2021 failure to register. The first arrest was from November of 2021. The second arrest was due to a warrant that was issued, so it wasn't a direct arrest. Does the court understand what I'm saying? So the first arrest for the first case that the court has, that was a direct arrest.
All right, well, hang on. Let's see if we can save us all some time. Ms. Eugene.
Yes, Your Honor.
Does this guy have, so I've got 3 failures to report as a sex offender. There may be some questions surrounding the case. Does he have a history of this, or is this a new, what do we got? Do you have an NCIC and FCIC? Do you have anything you can tell me about this guy's history? Is he a serial failure to register offender?
Your Honor, to be completely honest, I would have the same information that you do with regard to the face sheet.
Well,
that's the easiest way to do it.
I know he has a warrant out of Oregon. I'm looking at the hot
failure
file
register?
for Oregon.
No, the warrant is for a completely different thing. We've already contacted Oregon. They do not want him.
No, there's no extradition. I see that. But it's failure to report again. Because I can appreciate what you're telling me about the facts of the case, and therefore, you know, do the sodomy laws, but until you get a judge to say.
And we agree. We completely agree with that.
Then he's got to report.
Absolutely, and that's what he's supposed to be doing. And the latest failure to report was it was not a monthly thing. Once he got out of jail on this, he was reporting monthly. And then he forgot to report for this last time that he got arrested for. When I'm looking at the underlying cases, the first one, there was one of them the state has filed on, the other one the state has not filed on. They haven't made a decision one way or the other.
Wow. All right, I tell you what. He's got, for some reason, he had a $5,000 bond on one of the 21 cases, and the other 21 was $1,000. Somehow, whatever judge signed this one gave him a $500 bond on the new one, which, according to the, oh wait, am I looking at the right thing?
Look at the wrong case.
Hold on. Yes. Wait a minute. Oh, he's got 0 bond. Okay, never mind. Sorry, I was looking at, I keep forgetting I pulled this from the back, so I was looking.
No problem, Judge.
So he's got 0 bond. I think he's entitled to a bond legally under the Constitution and law and all that stuff.
He does have local family here. It's not a failure to.
Well, here, my notes from reviewing the docket this morning was I intended to give him a bond of $2,500. I also said revoke on the other 2. However, since you are representing him and hopefully have some influence over your client, I'm probably willing to just take no action on the others, give him the $2,500 that I was initially going to. But sir, listen, until your attorney, I understand what your lawyer's saying, okay? But until you get a judge to say, yeah, that's not what we want, that's not the type of charge or type of facts that we think require registration. Until Mr. Pollock's able to get a judge to agree with him, you got to register. And my suspicion is you knew that because you have a failure to report from Oregon, so you're under reporting requirements out there, and you have 2 prior, and one was in a warrant and arrest. It's okay. I just get to say this stuff because I'm the judge. So I'm going to do what you want. But, sir, You have to register, just so we're clear. Until your lawyer comes and hands you a piece of paper that says, hey, I got a judge to say that what you did shouldn't be a reportable offense, you got to register. Just, okay, we're clear.
Okay.
Just so
Yes,
you're
sir.
not confused about whether you have to or don't have to, you have to.
Well, there's not much confusion now, obviously.
Well, I would have thought that after your first arrest, but who am I to say? All right, I'll give him $2,500 bond on the new one. I won't take any action on the other ones. Good luck to you, Mr. Pollock, if you can get.
Can I get a case number for this news case? Because I need a.
Yeah, it's, I just threw it away. It's, I have it, 2022 CF 4061. There's a 0 there. I don't know if that's meant to be an O for AO or if it's a 0.
AO.
Oh, okay. Thank you.
Okay.
I'll get pleadings filed.
All right.
Thank you, Judge.
All right. Good luck to you.
Have a good day.
Thank you, sir.
All right. See you. All right. We're slowing down. Is this Moses?
He filed it, Your Honor.
Oh, praise Moses. Nichols?
Yes, sir.
Okay. All right, Nichols, you're here on a Willis in 2022. That's not a case number.
It's no case number.
Oh, this is a warrant. Wow, a warrant for no valid? Seriously?
Willis.
Yeah, still.
See his history?
We issue warrants for this?
Mm-hmm.
How do we ID the driver? Never mind. You got $1,000 bond. I'll leave it on that. Oh boy. You got cannabis. You got a no motor vehicle registration. You got a no valid DL. You're out on bond and all that stuff, and here you are driving around again. Mr. Brantz, why should I not revoke his bond in these, at least in the no valid DL?
Your Honor, these are all nonviolent offenses. I believe if
Yeah, but that's not my concern. My concern is he knows he's not supposed to be driving and he still drives.
according to our client, he does have some defenses to not only out on bond cases, but also the allegations in the warrant. So I would have you take no actions on the out on bond. If you are inclined to take action, I would just revoke and double the bond amount.
All right, okay, that's fine. We need to move along, so I'll leave it at 1,000 and I won't take any action. Bye, good luck. Consider this your lucky day. Counsel, what case are you hearing? I'm not promising I'll take it out of order, but if you tell me.
Devin Smith.
Devin Smith?
You need the case number, Your Honor?
I gotta do it this way. What's Mr. Smith accused of?
Grand theft, third degree, and a no valid?
That's it?
Yes.
He's got a bond?
According to the affidavit, it's a $2,500 bond and $500.
That seems reasonable. What was his name again?
Devin.
Smith. Uh-oh. He's already out on other stuff. All right, well, let me put it aside because they have to bring him up. Are you Mr. Adams?
Yes. Yes,
Mr.
I am.
Adams, you failed to appear. For some reason, the judge was in a good mood, gave you a $2,500 bond on that. I will leave it at that amount. Good luck to you.
You should have called us. Huh? You should have called us.
Is that Alston?
Yes, sir.
Alston?
Yes, sir.
All right, sir, you got a $1,000 bond on count one, $250 on count two. I will leave those bonds at those amounts. I am appointing the public defender to assist you. Good luck to you.
Your Honor, I ask for no return?
I'm sorry?
I would ask for no return, Your Honor.
No return to the scene. Tell that guy he can't go back to the scene.
You say that bonds?
Yeah. Guys, if you get a chance to grab Devin Smith, so we can address that. He has a lawyer here. Is that Baker? All right. Mr. Baker, you have a $1,000 bond on count 1. This is in case number 2022 CF 7010AO. Count 1's 1,000, count 2's 150, count 3's 100. I'm going to leave your bonds at those amounts. I will appoint the PD to help you. Good luck to you. And this, is that Mr. Byrd?
Yes, sir.
All right, Mr. Byrd, you have a bond of $1,500 in this case. I will leave the bond at that amount. I will appoint a public defender to assist you in this case. Good luck to you.
Is it VOP as well, Your Honor?
VOP. I don't have a VOP.
Devin Smith?
No, this is
Oh,
Deshae
no, no.
Bird.
What?
Oh, Shane, Deshae Bird.
He has he has 2 cases.
2 cases.
Oh. Mr. Byrd?
Yes, sir.
Sorry, I skipped one. In 2020 CT 7646AO, you're also in on a violation of probation, and that carries a 0 bond, which I will leave at 0 bond. You'll have to seek release from that judge, the judge on that case. I'm also appointing the PD in that case for your assistance.
Thank you, sir.
All right. Thank you for catching that. Ms. Eugene. All right, and this is? That's Devin Smith. All right, counsel, we got your client up here. Let me get his face sheet. Here it is. All right. So today he's here on grand theft, 3rd degree motor vehicle, no valid DL. He came in with a $2,500 bond on the grand theft, which I'm inclined to leave it at that, and he had a $500 on the no valid. I'm inclined to leave that at that. Now, do you want to tell me why I should not revoke his release on burglary of a conveyance in 22 CF 1835AO? And wait, what's this? Possession of methamphetamine arraignment. What is that?
What? That's BTR.
What's that?
All right, I'm not going to worry about that. All right.
Good afternoon, Judge. Daryl Smith on behalf of Devin Smith. I was looking for that case number in the system. It was kind of confusing. I couldn't find another case number.
Which one? The burglary of a conveyance? It's 2022 CF 1835AO.
I tried to look it up. I didn't see it.
Well, that's the case number I got. And that's the sheet I have.
I just got this case maybe about 3 hours ago. I'm familiar with Mr. Smith because I represented him before, but
you're not related, are you?
No. I just didn't know he was out on bond for a 2022 offense, so I'm assuming.
Well, it's burglary of a conveyance, petty theft, and possession of methamphetamines. State, do you want to be heard on revocation of his bond in the 2022 CF 1835 case?
One moment, you
He was ROR'd, I'll note that for the record.
I just want to confirm what it
Why
is
was he
that
RO?
actually filed on, Your Honor.
Why was he ROR'd on a burglary?
Possibly because of what he was arrested on and what they actually filed on. But they actually filed on burg conveyance, petty theft, and possession of meth, Your Honor. Considering that his current charged allegation is a grand theft motor vehicle, he's alleged to have burgled another conveyance, I would ask for you to revoke, hold at no bond, or at best, double the out on bond, Your Honor.
Mr. Smith?
Your Honor, because I couldn't find it in the clerk of court, I wasn't able to see the details of it, but I would ask if Your Honor would take no action as to that ROR. If Your Honor wants to revoke the ROR and set a bond on that, I would ask Your Honor to do that instead.
Well, according to the face sheet, he's got at least 3 convictions for petty theft. He's got 17 felony convictions, 18 misdemeanor convictions, 4 failures to appear, although I will note the last one was back in 2011, so he's got 39 unknown arrest cases, and he's got at least one stint in DOC. It's impressive in one respect, but not probably the respect that. Yeah, and here we go with another grand theft involving a motor vehicle, and he was out. So you want me to revoke ROR, double it to double ROR?
No, Your Honor, I thought that he was out on bond. I apologize. If he is out on ROR, I would ask that you revoke the ROR and set a bond commensurate with his history.
All right.
If you won't, just revoke and hold him.
Mr. Smith, I appreciate what you're asking me to do. I will start, first of all, in the new case, which is 2022 CF 701680. He has a bond of $2,500. I will leave that at $2,500. But given his history and given the fact that we are dealing with a similar, if not the same, offense, we have a burglary, we have a conveyance, in 2022 CF 1835AO. I don't know why I have this note about possession of methamphetamine arraignment hearing. I'm not even dealing with that. I don't know what that is.
Your Honor, it's just
Yes,
letting
it's
you
set for
know
an
that
arraignment.
formal charges have been filed, and that's the next court date.
Mm-hmm.
Oh, okay. Oh, that's right. That was one of the counts, wasn't it?
Sure.
Okay. I mean, normally I would just revoke and tell your client to go seek release from the judge on that case. But since he does have counsel, and therefore I can assume that you're going to assist him in addressing these cases, I will revoke the ROR. I will grant him a bond, however, $2,500 on the 2022 CF 1835AO. So basically, he's got $2,500 on the new one. I'll give him $2,500 on the old one, revoke the ROR.
Three counts.
Three counts, yes.
Oh, it's so 2,500, 100, 100.
And then on the new case, does you address the no valid driver's license?
Oh, yeah, he had, what was it, 500 on that? I'll leave it at 5. Yeah, I'll leave it at 5. Yeah, I'll just stay the bonds on the new one. Revoke his ROR, grant him 2,500, 100, 100, and hope and pray that he doesn't offend while he's out. All right? All right, good luck to you, sir.
Evan, I'm trying to get you out, so I'll talk to you when you get out. Thanks, Judge.
All right. All right, Chenault. Oh, this is the guy from the Swan. It's a nice hotel. Sir, you have a in your case, 2022 CF 7012AO, you got $2,500 bond on count 1, $500 on count 2. I will leave the bonds at that amount. I will appoint the public defender to assist you in the case. Good luck to you.
No return.
No return to the Swan.
Your Honor?
Yeah.
You're asking for anyone available for emergency get one signed.
Yeah. Mr. Clark?
Yes, sir,
Mr.
Your Honor.
Clark?
Yes, sir.
All right. Mr. Clark, you're hearing on aggravated battery and a tampering with a witness in 2022 CF 6988AO. You have bonds of $3,500 on count 1 and $1,000 on count 2. I will stay the bonds at those amounts. I will appoint the public defender to represent you. If you are released, you are not to have any contact whatsoever with the victim or witnesses in this case. It's not DV, so I don't have to worry about residences.
No, it was his residence, I believe, Your Honor.
Okay, so just no contact. Okay.
Your Honor.
Yeah.
May we request a lower bond amount in your discretion? Mr. Clark's older sister, she's trying to bail him out. She doesn't have enough money to bail him out. If you would consider perhaps a $2,500 and a $100 bond on count 1 and 2.
Well, count 2 would then be $100 to a bondsman either way. either at 1,000 or 100. Now, I think I appreciate your request, but I'm going to leave them at what they're set at. All right, Mr. Clary.
Yes, Your Honor. Yes, Your Honor.
All right, Mr. Clary, you are not entitled to bond on count 1, the murder charge, and you have a bond of $5,000 on count 2, the arson. I will leave the bonds at those amounts. You're not entitled to bond on count 1, but I'll leave the $5,000. I will appoint the public defender to assist you in these cases. Good luck to you.
All right, thank you.
There's no return on the warrant. There's no return on the warrant.
Oh, sir, if you are ever to get out during the pendency of those cases, sir, if you are able to, at some point to be released on this, you are not to return to the scene.
Yes, of course, Your Honor, of course.
All right.
Thank you.
Okay, Mr. Donovan.
All
right, Mr. Donovan, you have a $1,000 bond on count 1, $150 on count 2. I will stay the bonds at those amounts. I will appoint, oh, wait, is there more? Wait, we have more. So the first one I addressed was 2022 CF 6989AO. Stay those bonds at 1,000 and 150. You also have, it's like a Willis. Yes, and that's 2022 CT 3334AO. You have a $500 bond. I will stay the bond on that at $500. And appoint the PD to assist you in these cases. Good luck to you.
Thank you.
Mr. Douglas.
He refused, Your Honor.
He refused.
We'll wait.
Oh, shoot. I get so excited when they refuse, I can just pitch it. All right, PD's waiving. It's a $1,000 bond and count on the only count. I will leave it at $1,000. Appoint the PD. Mr. Duleni. Okay, so I've got 2022 CF 6932AO, failure register, which came in at 0 bond, which I don't think that's right. He's entitled to a bond. I also have violation of conditional release in 2022 CF 2342AO. Am I addressing that or not? Because I don't have any paperwork on that.
Let's see, ticket. No, that was already addressed, Your Honor. This is an add-on,
Okay, so all I'm addressing is the 2022 CF 6332AO failure to register, right?
correct.
All right, I think he's entitled to a bond on that. I'll give him a $2,500 bond, and I'll appoint the public defender to assist him in that case. Look at that one. That was perfect. Oh, come on. You have to admit that was good. Mm-hmm. I know you're mad because I'm going slow.
Mr. Gillis, Your Honor. I mean, mental health, Your Honor.
Gillis?
Mental health.
Mental health.
Yes,
Are we
sir.
waiving?
Yes, Your Honor.
All right. In 2022 CF 5943AO, I will grant him a $2,500 bond in that. Appoint the public defender to assist him. Good luck. All right. Mr. Griffin.
Yes, sir.
All right, Mr. Griffin, you got 2021 CF 12900AO, 12730AO, 12948AO. Do I have to do all these?
We're only here for the cases in front of you.
The 12897.
Oh, well, that makes it easier.
Yeah, these are add-on.
All right, so 2021 CF 12897AO, I guess that's the only one I'm doing. It's a failure to appear. You have 0 bond on that per the judge who issued the warrant. Therefore, I will leave it at 0. You'll have to seek release from the judge on that case. I will appoint the PD.
It
Good luck
shows he
to
has
you.
a private attorney.
Oh, he has a private?
No, I do not, sir.
You what?
I do not. I fired him.
All right, well, then, he says he fired his private.
Oh, okay.
So I'll appoint the PD in the meantime. All right, Shauna Harris.
She refused, Your Honor.
Mr. Brantz, are we waiving on Harris? She refused.
Yeah, yes, Your Honor.
Okay, she's got $1,000 bonds on counts 1, 2, and 3, 500 on 4 and 5, and I will stay those bonds. That's in case number 2022 CF 6998AO. She also has in 2020 CF 10699AO, $500 bond and grand theft, $1,000 on count 2 and $250 on count 3. And I'll stay those bonds. Is that everything? I think that's everything. I will appoint the public defender. Donnie Matthews. All right, Mr. Matthews, you're here on a failure to appear in case number 2019 CF 141889AO. The judge who issued the bond set it at 0 bond and also indicated that that should not be disturbed, that you would have to seek modification from the judge on that case. Good luck to you. Leah Mims?
She bonded, Your Honor.
She bonded.
Oh, Mims bonded. Parkinson? Okay, I'm going to assume that's Parkinson.
Yes, Your Honor.
Sir, you have no bond pursuant to the warrant. The warrant also indicates that that is not to be modified by the IA judge, so I'm not going to modify it. Bond stays at 0. Good luck to you. Felix.
She refused, Your Honor.
Waiving.
Yes, Your Honor.
She's got a $1,000 bond. I'll leave it at 1,000. Point the PD.
Her bond's posted anyway. Her bond's.
It is?
Bond pending, yes.
Oh, I guess on the last one, she posted her bond. Wait, but she refused.
It says bond pending.
I don't know where it is. Okay, am I supposed to do something different then?
They should have that.
Okay.
It shows bond pending, Judge. That's.
All right, is this Quincy Smith?
Yes, Your Honor.
All right, Mr. Smith, you are here on 2022 CF 6933AO, petty theft with 2 prior convictions, $1,000 bond. I'm going to leave it at $1,000.
You got to mix up. I don't have no prior convictions of petty theft, and I don't have a petty theft.
Okay, well, sir, that's something you're going to have to take up with the judge on that case. It sounds like something you may want your attorney to file a motion on, okay? You're also, I don't know, 6933.
How about the bonds that I had?
All right, Mr. Smith. Mr. Smith.
Yes.
Mr. Smith. I want to make sure you're also aware, because pursuant to the warrant, it says, in addition to the $1,000 bond, you are to have no contact with the victim, no return to the scene, no weapons, firearms, or ammunition, meaning if you have any weapons or firearms, you have to surrender them to law enforcement within 24 hours of your release.
I don't know what you're talking
Can we get an address for the scene, Your Honor?
There's not one, it just says no return to scene on the warrant, and I don't have any I don't have the affidavit.
That's what I'm saying.
I could look it up if I wanted to,
It's not.
but I don't.
It's no affidavit because I didn't do it.
Sir, would you be shocked if I said you were the first person that ever said they didn't do it?
I'm just saying, you can take your time and check it out, but I know.
May I just have a moment, Your Honor?
No, I ain't got no fries and no petty theft, and I never had no petty theft.
Well, the bond came in with $1,000.
It don't matter,
I
but
mean,
I'm just.
the warrant came in with $1,000 bond. The judge who signed it put that amount on for whatever reason they did. I can't tell you, but I'm not disturbing it. I'm leaving it at 1,000. I'm pointing the PD. Good luck to you.
That was the same picture I had when I first came on.
Take it up with that judge. You didn't do it. All right, Holdson.
He refused, Your Honor.
We'll waive.
Waiving.
Yeah.
All right, Toltz. All right, in 2022 CF 701980, he's got a $1,000 bond on count 1. And in case number 2022 MM258AA, he's got a $500 bond on count 1. I'm going to leave those bonds at those amounts, appoint the PD. Good luck to Mr. Tolson. Mr. Vargas. Mr. Vargas, you're here on 2022 CF 386780. Violation of pretrial release. You have a 0 bond pursuant to the warrant signed by the judge. I will leave it at 0 bond. You will have to seek release from the judge on your case.
Your Honor, this is one of those instances where he is entitled to bond again. It's on this charge.
You violated pretrial release.
He would still be, it's not necessarily his bond hasn't been revoked from pretrial. It's just he has a charge of a violation of pretrial, which he would be entitled to bond on.
Okay.
Further, it was for a no valid driver's license, which I know may help in your discretion, but he still is entitled to a bond.
All right, Mr. Brantz, I appreciate that. I don't know if you can see from over here.
No, Your Honor, I cannot.
All right. Well, what I was holding up is an affidavit of violation of pretrial release. And judge, can't really read that, but it says, the Honorable Judge from Division 16, it is further ordered that the defendant's release status is hereby revoked. Bond is set at 0. That means the judge who signed this warrant set the bond at 0. If you want to take it up with that judge, you are free to do so. His bond stays at 0. Good luck to you. All right. Do we have anything else we need to do? Is that it? All right, then I guess we are in recess. Sorry we went long today, folks. Warrant? Oh, you have a warrant. Okay.
Yes, Your Honor.
Thanks, corrections.
Bye.
You're done. Appreciate it. All right.
And then you said you had one more request?
I have a private counsel with me as well.
Oh, they're going to have to wait.
Yes, sir.
All right, well, you're going to have to wait. I'm going to call the case. All right, Omar Abdelar. You guys already pulled out the paperwork you need? Okay. Appearance for defense.
Parker on behalf of Mr. Abdullah.
Thank you, Mr. Parker. Is your client approaching? Thank you. No, he needs to go on the other side. Good afternoon, sir. State your name and date of birth, please.
Omar Abdullah, 11/29/2001.
Thank you. Sir, you've been picked up as a result of murder while engaging in robbery, robbery with a firearm, and burglary to a structure or conveyance while armed. Court has reviewed the charging affidavit. Counsel, did you have a PC challenge? Because PC was already found in the arrest warrant.
We're just going has to leave it at that.
Okay. I do concur with the finding of PC based upon my review of the arrest warrant. There is no bond on any of these charges.
Yes, Your Honor.
All right, anything else?
No, Your Honor.
Okay, thank you. Oh, and he's to have no contact with any of the co-defendants. Thank you. You too. Mordlin Dulcine.
President approaching, Your Honor.
Good afternoon, sir. State your name and date of birth, please.
March 31st, 2001.
Thank you. Mr. Dulcine, you've been picked up as the result of an arrest warrant that was issued for murder in the first-degree felony, robbery with a firearm, and burglary of conveyance while armed. Probable cause was found when the warrant was issued. I have reviewed it and I concur with the finding. Sir, there is no bond on any of those charges, and you are not to associate with any of the co-defendants. Thank you.
Thank you, Your Honor.
I may or may not have already handled some of your cases. I just had another state attorney join us.
Yes, sir.
Hello, Cisco Unity connection message.
All right, we're going to go back to those, counsel. We'll start with the non-interpreter ones. Luis Ramirez Lamort.
Your Honor, I've been informed by corrections that he has refused to join us today.
All right, well, when you refuse to come to court, you usually get a warrant, but since he already has one, out of Polk County, there is zero bond on that for a domestic violence battery.
Yes, Your Honor.
Thank you. George Otero Marin.
President approaching, Your Honor.
Good afternoon, sir. State your name and date of birth, please. 420 or 520?
420.
Deputy, can you confirm this warrant? The warrant has 520.99 on it, not 420.
What's the name?
Jorge Otero Marin.
Yes, ma'am.
I'm letting the deputy know your name, sir. Pull it up in CCIS as well.
Our system shows 420.99.
Your system shows that for the warrant or for the charging affidavit?
I have to look at one, Judge.
I don't have the warrant.
Oh, you don't have the one?
No, I don't have the warrant. That's why I'm pulling it up in CCIS. Because the summary information that I have shows the date of birth as 520. State, do you happen to have a copy of this warrant?
I'm looking now, Your Honor.
I see the case, but I don't see the warrant in it.
Your Honor, I do not have a copy of the warrant.
Deputy, are you able to find out anything? It's not in CCIS. This warrant's out of Brevard.
The warrant has both birthdays.
Because there's multiple cases with the same name gentleman with 420, but
The one out of the bar. It's this one.
he uses both birthdays? Or they have him in the system as both birthdays? Huh, that's interesting. Perhaps they should fix that. All right, counsel, I've been able to see the warrant in the system, and it actually has both birthdays of 4/20/99 as well as 5/20/99. Someone's going to need to fix that on their end.
Yes, Your Honor.
But the warrant is out of Brevard County in 21 CF 49093. There is a $5,000 bond on that. Mr. Otero, if you have the ability to bond out, you're welcome to do so. If you don't, then they'll be notified that you're here and ready for pickup.
All right.
Thank you, sir. Have a good day.
How long did it take to pick me up?
It's up to them, sir. Thank you. Austin Owens.
President approaching, Your Honor.
Oh, that is the first time I have ever had that happen. Good afternoon, sir. State your name and date of birth, please.
Austin Owens, 11/05/1994.
Thank you. Mr. Owens, you've been picked up as a result of a warrant out of Seminole County for 212380 CFA. There is no bond on that, sir. They'll be notified that you're here and ready for pickup. Thank you. Janelis Raquel Alcantara Contreras.
President approaching, Your Honor.
Good afternoon, ma'am. State your name and date of birth, please.
Janelis Raquel Alcantara Contreras, 9/23/98.
Thank you. Ma'am, you've been picked up as a result of a warrant in 2020 CT 1948 for failure to appear for arraignment. There's a $2,000 bond on that, ma'am. Thank you. Jerry Ishmael Avila.
President approaching, Your Honor. This client has indicated he has hired private counsel.
Sir, you've hired private counsel?
Yes.
Do you wish to move forward without their appearance today?
Yes.
All right. You've been picked up as a result of a warrant in 2014 CT 1767 for a failure to appear for pretrial. There's a $1,000 bond on that, sir. Thank you. Pierre Calixte.
President approaching, Your Honor.
Good afternoon, sir. State your name and date of birth, please.
September 3rd, 1963.
Thank you. Sir, you've been picked up as a result of a failure to appear for arraignment in 22 CT 543. There's a $2,000 bond on that, sir. Thank you. John DePolis.
President and approaching, Your Honor.
John DePaulis, 31774.
Thank you. Sir, you've been picked up as a result of a warrant for violation of probation in case 2017 CF 1820. There's no bond on that, sir. Thank you. Jermaine Gordon.
President approaching, Your Honor. At this time, defense counsel would request a waiver of the reading of the charges.
Yes, sir. Good afternoon, sir. State your name and date of birth, please.
Good afternoon. Jermaine Gordon, July 978.
Mr. Gordon, has the attorney explained to you what the charges are? It's yes or no. Do you understand what you've been charged with?
Yes, Your Honor.
Okay.
If I may.
No, sir. Let me go through my spiel first. Okay? Thank you. You've been picked up as a result of an arrest warrant Probable cause was found in the warrant. The court has reviewed it. I do concur with the finding of probable cause. Bond is going to be set on count 1 in the amount of $5,000. Count 2, $150. Count 3, $150. Count 4, $150. Count 5, $1,000. Count 6, $150. Count 7, $150. Count 8, $150. You are not to have any access to the internet. You're not to have any contact with persons under the age of 18, and you are not to possess any weapons or firearms. Now, before you say anything, I'd like you to take the opportunity to speak with the attorney and make sure that it's something you would like to say, because everything you're saying can and will be used against you.
Just understand that you're like to speak to you.
May I have a moment, Your Honor?
Yes, sir.
Your Honor, against the advice of counsel, he wishes to make a statement.
All right. Record will be noted that it's against the advice of counsel. Go ahead, sir.
Good afternoon again, Your Honor. I was here last week, Your Honor, and I got released on Monday. I was supposed to go into the sheriff department to update all those information that you're speaking about, and an appointment was scheduled for the 23rd of this month. However, after the appointment schedule and the sheriff assured me that I can't be arrested while I have an appointment pending, 2 days after the 13th, they sent out a warrant, and the warrant was issued yesterday for my arrest. I can't go into the sheriff department without an appointment, which the appointment is already pending.
And sir, all of that information could possibly be used as a defense. But for today's purposes, it's a finding of probable cause based upon the arrest warrant that was issued. Thank you.
Total, what's that total?
Your Honor, I recorded the bonds. I'd be happy to provide him the total.
Thank you, counsel. Gary McQuaig.
He's present and approaching, Your Honor.
Thank you. Good afternoon, sir. State your name and date of birth, please.
Gary McQuaid, January 9, 1958.
Thank you. Mr. McQuaig, you've been picked up as a result of a warrant in 21 CF 2929 for failure to appear for your pretrial. There's no bond on that, sir. Thank you.
Well, there's no legal charge on that either. That's an illegal charge you got to have.
All right, have a seat, sir. Thank you. Daryl Blaze.
He's present and approaching, Your Honor.
Good afternoon, sir. State your name and date of birth, please.
Daryl Blaze, 0425-2004.
Thank you. Mr. Blaze, you've been picked up as a result of an arrest warrant with charges of murder, first-degree felony, robbery with a firearm, and burglary of conveyance with an armed weapon. Probable cause was found when the warrant was issued. I have reviewed the warrant. I concur with the finding of probable cause. There's no bond on any of the charges, and you're not to associate with your co-defendants. Thank you. Megan Lynn Romanowski.
She is present and approaching, Your Honor.
Good afternoon, ma'am. State your name and date of birth, please.
Megan Lynn Romanowski, 4889.
Ma'am, you've been picked up as a result of a warrant in 21 MM 2138 for failure to appear for jury trial. There's no bond on that, ma'am. Thank you. Drusilla Trent.
Present and approaching, Your Honor.
Hello, Your Honor.
Good afternoon. State your name and date of birth, please.
Priscilla Trent, February 24th, 1991.
Thank you. Ma'am, you've been picked up as a result of a warrant for violation of probation. There's no bond on that, ma'am. Thank you. Clevin Calvin.
Present and approaching, Your Honor. This client has also indicated he's hired private counsel.
He's actually approaching the podium. Madam Clerk, as a training thing, so when I was provided this warrant, it was all blacked out, which means all the information that I needed is redacted. So when you're printing them, you got to click on see original so that those blackouts aren't there. Okay. This is a training. That's all right. Parents for defense.
Shannon Sullivan.
Thank you. Good afternoon, sir. State your name and date of birth, please.
Cleveland Calvin, November the 22nd, 2000.
Thank you. Sir, you've been picked up as a result of discharging a firearm in public, 2 counts of battery, touch, or strike, and criminal mischief. Counsel, did you wish to be heard about probable cause or about bond?
Bond, Your Honor.
All right. Court has reviewed the charging affidavit. I do find that there's sufficient probable cause. It was an arrest warrant, and probable cause was found during that time as well. Sometimes my notes are not as good as I would like them to be. Counsel, you wish to be heard with regard to bond? You can proceed.
Yes, Your Honor. There are 2 victims in this case for battery, one being a domestic violent count, Ms. Karen Quinones. She has filed a declination of prosecution. The other individual has sent a declination that has yet been filed. That was sent within the last hour. Individual's last name is Redwood, maybe Carissa Redwood. So we just respectfully request that bond be placed in this case. I would also like to let Your Honor know that Judge Sanders recently did sign off on a motion to revoke bond on the violation of probation. So I understand that that is also pending and will not be addressed today.
Well, you have more information than I do. I did not have that information. It did have about the VOP, but I didn't have anything that it had already been revoked, so.
It was just signed off on probably within the last hour and a half.
Then I will not address that one. Even though, counsel, even though they filed declinations, it'll be up to the state to determine whether they're going to pursue charges or not. So the rulings will be based on the information I have today. If additional motions need to be filed, of course, you know what to do.
Understood.
All right, so I'm finding probable cause with regard to all 4 counts. Bond to be set on count 1 in the amount of $1,000, count 2 the amount of $1,000, count 3 the amount of $1,000, and count 4 the amount of $1,000. You're not to have any contact with Karen Quinones Garcia. No contact means no in-person contact, no third-party contact, no social media contact, no telephone contact, no contact whatsoever. Do you understand? Additionally, you're not to have any hostile contact with Carissa Redwood. Do you understand?
Yes, ma'am.
You're also not to possess any weapons or firearms. Anything further, counsel?
Nothing.
Thank you. Always a pleasure to see you.
As well. Have a good day.
You too. No, as counsel just stated, Judge Sanders already revoked that about an hour ago. So it's already set at 0. Carlston Charles.
President approaching, Your Honor.
Good afternoon, sir. State your name and date of birth, please.
Good afternoon, Your Honor. Carlston Charles, February 5th, 1999.
Thank you. Sir, you've been picked up as a result of burglary of a structure while armed, as well as improper exhibition of a gun or a dangerous weapon. Court has reviewed the charging affidavit. I do find that there's sufficient probable cause. There will be no bond as to count 1. Count 2, bond will be set in the amount of $500. If you are released, you are not to return to 46907 Dwarfs Lane. That is the Waffle House, and you're not to possess any weapons or firearms. Thank you.
We are ready to proceed, Your Honor.
Yes, sir. Renato Lopez Prieto.
Your Honor, I believe that maybe, yes, he has refused to go. He's in self-harm. I believe he's having a mental health crisis. He has not joined us today.
All right.
For a 24-hour reset.
In light of it being a mental health issue, the court will reset when he is available.
Yes, Your Honor. Thank you.
Daniel Roller.
President approaching, Your Honor.
Thank you.
Daniel Roller, 119-1986.
Thank you. Sir, you've been picked up as a result of driving while license suspended with knowledge as a 3rd conviction felony. The court has reviewed the charging affidavit. I do find that there's sufficient probable cause. Bond to be set in the amount of $2,500. You're not to drive unless you have a valid driver's license from the state of Florida. As for 22 CT 843, 22 CT 798, and 22 CF 732, court will not be taking any action. Thank you. Jose Santiago Rodriguez.
President approaching, Your Honor.
Good afternoon, sir. State your name and date of birth, please.
Jose Santiago, November 6, 1991.
Thank you. Mr. Santiago, you've been picked up as a result of battery, simple touch, or strike, domestic related. Court has reviewed the charging affidavit. I do find there is sufficient probable cause. Bond to be set in the amount of $1,500. You're not to return to 2125 Creekmont Lane. You can go back one time with the assistance of law enforcement to obtain your personal items only. You're to have no contact with Melanie Reyes. No contact means no in-person contact, no third-party contact, no social media contact, no telephone contact, no contact whatsoever. Do you understand?
Yes.
You're not to possess or consume any alcohol or drugs. You're not to possess any weapons or firearms. With regard to 2018 CT 3398 that you're out on probation for, court will be doing an on-view violation and setting your bond at 0. Thank you. Larissa Lambert.
Your Honor, I believe I've been informed correction that she is still detoxing. We'd ask for another 24-hour reset.
All right, it'll be a reset for when she's available.
Yes, Your Honor.
Lazaro Ramon Macias.
He is also still detoxing, Your Honor. Would you reset when he's available?
All right, that'll be reset when he's available.
Thank you, Your Honor.
And that's on both of his cases. Let's see if we can get an interpreter.
Good afternoon, Your Honor. This is Laura Royo, State Certified Interpreter and previously sworn.
Good afternoon, Ms. Aurora. This is Judge Arendis. I'm in 4 Echo in Osceola. We're handling initial appearances, so I'll be piping it through the courtroom. Our first case that we have for you is 22 CC 1965, Bravo Gaetan Santos. He's approaching. Good afternoon, sir. State your name and date of birth, please.
Buenas tardes, señor. Por favor, indique su nombre de nacimiento, por favor.
Counsel, we don't have any sound. Oh, there we go. Thank you.
062598.
And your name?
Su nombre.
Santos Guillermo Bravo Gaitán.
Santos Guillermo Bravo Gaitán.
Sir, you've been picked up as a result of operating a vehicle without a valid license.
Señor, a usted lo aprendieron por estar conduciendo un vehículo motor sin ser titular de licencia válida.
The court has reviewed the charging affidavit. I do find there's sufficient probable cause.
Este juzgado ha estudiado el informe acusatorio y determina que existe suficiente indicios de criminalidad.
Bond to be set in the amount of $500.
Se fijará la fianza en $500.
You're not to drive unless you have a valid Florida driver's license.
Estará usted prohibido conducir al menos que sea titular de una licencia válida de la Florida.
Thank you, sir.
Gracias, señor.
Next case is 22 CF 1763, Eric Lefrib Ortiz.
President approaching, Your Honor.
Thank you. Good afternoon, sir. State your name and date of birth, please.
Buenas tardes, señor. Por favor, indique su nombre de nacimiento y fecha, su nombre y fecha de nacimiento, por favor.
Eric Lefebvre 7/17/91.
Eric Lefebvre 7/17/91.
Sir, you've been picked up as a result of battery, touch, or strike.
Señor, usted fue detenido por un acto de agresión física al tocar o golpear,
as well as hindering with communication to law enforcement.
al igual de impedir la comunicación a un agente policial.
The court has reviewed the charging affidavit. I find there's sufficient probable cause.
Este juzgado ha estudiado el informe acusatorio y determina que existen indicios razonables de criminalidad.
You qualify for pretrial release with a bond.
Parece ser que usted reúne los requisitos para la libertad provisional con fianza.
Bond to be set on count 1 in the amount of $1,000.
Con respecto al primer cargo, se fijará la fianza en $1,000.
Count 2, the amount of $1,500.
$1,500 con respecto al segundo cargo.
You're not to have any contact with the victim, Glendelis.
Prohibido ningún tipo de contacto con la víctima Glindelis.
No contact means no in-person contact.
Cuando le digo nada de contacto es no puede tener trato en persona.
No third-party contact.
Ni a través de un tercero.
No telephone contact.
Ni a través de llamadas telefónicas.
No social media contact.
Nada a través de medios sociales.
No contact whatsoever. Do you understand?
Ningún tipo de trato en absoluto. ¿Entendido usted? Sí. Yes.
Additionally, you're not to return to 106 Alderwood.
Adicionalmente, prohibido usted regresar a la 106 Alderwood.
You can go back one time with the assistance of law enforcement to obtain your personal items only.
Se le permitirá regresar una vez escoltado por agente policial para recoger sus pertenencias únicamente.
You are not to possess any alcohol or drugs.
Prohibido la tenencia de alcohol o drogas.
You're not to consume any alcohol or drugs.
Prohibido el consumo de alcohol o drogas.
You're to report for random urinalysis.
Se someterá usted a controles de orina aleatorias.
And you're not to possess any weapons or firearms.
Y prohibido la tenencia de armas de fuego o arma alguna.
Thank you, sir. You may have a seat.
Gracias, señor. Ya puede tomar asiento.
Raul Centeno Rosado.
President of Virgin, Your Honor.
22 CF 1764. Good afternoon, sir. State your name and date of birth, please.
Buenas tardes, señor. Por favor, indique su nombre y fecha de nacimiento.
Raúl Cedeno Rosado, 10 de febrero del 92.
Raúl Cedeno Rosado, February the 10th, 92.
Sir, you've been picked up on charges of tampering with evidence.
Señor, usted ha sido detenido por una acusación de adulterar pruebas.
The court has reviewed the charging affidavit. I find there's sufficient probable cause.
Este juzgado ha estudiado el informe acusatorio y determina que existe suficientes indicios razonables de criminalidad.
Bond to be set in the amount of $1,000.
Se fijará la fianza en $1,000.
Thank you, sir. You may have a seat.
Muchas gracias, señor. Tome asiento. Thank you.
Counsel, did we miss anyone?
I do not believe so, but if I may inquire, Your Honor.
Yes, sir. Ms. Aurora, thank you for your services. All right, thank you, counsel.
Thank you, Your Honor. Have a good weekend.
Ms. Aurora, thank you for your services. Have a good weekend.
Likewise, thank you, Your Honor.
Thank you to all of my patrons, members, and supporters. You are the reason that I am able to upload new bond courts daily. All members and patrons receive access to the Bond Court Discord server. Please send me a message on Patreon or leave a comment on YouTube if you are unable to join the server. Thank you all for your support.